Someone make it make sense.
Probably a couple.
Hello and welcome, everybody. There we go. Hope you guys are having a wonderful day or evening or morning, wherever y'all are joining us from. Welcome. We are at a very exciting point in time for this trial. But before we get into that, there's a lot of other things going on, as I'm sure you all are well aware. We do have actually some filings out of Idaho that were filed on December 6th, but were not posted to the docket. A lot of it looks like it's going to be sealed, but there are some objections from the state to the defendant's motions to suppress that are not sealed. So we will definitely cover those. I might do that tomorrow. I also had mentioned too, for anyone who is interested, I have the Sarah Boone Sarah Boone letter. We can also go over that. I do have scheduled for tomorrow the Daubert hearing from Karen Reed, but we might be able to do either the Sarah Boone letter or Koberger court filings, before that. Just let me know if you guys are interested. I mean, I'll definitely do the Koberger filings. I just don't know if you guys are interested in the Sarah Boone letter because I know everybody's been covering it. But we can totally do it. Maybe we can do a dramatic reading or something like that if y'all are interested. And then I'm thinking that on Sunday, I'll probably do the next installment for Shanna Gardner. We are quickly getting caught up to speed there, going chronologically. Shout out to Iowa backyard, by the way. And I am all caught up with timestamps, happy to say. And just as a reminder for everybody, if you don't see timestamps in the scrolly bar for any of the videos that I have ever made, or live streams, whatever, sometimes they appear, sometimes they don't, sometimes they go away and come back. YouTube is funny like that. So always check the video description because I always timestamp everything, as you guys know, very detailed timestamps, so that you can find certain things you're looking for, or I can if I need to go back and refer to something. So they're always in the description, but hopefully also on the scrolly bar. But I am all caught up as of right now with timestamps. So we're going to start, as we always do, by recapping where we left off from last time. The last episode, the state rested their case in chief. And I will say, for anyone who hasn't watched this whole trial, this recap will give you a great idea, I believe, of what the state thinks their case is. It'll highlight some of the most maybe important pieces of, or I guess, evidence that is, being disputed, points of contention, that type of thing. It's also going to show some highlights from the motion for a directed verdict, where, again, you're going to get to hear both sides argue to the court without the presence of the jury what they think the case is about and what the evidence shows. And as promised, it will also include composites of the heart stickers and the duct tape, as I talked about on the last episode. So let's jump right on into that. Here we go. Woo! Yay!
It's a house.
Do you see that item in front of you?
Yes, I do.
Okay. Is this a close-up of the same item that was displayed in 306 in evidence?
Yes, it is.
Where were those stickers located?
This is a sheet of heart-shaped stickers that appeared to have been cut in half. It was located inside of a black binder in that same cabinet as the previous sticker, which was located along the north wall in Casey Anthony's bedroom.
Right. Can you indicate by circling the item that you were speaking of? Do you recognize that as an item collected from the bedroom of Casey Marie Anthony?
Yes, I do.
Now, just to refresh everyone's memory, these stickers matter. There's a reason I'm showing these pictures, and again, they will be in the composite. Remember, the significance of these stickers. The state is hoping to suggest to the jury that these stickers are one of these stickers, heart-shaped sticker, right, is responsible for something that was found at the crime scene. Again, they don't really have anything to connect Casey to this at all. It really comes down to two things, and it's the car and the duct tape. Well, I guess it's three things: the duct tape, and then, well, kind of related to the duct tape, there was that one analyst that we heard from last time, and we'll see here on this recap, who testified that they saw an outline of what looked like a heart in between the two pieces of duct tape that were found like 7 or 8 feet away from the remains, but that they didn't photograph it. And then later, when they went to photograph it, it had magically disappeared. And so upon learning that, the state went back to the Anthony home and looked for stickers that they could suggest were responsible for that. But we're going to get into it.
Does that photograph fairly and accurately depict the item collected?
Yes, it does.
I'd like to show you Defense Exhibit W, which is a photograph of an item introduced into evidence in this case. May I approach the witness, Your Honor?
May I approach?
Yes.
Getting into Exhibit 313.
Since it's not introduced yet, I just want to ask you, do you understand that item to be something recovered off of...
So what's happening here is we don't have this evidence yet. Okay. This is the first time the jury's hearing anything about this. So at the crime scene, or where the body was found, right, there was an actual heart-shaped item, maybe some type of sticker. There was something recovered. Okay. So it's like, oh, okay. Well, interesting, right? So what he's just handed her is a photograph of that piece of evidence.
Suburban Drive.
To my knowledge, yes.
Okay. And that is what you believe to be a sticker, correct?
I never held this object.
Okay.
I have seen photos of this object, so I wouldn't be comfortable determining whether or not it had an adhesive side.
Okay. Did you find anything remotely, did you find that item?
So in other words,
At the end.
they don't even know that it had adhesive on
Anthony
it.
Hill.
This exact item?
Correct.
Because I have never actually held this item and I've only seen it in pictures, I wouldn't feel comfortable with that.
Okay. From what you see there, do you...
Now, the adhesive thing matters, and that's going to come up here momentarily, because remember, what was found in between the two pieces of duct tape was not a sticker, right? It was just looked like maybe the outline. The way it was described was as if you had a Band-Aid on, and then you take that off a couple days later, and there's like the adhesive residue outline, like that in the shape of a heart. That's what was testified to. But again, there were no pictures.
Recognize what you see there from any item that you saw in the Anthony home?
That's what matters.
She's not comfortable giving her opinion about this.
And there's objections.
She can ask the last question.
So he's asking her, and we will see this picture, but at this point in the trial, we haven't seen it yet. Does that look like one of the things you found in the Anthony home? Does that match any of the stickers you found in the Anthony home?
Can you repeat the question?
Sure. Did you find that item at the Anthony home?
Not to my knowledge, without actually holding the item.
So again, remember, she's seeing a picture of it. Now listen to what she's saying. She's saying, this is really interesting. She's saying, I really would need to actually see the piece of evidence. The picture, it doesn't do it for me. I can't really tell. And as of right now, they have the item of evidence, but the state has not introduced it. All there is this picture. So she's like, I can't really tell without holding the item or whatever, right? Okay.
Okay. We'll follow up.
Which one might realize, well, maybe that's why the state didn't enter it into evidence yet, right? Because otherwise he could give her the actual item, but just wait.
With that later, but from what you can see, you didn't find that item at the house, right?
Again, I'm really not comfortable because I don't have measurements. I haven't held this item. I wouldn't be able to say what size and if it was comparable to other items found in the house.
Don't worry.
We understand. It's
The item in question, we will find out what it is, but right now it's an unknown item.
you have limited knowledge. You've just seen it in photographs.
Yes.
But from the items you've seen in photographs, you never saw that item
Wait till we get to seeing what it is. It's
at
shocking.
the Anthony home, correct?
It's crazy. It's crazy.
Sustain.
Okay.
This whole thing is crazy.
When I would introduce Caylee for identification.
So now it's like, what is she doing? So the witness has left the stand. Okay. He's asking her about this item. She said, I can't tell unless I see the piece of evidence. The picture's not doing it for me, which is fair. But here's what's not fair. Now that she's off the stand, watch what
It's an item previously identified by Robin Maynard
What says the defense?
I would object. The proper foundation, and we wait till this witness leaves the stand before we introduce that, so I couldn't ask her about it.
We have some questions you want to ask?
That's the actual piece of evidence. Okay. The time to introduce it would have been when the witness who tested it or discovered, like that was a couple witnesses ago. Okay. That witness who just left the stand is the one who collected the stickers from the Anthony home. Okay. And so again, the way this piece of evidence that Ms. Drain Burdick is holding pertains to her is because the question asked of that witness who just got off the stand was, does this piece of evidence match what you found in the Anthony home? And she's saying, I can't tell without seeing it. Right. Okay. That piece of evidence is what's in that envelope. And the state, okay, did not enter into evidence when the previous witness was testifying about it. Again, it was a couple witnesses ago. And now that this witness, Ms. Burrows, left the stand, now she wants to enter it without any witness on the stand. Now the jury is still present. Okay. Keep that in mind. The jury is still present and they're seeing this.
That's the item.
This is the item. Remember when they were saying they were just that witness that just left the stand, right? And it was like, and I was saying, we don't know what the item is yet. I didn't realize I said that again. The reason that they couldn't be more specific about it is because the state did not enter it into evidence. And so he couldn't ask her more specific questions about it. Remember how she was like, not without holding it, not without picking it up, I couldn't say. He couldn't ask her to do that because the state did not put it into evidence. The witness who they would have put this in through was Robert Maynard, who already has testified. This right here goes to show you that the state is trying to fucking gaslight the jury. Because here's the thing. This item, we're about to find out what it is. This is the item in question that it's like this unknown thing, right? They should have put it in through that witness who testified several witnesses ago. They didn't. And now they're trying to sneak-a-doodle it in without any witness on the stand. Sneak-a-doodle. But it gets worse. Just wait.
Of the photograph?
Stop the witness before she
She's like, oh, let me just hold it up and show you. What
leaves the floor.
What is wrong with you, dude? I think she was hoping she could just sneak it in without him noticing.
Let me.
Look, because you hear she's like not even saying anything. She's just like, it's like a dog with a tail between its legs because this is really gross.
I want to ask her a question. So
you should be embarrassed that this is what you're doing because it means that you're trying to hide your own evidence. This is not, yeah.
Objections. Someone is asked the witness about
ask who?
the last witness about the evidence.
So what he's saying is that because he wanted to ask about this, remember again, the unknown item, he's like, and he wanted to ask her about it, the one who just testified, and he couldn't because it wasn't evidence. What he's saying is, okay, if we're going to bring back the other witness and get this into evidence, then does that mean I can get the next witness, the one who just finished, and ask her questions about it because I couldn't? That's his question.
And return the last witness to the stand.
Get her back. So now, after the whole thing, I can't tell without holding, guess what?
Ms. Burrows, you're still a no from Mr. Baez. You may proceed, sir.
I love that color on her.
My apologies, Ms. Burrows. We happen to have the item that you looked at.
Oh, lucky you. He's like, look at how happy he is. Yeah, we happen to have it right here.
So that way I wanted you to see it. May I approach the witness, Your Honor?
Now, she's probably not seen this before. Remember, her job is just to collect the stickers at the house. So but again, the question is, does this look like what you collected at the house, right?
Have you had an opportunity to look at the item?
Yes, I have.
Oh, boy.
Now you have it. It's not in a photograph, right?
Yes, correct.
Okay. Did you find that item at the Anthony home?
I did not find this exact item.
There it is.
Did you find, that appears to be thick, does it not?
Yes,
Not a flat sticker?
correct.
Something that would be called, I guess, a bevel?
Yes, it's a raised surface.
Raised surface, yes.
As soon as I heard that, I was like, are they talking about a heart sticker that has a beveled raised surface? I was like, you've got to be fucking kidding me. It's incredible. Because you know what didn't have any of that? All of the stickers, whether it was a heart sticker, a Mickey Mouse sticker, a star, all of the stickers that the state showed that were from Casey's room, they're all regular stickers, like akin to a stamp. They're flat. And I'm like trying to picture, what does this item look like? Don't worry, we'll get to see it. But it's like a beveled edge. What? And it's like, you've got to be kidding me, especially because this outline, if it ever existed, right? Because the outline was never photographed. It was sandwiched between two pieces of duct tape.
You didn't find anything like that at the Anthony home, did you?
No.
Well,
No further-
so that right there already, it's like, okay, but the jury hasn't seen it yet, right? Because what happened was now it's been admitted into evidence. He could ask her about it, but it has not been published. So we're going to get to see it. Don't worry. So, but before that happens, so they didn't publish it. The state did not publish it. All right. So that's where we're in chronological order here. Okay. So the next thing that happens is Cindy takes a stand.
In 2008, were you aware of whether or not there was any duct tape
In case anyone missed Cindy, don't worry. Here she is again.
in your home?
Hey, duct tape.
I recall black duct tape that we had, and
So notably, note that they don't call George back to ask him about the duct tape. Anyway,
I think we had blue at one point and possibly silver. I'm not sure. I'm not.
I love this answer. I love this answer because she's been through this entire trial. She knows, everybody knows the duct tape that matters is silver and it has that distinctive brand on it. Everybody knows this. I love how she's like, we had black, we had blue, like as if she's like knows for sure they have this. But then we may have had silver. Like we know you had.
I wanted to really use it. I know I did use the black when we had protesters because I used it to wrap the no trespassing signs.
Great.
Was any of the duct tape that was in your home kept anywhere other than the garage?
Not that I'm aware of.
Ma'am, do you recognize anything in QT for identification?
So that question, when I heard, okay, I'm just going back up again. When I remember editing this video, when I heard that question, I was expecting the answer to be yes, the Henkel brand duct tape. That's what I was expecting.
I recognize Caylee's sign, her poster from the Kid Finders missing the children's poster that they made for her.
So by the way, this is the first time this has been shown, I believe, in this entire trial. This is the first time we've heard about this, right? We've heard that there was a flyer that was hung up with this Henkel brand duct tape, but no one had seen it yet. What's so crazy is when you look at this, that duct tape is like, you can't even, like, okay, because normally if you're going to tape something, right, what would you do? You would like put it on the back, you'd roll it up and put it on the back. It's so crazy how whoever decided to tape this, notably from what we know so far, must have been George, because he was the one who was there at the command center, and this was his duct tape. That might even be him in the background. Like you taped it where it covers up like half, like the top, I don't know, almost half, like in other words, you can't even ignore it. It's like almost just weird how much it covers up the poster. But there it is. Like, I mean, it's almost like even if you were just somebody walking by and looking at the flyer, you'd be like, God, who taped it like this, right? Like you can't ignore that. But guess who does? Guess who does when being asked about this piece of evidence?
Okay.
I mean, the way she could have answered that is, I recognize the flyer.
Do you know where that poster was?
Yep. Nothing about the tape. I can't. Crazy. It's like a jet plane could come crashing into that courtroom and these two people would pretend it's not there. That's what this is like for me.
I'm not sure if it was on the inside of the tent in the middle part or on the one of the outside legs of the tent. That tent was moved so many times that I don't recall, and I wasn't there as often as.
I mean, I'm just gonna point out to you, she was not asked the question of what leg of what tent was it on. This is insane. She's just going to just go on and on about the different types of tents. And it's like, what the fuck?
George was, so I'm not sure if that was in the center post or on the outside post.
Right.
In that picture, I can't tell.
And
So
when you were
she doesn't like that answer, I'll tell you why. Because you hear what Cindy said. I wasn't there as much as George was.
referring to a tent, are you referring to a tent that was used at the command center?
Crazy.
Yes, in the beginning we had those little pop-up tents that you purchase.
Another reason this is crazy, I'm just thinking, I mean, there's so many reasons. I just thought of another one. the picture that was shown, the exhibit that was shown, wasn't of the tent. The tent is not in question. The tent's not even in the picture. It's just the flyer with the tape on it.
The store, and then at one point, Kid Finders had a very large tent donated that had center poles.
Insane.
And that one we used at our last center on Goldenrod up by East Colonial. And I can't tell where this one's taken it. I can't tell from this is one of those pop-up ones with a large tent.
Do you see an individual in the background?
Bizarre.
I see someone, but I don't know who that is.
I don't know why. I don't know what the point of that is. That's George. That's supposed to be George. I don't know. Why are they not talking about the fact that they're not talking about the tape when we all know that's why that picture is there? That's why that picture is there. So here's the thing. I was going to say, can I pull up? I'll make sure I can do this. I don't think it's really that necessary, but I'll make sure I can have this. I'll make like a composite for the next episode of the duct tape, because what we have is we have the tape on the gas can, right? I'll do a side by side of all the. So we have the tape on the gas can, and then we have the tape, the piece of tape that we've seen isolated that was found at the remains that's still in good condition, and then we have this. Again, I'll do a composite so we can verify, but I don't think there can be any question that it's the same tape, because even though you can't really see the brand name, the fact that it has that circle and that is very distinctive, and I have little doubt that it's the same brand. Okay, so here's the composite I made, guys. All right, so there's the poster now. Of course, I have it zoomed out and then zoomed in, and then on the gas can, I know you can't really see it, but it had already been testified to that it was Henkel brand duct tape on the gas can. Like that had already been, that came out early on. They called it the Henkel brand duct tape on the gas can. And in fact, what's interesting is that George even said, I covered that up. I think that was the first time he took the stand. He was like, yeah, I covered the little valve up with the duct tape. So in other words, that connects him to the Henkel brand duct tape in his own admission, right? And then we have the tape on the poster. And then on the right, that is the duct tape found at where the remains were found. And you might notice how underneath Henkel, it has some other writing, consumer, blah, blah, temperature. Remember, this had been out there for months, and you can actually see how it's degraded. Like you can see the fibers. So in other words, that print that we can see under Henkel, that would be, I would imagine, on like the back of the duct tape or the underside, so that when you look at the new duct tape, like on the poster, for example, you can't see that. But if it degrades enough to where it's not as thick and whatnot, and the adhesive, then you would see the inner, either it's like the inside part of the tape or like the back side of the tape. But anyway, I don't think there's any question that it's the same brand. Again, I know we can't see it on that tape on the gas can, but I included it anyway just to show the connection of that's where that tape was found. And remember, the rest of the roll was never found. Now here's the other interesting thing. So we know that the roll of tape still existed at least whenever these flyers were put up, right? And then what it looks like is what happened is that when the remains were found, okay, and then it was learned about the duct tape, then that roll of duct tape was then disposed of. And remember, not only was Caylee in custody for the most part, she was out briefly, but she was mostly in custody. She was in custody when the remains were found. So if the roll of duct tape was disposed of that day or later, it couldn't have been her, right? But as it pertains to the flyers, not only was she in custody, but we know she never helped. That was one of the big parts of the state's case, was that she never helped with the flyers. So in other words, we know, like, in other words, it's so funny because the state, they're like really trying to make it show like George was out looking for her and Caylee wasn't. And meanwhile, Cindy was working. Well, okay, so then that's them almost conceding the fact that George put that tape on that flyer. So the only way the state can try to wiggle around this is to try to say that duct tape is not Henkel brand, right? And again, the craziness of how this was shown to the jury and literally completely ignoring the tape. It's crazy. It's crazy. Absolutely crazy. Oh, StreamYard. It's been having trouble with video files. Hold on. Hopefully you guys can hear me.
We have a question from the jury.
Oh, no. Right. Question from the jury.
Can we see Exhibit 313?
That shows you how much they were paying attention to where they even remembered the number. That's how much they were paying attention. Now, I don't think it helped if you're the state, right? That they made such a big deal by objecting when he was asking her questions about it. That draws attention. The way they were objecting, and then the jury was there when she tried to sneak-a-doodle that in. Jury was there. And then they noticed that it was the witness was asked about it. Obviously, the jury's like, this matters, and you're not showing it to us.
We did not see it after it was introduced.
Yep.
I think 313 may have been that heart shape.
Oh, jury. Go figure, right? Fuck me.
You may want to take out the overhead document.
Judge Belvin, it has a name, and its name is Elmo. It's the Elmo.
No.
We're going to get to see it.
They asked
We're going to get to see it. We're going to get to see it.
for Exhibit
And
3.
the question will be, does this match? The whole point of this is this the same sticker as all the stickers? Remember how many stickers they showed us from Casey's room and whatever? And remember how they looked? And again, they're different shapes, but remember that they had that one sticker they especially seemed to like. It was on the envelope. Then they had others. They were all normal stickers, right? Flat, like a stamp.
I don't have any objection.
And I just want to point something out too. So remember, up until this point, what the state wants the jury to believe is they showed all these pictures of the heart-shaped stickers. Actually, they did that with more than one witness, the ones that were from Casey's room. So the jury's seen those. Then they hear testimony about two things. One, that there was a heart-shaped outline or adhesive outline or whatever in between the duct tape, but it wasn't photographed. And when they went to go photograph it, it was gone, right? And then they heard that there was a heart-shaped item also found at the crime scene. So why would the state not publish this to them? Because they want them to believe it's one and the same, that it's one of Casey's heart stickers and that it was on the duct tape, and then it got moved to something else. So the whole question here is the state wants the jury to think that this thing we're about to see here is one of Casey's stickers, but they didn't want to show it to them. They just wanted them to hear heart-shaped item and assume it's the same thing. Incredible.
If they want to pass it around, I don't have gloves available for them at this juncture.
Look at her trying to make excuses. You know they can get
Well,
gloves.
they asked specifically for Exhibit 313. So pull out the document camera.
The Elmo. The fact that she says that, I don't have gloves. Here's the thing. The state wants to be able to talk about this item, this heart, without having to show it to the jury. And why? Because they want to try to trick sorry, that's too nice. They want to lie to the jury and try to, and so that the jury will assume it's the same sticker. They want the jury to assume that this sticker is the same stickers that they found in Casey's room without showing them this evidence. Crazy. This to me is crazy beyond. Because if this piece of evidence is supposed to be good enough to convict her, it should be good enough to also be exculpatory if in fact it doesn't match. And the fact that they tried to hide it from the jury, I can't even tell you how upset this makes me, because how dare you try to lie to the jury? Really? How dare you try to lie to the jury? And what does that even say? I mean, the big picture there is huge, right? Like, what is this? Like, where are we living? Like, this seems like some, dystopian situation, or like, I don't know, Soviet Union, like, it's bizarre that this is what we're dealing with. And that, thank God, the jury paid attention and they heard it get introduced, and they realized they paid attention to the exhibit number and realized they never saw it. Incredible. And the fact that they have to ask the state to see it,
I want to ask her some questions about it.
Go ahead.
Okay. Can you see that, Mrs. Anthony?
Yes.
Okay. On line, I'd like for you to read for a moment lines 10 through 15.
Yes.
And
I'm pausing it. to read it. Question. Okay, did Casey remove any duct tape from the house when she was out of jail for that period of time, the 2 periods of time? Answer. As far as I remember, no, because I think we only had 1 roll of duct tape and George was using that. I mean,
During this.
I would object. It's the lawyer who has to ask the question. This is improper. There's no impeachment going on with the
no legal objection, of course.
question and answer.
I'm not impeaching her. I'm asking her questions that she was asked during direct examination. She was shown this item and discussed it.
They have to go here with this. He's got to
The
let
page that he's referring to is hearsay, and we would object on that basis.
you showed the page, but you didn't show that part.
Deposition.
Hearsay in terms of who was the person who was being questioned.
Right? It's an out-of-court statement. If he wants to ask her it independent of it rather than reading from a hearsay document.
What is wrong with her? It's a deposition. A deposition is literally not an out-of-court statement. You're under oath for deposition, so that counts as an in-court. A deposition is by definition an in-court statement. Even if you're not in court, that's how they work. That's why depositions are taken. They are equal to testimony from the witness stand. They are not hearsay.
That's one thing, but it would have to be impeaching information.
That's what I'm saying.
You can ask the form of the question and the leading question, so you can read the question and give it an answer. You're on cross-examination. Go ahead.
Mrs. Anthony, were you asked by Ms. Drain-Burdick if Casey removed any duct tape from the house when she was out of jail for the period of time, the 2 periods of time? Were you asked that question?
I don't
That shrug. Wow.
remember, but if it's in my
I mean, my God.
deposition, then I must have
And the turtling.
been asked that question.
Does that refresh your recollection that you were asked that question?
Good answer,
You see
no?
that there?
No, I don't remember talking about, I don't remember them asking me if Casey removed any duct tape, but if it's in there, then I had a 2-day deposition, so I don't remember every single thing that she asked me.
May I approach the witness, Your Honor?
You may.
That's what I will say. So every time she's come to court, she's worn a tank top. Like, look at her, like, with her tank top. In North Carolina, you cannot enter the courthouse, even if you're just going to go pay a, I don't know, even if you're going to go get a record, like say you want a copy of your birth certificate, okay? And you just need to go to the clerk of court to obtain that copy or something like that, right? Or anything. You can't enter the courthouse in a tank top in North Carolina. They won't let you. You also can't enter, like, you can't wear like shorts or even like sandals. Like you have to have, there's a dress code. She wouldn't be allowed. And I would have thought that would be pretty much everywhere. But I don't know if they made a special exception for her, but it's weird because literally I don't think you'll ever see a witness ever in a trial wearing a tank top like this unless they've got a shirt over it or something, of course, right? This is just highly unusual and very weird that she's wearing. And why would she choose to wear that, right? Like, it's just very bizarre.
Do you recall giving a deposition in this case, ma'am?
Yes.
And if you could look at the first page of the date.
We know courtrooms are always kept freezing cold. We know that.
No, the first. Hold on. Yeah, the very front.
July 29th, 2009.
Okay. And were you placed under oath at that time?
Yes.
Okay. And can you read that 10 through 15 lines, 10 through 15?
10 is question, okay, did Casey remove any duct tape from the house when she was out of jail?
Wait, slow down. She can't hear you.
Okay.
She's trying to get it over with.
Question was, okay, did Casey remove any duct tape from the house when she was out of jail for that periods of time?
Can you give the answer?
As far as I remember, no, because I think we only had 1 roll of duct tape and George was using that.
Thank you, Mrs. Anthony. You may stand down.
Now we're on to the sticker. Yay.
Okay, members of the jury, you had asked earlier
God.
to have an opportunity to see Exhibit 313.
I have never seen this in a trial. Like, normally when the jury's asking me to see things, it's if they're during deliberations. This is so incredible that they tried to sneak this out. I'm just still blows my mind. They tried to first sneak it in without they tried to sneak the actual piece of evidence in, right? Without a witness and without the witnesses who would be questioned about it able to do so, right? Then they entered it into, or they offered it into evidence or whatever. And so then that item could be talked about and looked at by Miss Burroughs, right? But they still didn't publish it. It's just so crazy during the trial. And then the jury has to ask, this is just so insane to me, obviously.
Can publish it via the document camera. And we can also pass it around for you to look at. Would you like one or both of those methods?
What do you guys think?
Okay, here we go.
Okay.
Both.
So we will publish it on the document camera.
Exhibit 313 is identified as a piece of cardboard matting with pink raised heart-shaped material attached.
Raised.
You will also notice
This matters.
now that it has separated.
Okay. So here's the thing, that piece of the thing that matters, right, is that this was found attached to a piece of cardboard. The piece of cardboard, I'm sure I'll probably say it here in a second in this recap, but it's like the sign for the daycare or whatever. But the thing that matters is that it was stuck to it. Because remember, the whole point is the adhesive, right? In other words, if that heart-shaped outline ever existed, that the supposed adhesive that was never photographed, there's there could be two explanations. Well, I actually think there could only be one. The state wants you to think the explanation is it was a sticker from Casey's room, although no such sticker was actually found. However, there was a heart-shaped sticker item found, okay? And so the fact that it has adhesive on it matters. Before they show it, here's what I want to do. So remember, what the general consensus and what I had been told by someone in the chat, I don't know, like 2 weeks ago, was that they found the same sticker, one of Casey's stickers, okay? Again, I'm just reiterating, and that they found it on the piece of duct tape, and it was the piece of duct tape that was on the remains. Now, what we heard from the testimony was that none of that's true. They didn't find a sticker on any duct tape. They found there was the outline, right, and then it disappeared. Whatever. They didn't get any pictures of it. And the duct tape that was allegedly seen, right, was in between the two pieces of duct tape that were 7 feet away from the remains. The only last question that we still had was, is it the same sticker or is it a different sticker? So take a look at that sticker, guys. And remember, we already heard that it was raised. It's like a jelly type. You know what it reminds me of, kind of, is like a stick-on earring in a way. You know, they have this press-on, stick-on earrings for kids. Kind of reminds me of that. This is despicable. The prosecution was hoping to suggest that this was a matching sticker. And in fact, again, crazy, that was apparently what the general, still is, the general consensus, because again, what I was told was it was the same sticker, that it was one of her stickers. There is nothing like this that was found in the home. And they even testified to as much. There was nothing, they were all flat like a stamp. This same sticker was not found. And remember, this came attached to the cardboard, and the cardboard was the sign for the daycare or whatever, the school. There it is.
State may call their next witness.
Your Honor, at this point, the state of Florida would rest.
So wait, where was the composite? Let me back it up a second. Did I miss the composite part? Hold on. Because there it is. Okay, so I just want to talk about this real quick. So there's the composite. So, like I said, we already saw the composite for the duct tape. Here's the composite for the heart-shaped stickers. So, so on the left, you've got, these are the stickers that they found in Casey's room, right? So you've got the top one, the bottom one, and then there's a close-up of the sticker on the envelope. So the top on the left-hand side, and then in the middle at the top, those are the stickers that were found in Casey's room. Again, they're stickers. They're made of paper, okay? And then we have, of course, the actual Exhibit 313, and then a close-up of the heart. So to say that this was found from Casey's room there's no way. Oh, happy you're here, Flash fan. You're here just in time for the composite of the heart. This was, I promise this from last time. So of course you've got the Casey stickers from her room, and then you've got the actual item found at the crime scene. Again, it looks like one of those. And when I was a little kid, I had these, the little earrings that they're stick-on earrings, and that's what that looks like to me. The way that it's like thick, beveled. It's probably a bit squishy. I mean, it's yeah. I mean, okay. So now let's go to back to where we were. So the state's going to arrest. Okay. The school. There it is.
State may call their next witness.
Your Honor, at this point, the state of Florida would rest.
Ladies and gentlemen of the jury, the state has now rested its case.
We did it. You guys, we did it. They rested. It's done. Thank God.
May the attorneys approach the sidebar for a minute along with the court reporter. All right, you may proceed.
All right. Buckle up, guys. Buckle up. This is, oh man.
It is well established in the jurisprudence of this country and in this state that at the close of the evidence.
So for anyone who's joining us, we're at the tail end of the recap from last time. So this portion here is highlights from the motion for a directed verdict.
The state and or again, at the end of all of the evidence that is presented, we are entitled to present an argument to the court seeking a judgment of acquittal. And when the state relies upon purely circumstantial evidence to convict an accused, we, the court, have always required that such evidence must not only be consistent with the defendant's guilt, but must also be inconsistent with any reasonable hypothesis of innocence. Our current rules and the circumstantial evidence instruction promulgated by the Supreme Court says as follows. Circumstantial evidence is legal evidence, and a crime may be proven by such evidence. A well-connected chain of circumstances is as conclusive in proving a crime as is positive or direct evidence. Its value is dependent upon its conclusive nature and tendency. Circumstantial evidence is governed by the following rules. 1, the circumstances themselves must be proven beyond a reasonable doubt. I'll digress momentarily and direct the court's memory to Dr. Gerardo saying that she concluded that she would label this case as a homicide by indeterminate means, choosing the word homicide because in her view the circumstances established that by preponderance of the evidence.
Ready?
So, by my experience and by what is known, the way homicides occur, I felt that the preponderance of evidence and that there was no other logical conclusion could be found.
Preponderance of evidence. So this bothered me before, but I didn't say anything about it. But it's interesting that she says preponderance, right? Because that's a legal standard that is the same as the greater weight of the evidence, right? And greater weight of the evidence is 50% plus a grain of sand. And it's interesting that she offers that. He didn't ask her what the burden was here, what the legal standard was. She offers that. She says by the preponderance of the evidence. And that's a problem because this needs to be beyond a reasonable doubt.
That is directly contrary to the law.
Yes,
2, the circumstances must be consistent with guilt and inconsistent with innocence. And 3, the circumstances must be of such a conclusive nature and tendency that you are convinced beyond a reasonable doubt of the defendant's guilt. If the circumstances are susceptible of 2 reasonable constructions, one indicating guilt, the other innocence, you must accept the construction indicating innocence. There is no evidence to establish when the child died other than in a monthly window of possibility, where she died, how she died, who, if anyone, was with her in attendance when she died, and they have failed wholly to rebut the reasonable hypothesis of innocence, that is, that there was accidental death and inappropriate efforts by those unidentified as of yet to cover up that accidental death.
Wow, that was powerful.
With respect to count 1, the first degree premeditated murder, the evidence fails to exclude a reasonable hypothesis of innocence. And that is that there was no premeditation, even if there's a determination that there was a murder at all.
Right.
When the element of premeditation is sought to be established by circumstantial evidence, the evidence relied upon.
Is the state supposed to be trying to prove premeditation? Because, I mean, I feel like that hasn't even entered into this at all in this trial.
By the state must be inconsistent with every other reasonable hypothesis. We don't have any cause of death. We have clear admissions from the experts that do not know the cause of death. And by the preponderance of the evidence, we have the speculation of Dr. Garavalle that
yeah, say it.
it was a homicide because she claims that 100% of people report things, some such thing.
You know,
100% of the time that accidental deaths are reported unless there is a good reason not to be. That's partly behavioral science.
Incredible.
That if there was an act which the state alleges variously as, I think, I interpret, perhaps chloroform and or duct tape.
Did y'all hear that? Well said. The shade, the well-deserved shade on behalf of the state there.
As with yesterday, a piece of cardboard was found in the vicinity of the body, 9 or 10 feet away, as I recall the testimony of Dr. Michael Warren, anthropologist from the University of Florida.
Yes.
And that had a heart-shaped emblem stuck on that piece of cardboard.
Here we go.
Nothing like anything related to this crime scene specifically. Remember, let us not get confused about what may be nothing more than media hype or whatever. The only evidence related to anything to do with a heart shape was the testimony of Miss Fontaine, if I recall, from the FBI, saying she had observed an image of a partial similar heart shape on the edge of duct tape, but somehow, poof, they couldn't photograph it in the FBI crime lab at Quantico, Virginia. So,
so good.
We have no evidence then that connects that circumstance. The only
part when he gets to the duct tape.
Evidence that we have about duct tape is severely questionable near the mouth.
Love how he says near the mouth.
In the vicinity of the mouth.
Yes.
And the only person
here
shown to have had access to, use of, familiarity with the subject duct tape, unfortunately, was the grandfather.
I'm clapping. It gives me goosebumps because that is it right there. This duct tape is like the whole case, and it just, thank you for saying what we're all thinking. Thank you for saying what we're all thinking.
Where was this child killed? Was she killed at all?
Scare quotes.
Or was it an accidental death?
Love the scare quotes.
Now, I submit to you, Your Honor, I know you're burdened. I know the circumstances, as you well know, not my first time. I'm trying murder cases for 40 years.
The suggested witness to this accident and its aftermath, Mr. George Anthony, has conclusively rebutted this hypothesis.
See, this is where, for me, can you see why? Can you see why I've said what I said? The fact that how do you even do this with a straight face? Honestly, I feel like George, I can't even think of a comparable thing to George, because George is like just an absolute utter disaster in every way, and in ways that are different than we usually see. George just takes the prize for like the biggest disaster ever to take the stand, honestly. So I thought about this when I was doing timestamps of like trying to think of something that can compare to George. George is red Solo cups. George is red Solo cups. If he were a physical item and he was in this trial, he would be red Solo cups. That's the only thing that could compare, honestly. So this would be like in Karen Reed. This would be like, at closing argument, right? Whether you say last trial or upcoming trial, this would be like a closing argument or at a motion for a directed verdict, right? This would be like the state being like, here's our best evidence. Do you remember those solo cups? That completely disputes whatever they would say, or whatever, But in other words, using the red solo cups as if that's like one of the key elements to prove their case. It's like if they relied on that and they like really hammered it in and they're like, you saw those red solo cups, that proved blah. That's like what this is with George. Oh, weird. Yeah, it was streamed. Yeah, it was streamed. I don't know why people can't find it. I was going to cover that tomorrow. Yeah, and as for this, that makes sense because I know there is, I think my next court filing that I have actually is their next motion for bond. And remember, at the end of the last one, we saw how they get an opportunity to try again. It was towards the end of the judge's ruling. Not that it was her decision; it's by law, right? That they can retry, reapply, or they can ask her again, right, for bond. So yeah, so that will be. And that would make sense too if that interview or press conference that he gave was after the second bond hearing. So yeah, and I think that next episode will probably be on Sunday. Probably be on Sunday.
Emphasis that at the judgment of acquittal stage, the defendant is proposing the court accept.
Somewhat helpful for anything.
It is our position that a reasonable jury in this case can conclude that Caylee Marie Anthony died as a result of the application of 3 pieces of duct tape to her nose and mouth.
Okay.
That a reasonable jury can conclude that Caylee.
Here's where I lose it. Here's where I lose it. Why are you misinformationing right now? That's where my brain can't even compute. Why are you misinformationing? I don't even have words. I don't know how you even say stuff like this and then not get, I don't even know. I don't even know what first out of the courtroom, right? I mean, because it was only 1 piece of duct tape. And you know how many pieces of duct tape were on the nose and mouth? 0.
That a reasonable jury can conclude
the fact that this is the government representing the government and they have the power to take your life away and they can just blatantly lie. Do you see why I get so upset?
Caylee Marie Anthony died as a result of poisoning by chloroform.
There was no evidence of that. Stop. There is no evidence.
That a reasonable.
There's no evidence. I don't understand what is happening because the toxicology showed no chloroform, no Xanax, no poisons, no drugs of any kind. A
reasonable jury can conclude that Caylee Marie Anthony died as a result of the combination of the two based on the evidence.
You saw what she's saying. Okay. It's like, so, just in case you think either or both of our suggestions are shitty enough, don't forget, you can combine the two and see if maybe you've got like an F- over here and an F- over here. She's like trying to suggest that you can combine them and get like a C+ or something, which that doesn't even make sense. But never mind that. If you have to compare beyond a reasonable doubt to a grade, it's like A+++++. And she's like, take F- and add another F- and you get A+++++. Sorry, I don't think you know how to do math.
That was discovered in the trunk. And
I wonder if like F- is what she got in school.
The evidence connected with how her remains were discovered. It is our position that a reasonable jury can conclude that the relationship between the parties in this case, specifically Mrs. Anthony and her daughter Casey, could provide or did provide a motive for Casey Anthony to eliminate the child.
What? What are you talking about?
It is our position that a reasonable jury can conclude that.
Idiot. I don't. Hi, Cece. Glad you're here. There's no evidence that has come in. Okay. There's no evidence that's come in about that. There was some talking. Okay. There was mentioning in the Orange County Sheriff's Office investigative report. Not about Casey, okay, but about her mom. What was in that report was that Cindy said Casey was jealous of her. Not Casey said it. Cindy said it. Cindy told them that she thought Casey was jealous of her, but Casey didn't say that. Second of all, that was only in the sheriff's report, and that is not coming at trial, ma'am.
Ms. Anthony began preparations for
Stop.
the elimination of
You can't just invent and make up premeditation.
the child as early as March of 2008 when she conducted searches, computer searches for how to make chloroform.
Stop it. Dude, this is the thing. So that's what it is. Remember the question I had? Where I was like, I don't even know what I could think of if I tried about premeditation. Their premeditation is the searches for chloroform. You've got to be kidding me. That's it? When we saw that, remember, it was a total combined of 13 seconds or something? And it was proven through the testimony of their expert that the tabs refreshing in the background could have made it look like it was that many searches, and that's why it was 76 searches, but only totaled 13 seconds or something ridiculous like that. But the page was only viewed once, and that when it was viewed, it was right after she got that picture from what's his face, Shrug's boyfriend on I almost said Instagram, on MySpace, and it had the picture, and it was killer with chloroform or whatever it said. It had that picture. You guys have seen it, and then right after that, that was when it first started searching. I have no words. That's your premeditation?
And other means of weapons and how to create injury.
Still goading. Also, hang on. The logical next question is, if you think that she was killed with chloroform, and if you think that anyone was looking up how to make, I don't even care who, it could be George, it could be anybody, think someone was making up how to make, then what you're saying is someone looked up how to make chloroform, learned how to make it, made it, and used that to kill somebody? You know what's crazy is we're missing all those middle steps, right? Yeah. They've somehow conveniently left out, if someone's looking up how to make chloroform, right? And then someone dies from chloroform. Well, where is the parts? Where are you showing that they bought the equipment? Where are you showing that they actually made it? How are you showing it's even possible? Because I looked it up actually, and I don't think it's possible to make it home. So if someone, okay, let's just say that someone even wanted to do that. Let's just say that somebody wanted to kill someone with chloroform, but they really wanted to make it homemade, and they Googled up how to make it. You know what they would learn? You can't make it at home. That's what they would learn. So then I don't understand. Because then the next thing you should be looking for if you're the state is a purchase of chloroform, right? A purchase of chloroform, because they learned they couldn't make it at home. I can try to fill in the blanks of how this could look if someone was actually doing any of this, right? They would try to figure out how to make it. Okay, they look and they're like, okay, yeah, you can't be, then you would see a subsequent Google search, right? We didn't see any of this. You would see a subsequent Google search for whatever the chemicals are, whatever the type of machine or equipment. You would see Google searches for that. Is it legal? Can I purchase it? How big is it? How much does it cost? You would see that shit. And then you would either see them buying those things, or you would see them seeing, oh wait, that's not possible. And then you would see them doing another search for, where can I buy chloroform? This is what's, you guys see what I mean? I can't. Here's the thing. Despite the fact that there's no evidence of any chloroform in terms of the death or any of that, right? Because it was all completely insignificant. All of that came out from the experts when it was on cross-examination, of course, right? Even if you say, okay, fine, let's pretend in an alternate universe that they did the toxicology and they found chloroform. Let's just say that happened. If you're trying to say that your theory of premeditation is that they made a search for how to make chloroform, and then after that, there's no evidence that they actually made it, how do you tie that person to the body, even if that body tests positive for chloroform, which it didn't? I just don't know how you get around what's missing, right? Because if you're, in other words, if you're trying to say someone did intend to make it, they Googled it, that's my point. She's saying that Google search was made because someone was intending to make chloroform. But there's no evidence that anyone made any chloroform, or even tried to make it, or even looked into making it. Even if you could prove, which you can't, that chloroform was involved in the death.
In that case, Ms. Lewis was convicted of drowning her daughter by holding her under the water.
She said drowning. Well, that proves my point right there. What more needs to be said? She said drowning.
More than one hold or grip on the victim during a single act of abuse or strangulation.
Yeah, Boise. I know
the holds during the strangulation did not constitute a single act of abuse.
Drowning, people, drowning.
Therefore, it is our argument to this court that
Oh, this is bad. I don't even know what her point is here. She's giving examples of case law that I understand. I understand the issue, right? In terms of like that is a good legal issue of like, if you shake a baby, right? Is each shake or whatever, I get it. But I don't know how that applies here. Like, how does that apply here? Are you saying that I just don't understand how that applies. We'll see.
Since a reasonable jury can conclude that Caylee Marie Anthony's death was caused by the application of multiple pieces.
No, she's not. You guys, no. The question I just asked, right? I'm like, how is this relevant? How is this related? If just when you think she can't stoop any lower, I'm going to lose my mind.
Therefore, it is our argument to this court that since a reasonable jury can conclude that Caylee Marie Anthony's death was caused by the application
Clearly, she was wrong about that.
of multiple pieces of duct tape, which obstructed her airway, both her mouth and her nose, based on the evidence presented in this case, that would not.
She said based on the evidence. The evidence is that there was nothing on her face, her mouth, or nose, and the evidence is that is one piece. And you know what? That's so fucked up, right? Because again, the two pieces were 7 feet away, and that you would like, if you're going to make this argument, it still falls flat because it wasn't on her nose and mouth. That's what the evidence showed from your people. I can't. But then to try to say, because you want to be able to say it was multiple instances, you're saying that all three. You can't just make things up. You know what she would have been better off? She would have been better off making it up that the one piece of duct tape was stuck on, pulled off, stuck on, pulled off, stuck on. At least then you've got the one piece of duct tape, even though it's still going to be in the wrong place because it's not found on his mouth, whatever. Anyway, but if you were to argue that stuck on, pulled off, stuck on, pulled off, because that is a better made up scenario. Because here at least there's no evidence to disprove that, right? Whereas there is evidence to disprove the three pieces. We've already seen it.
Either as it relates to the application of the duct tape or the administration of a poison to the child for whatever purpose.
Oh my God.
The other issue for the court's
What poison? No poison was found. A Google search after getting a picture that says chloroform in it does not mean you can't just then. The leaps that you have to have, you guys, the leaps you have to go from the Google search that really was like probably one search. The leap to go from that one search to someone died from being poisoned. It's my poor goat is going to die of exhaustion. I don't even know.
And I thank the state for pointing out some of the depth of the errors.
Depth of errors. Fuck yeah.
If I heard correctly, the state is suggesting that they have presented evidence to overcome the motions here by talking about poisoning by chloroform. Now, I realize my hearing disabilities or such, but I don't believe there was any evidence whatsoever of poisoning by chloroform. The only use of duct tape evidence in this case was George Anthony putting some over a breather valve on a gas can, which sits right there in evidence.
Thank you.
And that there was similar duct tape on a command center flyer looking for a missing child.
Thank you.
The only person having that was not this defendant.
Thank you. I feel better.
In our case, there has been no evidence presented that Caylee Marie Anthony used duct tape for any purpose, that she used chloroform ever for any purpose, and that in any way, in any capacity whatsoever, she contributed to the cause of death of this child. It is forcing, guessing, and speculation, and not in this country.
Yes. That's it. That's the point. Gives me goosebumps hearing that every time.
I ask the court to please take the time to read all these authorities before you rule. Theirs
Makes me emotional.
and ours.
It really does.
Thank you.
Wow.
Okay, the court will be in recess until,
Really. I mean, it's so important. It's so important. It's so important.
considering the evidence in the light most favorable to the state, and reviewing all of the evidence and considering the tests that have been laid down by the Florida Supreme Court, the defense's motion for judgment of
Here it
acquittal
is. Denied.
as to counts 1 through 7 are hereby denied. These are strictly questions for the jury to decide. The court
Really?
specifically
No,
finds that the
it's
state
murder.
has presented substantial, competent evidence
The way
for
that
this
he
jury,
the way that he calls it competent is really funny to me.
who is the trial of fact in this particular case, to decide this
What about the
particular
evidence
issue.
that hide from the jury? What about that evidence?
This court will be in recess.
In case you couldn't hear what I said at the end there, I was like, what about the evidence they tried to hide from the jury? What about that evidence? So I had to look up because I don't know Celsius. So -7 degrees Celsius. So that's 19 degrees Fahrenheit. So that, I guess, is warm for CC's in Canada, for anyone who doesn't know. It was that cold here a couple days ago. It's warmed up slightly today. Yesterday, it was like, I think maybe, so I'm again thinking Fahrenheit. Yesterday it got down below 19. I was actually out there raking some leaves. That was fun. But today, right now it's 40 Fahrenheit. So, but yeah, 19, it's funny because like when I lived in Boone for all those years, that I would have had the same sentiment where 19 degrees would have been flip-flop season. But yeah, in terms of the law and the court, they get their hard copies and the electronic. The whole point is like you file them electronically so that other people can get them quicker, right? And then you have to do what's called hand deliver. So, and then they hand deliver in person. So it looks like on the 21st, and this is in reference to the Shanna Gardner case, on the 21st, there were a number of court filings from the defense. So you can see he hand delivered them at the same time. So there's like, I forget what they were. There was like a supplemental disclosure just about turning over discovery. And then there was an invocation of constitutional rights, which I read that. It was just like, the Sixth Amendment rights. It's like a couple sentences. And then there was the big filing, which was the second motion for consideration for bond or pretrial release. So Mr. Baez dropped off those 3 filings in person, and I would imagine that's why he was at the Duval County Courthouse for that press conference. So that anyway, so in Boone, we would have snow for like 8 months straight, sometimes longer. When I lived there, we had snow every month of the year except for August and maybe July. Actually, no, I think we did have snow in August one year, so maybe it was just July. But we would have snow continuously, tons of it. And in Greensboro, we do have snow, but not nearly as much as Boone. Some years, like what was it, like 2 years ago, we actually we had some snow. Earlier in November, we got like a dusting of snow, but if you blinked, you would have missed it. But in Boone, it was like it was like you would see it. It's like, it's like up north, right? Because of the elevation, like we would just be dumped on constantly. Right. I know. Yeah. There's this one funny story. So I'll tell you guys a quick funny story about Boone. Actually, I've been meaning to show you guys some pictures. Maybe I'll do that real quick. Let me plug in. Cause yeah, I've been meaning to tell this story and show these pictures for a really long time. And I realized I haven't, and I think I still have the pictures. So let me do this. I'll show you guys because Boone is really beautiful. So let me do this, pull up these pictures. So let me think of the year. This was in going from 2016 into 2017. I was still living in Boone. And what happened was, oh, by the way, for anyone who didn't notice, in the thumbnail for Casey Anthony, there's a new addition to the thumbnail. Did anyone notice the new addition? I'll not say what it is yet. I'll see if anyone noticed it. But anyway, yeah. So in the winter going from 2016 into 2017, so like December into January, okay? It was the coldest winter on record in the entire history of Boone, and also the most snow and also the biggest wind. And what's really funny is I was teaching all my lessons in person. I have my violin studio at my house, and I did not ever watch the news. I didn't even look at the weather because, what it was like is you just expect it to be cold and snowy. So there's no point in looking. You don't need to look up the weather, right? It's going to be cold and snowy for months, right? So it was really funny because there was one night, it was probably between Christmas and New Year's, maybe. I'll never forget it. You acclimate to the weather, right? To the cold. So I literally, I was, there was tons of snow, right? And I went to go grocery shopping or whatever, right? And where did my picture go? Yeah, I went to go grocery shopping, and I was bopping around town, and I was where are all the people? I was where is everybody? There were no people to be seen anywhere. And I was what is going on? Where are all the people? I'm not even joking. I was literally the only car on the road at all. The only car. It was like a ghost town. It was it had been deserted. And I was that's weird. Humdy dumdy dum, scrolling, just squirrel life, doing my thing, scrolling around, And then the same thing happened the next day. And then I was that's weird. And then I don't even know how I discovered it. I think I do. Now I do remember. So what happened was I was it seems like it's been especially cold. So I went and looked at the weather, and I didn't have any notifications because I had all that shit turned off, right? I looked at the weather and I was wait. What? Am I seeing things? And it was -40 with the wind chill. And it had all these alerts, all the different alerts it'll have. It had a 50 million alerts, and it's don't go outside, don't leave your house because you will die type of stuff. And it was coldest winter on record. And I looked at it and I was oh, that explains it. Told not to leave their house, and I was out there just living my normal life. I was wow, this coat usually is warm enough, but I feel a little chilly. Oh, it was really funny. I was wow, that surely explains it. Okay, let me share this to you guys. I'll show you what Boone. Okay, so okay. Yeah, it was and so for 2 weeks straight, maybe longer, I don't think it got above -40. It was -20 without the wind chill, -40 with the wind chill. So can you guys see? So this is Boone. This is a really popular place. This is obviously fall. Okay. This is the Blue Ridge Parkway. This is home to me. I lived much of the time that I lived in Boone. So this is the parkway, right? But there's different ways to access it. There's trails you can access it. My backyard when I lived in Boone, for one of the places I lived, my backyard was the access, one of the accesses by foot to get to this. Okay. This was my backyard. Basically. But the trails, I have another really funny story I could tell sometime if you guys want to hear about when I got lost under this area. This is the Lynn Cove Viaduct. My friend and I got lost under here, and it could have gone really badly. We were hiking. But this is a really popular place. People come from all over the country during fall, and they call them leafers. Okay. And so what they do, see how there's no cars on the road. What they will do is they will go really slow, and you can see all the out-of-state license plates, and they just go really slow so they can look at the leaves. And this goes on for 2 months in the fall. And it's really funny because when you live there, you're just used to it. Right. So I've got story after story after story though about this Blue Ridge Parkway, but this is a really popular vantage point of a photo. Oh, that's interesting. Durham. Shout out to Durham. Oh, so flash. Okay, can't make out the details. Well, it is the what's added to the thumbnail for Casey Anthony. I added Garrus, the canine. He's cute. He's a good boy. That's it's that picture of him being really proud. And then here's a picture. I really miss it. I love Boone. Let me zoom in. Okay, so this is, obviously, this isn't a huge, this is just a normal day. So what this is what would be considered downtown Boone, okay? Downtown. So think about imagine an old-fashioned gold mining town or whatever, mountain town. You can probably kind of see, that's what Boone used to be, and now it's a college town. But this is the downtown, if you can believe it, right? a lot of these buildings and businesses have been here since like the 1800s. There's a sign right here for the Mass General Store. That's it became kind of famous. Like they've got like locations now in like Asheville and other places, but pretty sure the first one ever was right here in Boone. And like all these little shops. So this was again, my stomping grounds. I used to live on King Street. There was one like part of the time. And then where I had my studio, for a couple of years I was living, if you could see my arrow, it's basically would have been up here, like up that hill. So it was like walking distance to King Street, but I had this incredible view with a balcony where you could see all of downtown and you could see all the way down to where the school is. It was really amazing. But this is just kind of an idea of what it looks like when there's snow and when it's like, holiday season or whatever. This is obviously this would have been a mild day. Obviously it looks like a movie set, right? I know. Yeah. Yeah, it does. So I could tell y'all stories about Boone for years. We could be here for a long time, and we could even do a field trip if you guys wanted to, where we go to Google Maps and I could show you guys the different places. I know, if you guys, just for fun. I mean, it is it's a really cool town, and it's got a lot of quirks, and there's just a lot of good stories. Like the only good story I can tell about Greensboro is when that bear crossing I had. I think that's like literally the only one. Well, then of course also the animals in my backyard. But yeah, other than that, Greensboro is like a normal city, but Boone is like really magical. I just have I have a lot of really funny stories, especially because I'm like super accident prone. So a lot of them are funny. Like the list of accident prone funny stories would be quite long. But anyway, and so the other cool thing about Boone is like, you're literally, not far, 10, 20, 30 minutes, depending on how far you want to go, away from like waterfalls, hiking. And when I say that, I mean, it's not tour, like, like there's some places where it's like, okay, here's a sign, like go hiking here. Here's a trail. Here's a sign, and there's like people and like stuff, right? That's not what this is like. Like all the waterfalls and hiking that I'm talking about are like, you have to know where they are, but they're close by, but there's no parking. There's no sign. There's no nothing. Like literally you just know where it is and you go. And like, you can go swimming and jumping off the waterfalls and climbing. And actually some of it's really dangerous, but anyway, Cece says she could listen to me read the phone. Well, that's really nice. I'm surprised. I don't know what that's about, but thank you. Yeah, that's a good idea. I could totally do that. We could do like story time, and you could do like Google Maps. Yeah. So I could also tell a lot of funny stories about my car. So when I lived in Boone, I had a BMW, and again, I'll save this for the story day. But yeah, like when I was telling that story earlier about bopping around, and it was like freezing cold, and like I was the only person on the road. As I was telling it, I was picturing my BMW that I used to have, which I loved that car. And I was driving that around, bopping around. And so, yeah, but that's Boone. So, really charmed, magical. You really can get around without a car for the most part. Like, when you're in college, right? Like you're living on campus or like on King Street, you don't need a car. Eventually if you're going to live, a little ways out, you need a car, but anyway, it's super cool. There's no, there's like very few chains. Like there's no Target. We didn't have a Starbucks until I still live there. The first Starbucks didn't arrive until 2017. Still no Target. Which I actually isn't great because I happen to love Target. I always wished we had a Target, but again, speaking to like the small town, because we're like surrounded by mountains. So like the first Starbucks wasn't until 2017. So like, just a lot of local, again, old, family businesses, and most people know each other, and it's just super cool. Okay, but anyway, let's get back to the next episode. Let's see. Here we go. Perfect. The defendant's case in chief. Here we go. Y'all are so nice.
My name is Gerardo Bloise, Gerardo, Bloise last name.
I forgot forgot to ask you all the question. Oh man, I forgot. Okay, so I was going to ask who wants to try to guess who's going to be their first witness. But anyway, now you know. So this is the defense's first witness in their case in chief. And who do they call? Like the lead investigator, the state's lead investigator is their first witness. Powerful.
Bloise, Bloise.
May it please the court.
He's back. Back.
Ms. Drain. Good morning, ladies and gentlemen. Good morning, Mr. Bloise.
Good morning, Counselor.
Mr. Bloise, we've already know you work as a crime scene investigator for
We've
Orange
already
County.
seen you 80
Correct.
times.
Okay.
Yes.
And rather than go through your qualifications, I'd like to just jump right in if that's okay.
Okay, no problem.
Sir, on Wednesday, July 23rd of 2008, you were asked to inspect a vehicle. Were you not?
Wednesday.
Yes. If you want, you can refer to your report.
Say Wednesday, July
By
30th.
the way, I'll just note it took him like 10 minutes to get to where. That's why it cut like that. It took so long that Court TV actually did that. I didn't even have to do that. But that's not the end of it. There's like additional times where he like double checks the date like 5 times, and there's times where I did end up cutting it. But it's just interesting to note that he's really not wanting to find this. It's kind of odd.
23rd.
23rd?
Yes.
Yes.
He had this readily
And
available to the state.
who did this car belong to?
Anthony Lazaro, Tony Lazaro.
Okay. And what you did at this time was you did a vehicle inspection of the exterior and interior of the car.
Correct.
Okay. And part of that was you also wanted to check the car with an alternating light source.
Correct, yes.
And you also did a presumptive test for blood, did you not?
I hate that Tony Lazaro was ever considered as a suspect. You know, I get it. I understand that's like par for the course, but like, you know, that sucks. Cause like, honestly, he was really, I mean, really nice guy.
Yes, I did.
Sustained, rephrase the question.
Can you tell us everything you did with that car?
I inspected the vehicle exterior, interior, and also I checked the trunk area, and I observed some stain on the carpet. Before that, I used alternative light sources, gave me a positive reaction for stain. Next step is I use a presumptive blood test in that area, and the result was negative.
Okay. And is it your experience that the alternating light source, the purpose of it is to tell you where to look further?
Why would I block you?
Yes.
Okay. So it's just basically a tool that people's cars have stains, and that's where you should look.
Sustained.
How does the alternate light source assist
I
you?
only have ever had to block somebody one time. It was like during I think it was during Karen Reed when it was like the first troll that I ever had, and everybody was like celebrating, like, "Yeah, your first troll, you've made it," you know, or whatever. But there was like some troll, and anyway, that's the only time I had to figure out how to do it. I didn't actually know. I was like, okay, but then I figured. So yeah, I don't know. I've blocked somebody once, I guess you could say.
The alternative light sources is tools that we have in order to detect any kind of reaction for body fluids.
Okay. And then your next step would be to do what?
Next step, if I observe any suspected stain, I proceed to do a presumptive blood test.
Okay. And you did that, and what were the results?
Negative.
Okay. And you also then did what next?
After that inspection,
This is interesting. I wonder where he's going with this because I don't know. I don't actually know. Like so this is Tony Lazaro's car, and he's saying, "Did you check there was a stain in the trunk?" Okay. And they tested it for blood, and it was negative, and they're going through all this. I'm wondering what this is about. Is this about the fact that connecting that, like, the whole thing about trash being in people's trunks or something? You know what I mean? And that it could. I wonder if the defense brought in experts who tested it, and the findings are going to be very similar or the same as like what they found in Casey's car, and it's going to be like because he had trash in his car. You know what I mean? Like just in case. I mean, just in case there was ever anyone doubting whether or not there was a dead body. I mean, you know, just it's honestly overkill because I don't think they would need to do any of that. But if they can, that would be crazy good for them.
photographed the interior, exterior of the vehicle, and that's it.
Okay. Did you place the car on a lift at all?
No, I did not.
Okay. And can you check your report and see if there was anything else you did?
Yes, I did, but this is the other vehicle.
Okay.
That was the Sunfire vehicle.
But you didn't indicate that on your report, so I just wanted to clear that up, right?
Wow.
Yeah, in the out-of-death garage, I mentioned at 16-13 hours that I moved the vehicle from the forensic garage, which was the white Pontiac, to the lift.
Sunfire.
Okay.
Yes, it is in my report, but I don't mention the...
You don't
So I think he's trying to say, so he put Casey's car up on the lift, but he didn't do Tony's.
mention which vehicle.
tag number, exactly, yes.
Okay. Now, did you collect any items from Tony Lazzaro's car of evidentiary value?
No.
Okay. I'd like to take you to August of 2008, August 6, 2008. Can you tell the ladies and gentlemen of the jury what you did on that day?
August 2008?
Yes, August 6, 2008.
That's that's another one where there would a lot of time elapsed for him to find
It
this.
was a search warrant
Okay. And where was this search warrant executed?
at the residence of the Anthony's family.
Okay. Would that be the home on 4937 Hope Spring Drive?
Okay.
Yes.
Okay. And what was your assignment to do that day?
And that day, that was to check the bedroom belongs to
right.
his bedroom.
Okay, so in case anyone's wondering whatever happened, like in case anyone's like thinking, okay, during the state's case in chief, right? Like that we heard nothing about, like, did they check Casey's clothes? Did they check the interior of the house? Did they find anything in the house? Did they check the bedroom? None of that. No, they didn't tell us any of that. They did not. The state did not enter any of that into evidence. But this is when we're going to learn that they did all of those things. They did all of those things.
Belongs to Casey. And then to check for clothing. And inspected clothing with using authorized sources. And then collected some pieces of clothing from the bedroom.
Was part of your assignment to search any other rooms?
Not to my best recollection. The only things that we checked was the living room area and the garage area, the car, the vehicle, and that's it.
Okay. Did you check George and Cindy Anthony's room?
I just did visual inspection. I don't remember if I used any kind of light sources. To my
So,
best recollection.
so this sorry, pause. So that's a really good question. So in other words, they did not, at least at this juncture, check. Nothing was done with George, which is odd because you know how that goes, right? Everybody's supposed to be a suspect. And it's so interesting how, like, literally, they did look into Tony Lazzaro and rule him out. I think they looked into like the other roommates, but you know who they never really investigated, or I say really, who they didn't investigate at all is George and Cindy, even though they live at the house. And the other thing is this. If you're going to do only one of them, George was the last person to actually say he saw her alive, Caylee. George said he saw her with Casey, but still, that makes him the last person to actually say he saw her alive. It's like the fact that they did not do any of this, especially when they're already in, it's insane. It's insane. Now, at this juncture, this is August. This is before they found the remains, which means it's before they found the duct tape on the remains. However, at this early stage of the investigation, standard protocol is you still are looking into everybody, right? Because at this point, they also hadn't indicted Casey for murder. She was not indicted until October 14th. So really, this is still preliminary. Like, in other words, law enforcement is tunnel vision on Casey, which they aren't supposed to do and shouldn't have done. But in terms of the investigation, they don't have anything. And so, I mean, they never did, except things that point to George, but I've talked about that a lot. So anyway, my point is that it's crazy. This really shows the bias that they didn't even look into it or test any of it, so.
But you did do a visual inspection of Did you, excuse me, let me strike that. You did go further in Casey Anthony's room.
Yes, correct, yes.
Okay. I'd like to show you a series of photographs identified as Defense Identification Exhibit X, Y, Z, AA, AB, AC, AD, AE, AF, AH, AG, AI, and AJ. May I approach the witness, Your Honor?
You may.
I'm showing you now Defense Exhibit X. What does that appear to be to you, sir?
That was the bathroom.
Who's better?
Casey.
I will just say, for anyone who didn't read the video description, you're going to see a lot of familiar faces in this one. There's going to be some new faces. The new faces, by the way, are all FBI agents who worked on the case. And the old faces are all either FBI or law enforcement who testified for the state. So essentially, every single witness in this episode, so it's the defense's first, I don't even know, however many. We go through a lot of witnesses. It might be like 6 or 8 witnesses, but they're all law enforcement. And the only difference is that there's FBI agents that the state chose not to call. But they're all law enforcement. It's not like their own experts or their own it's all law enforcement. Crazy.
And is that a fair and accurate representation of the bedroom as it appeared on that day to you?
Yes.
Unless there's any objections, I'd like to move Defense Exhibit X into evidence.
I'll review these series of photographs. I have objections to none of them.
Okay.
Remember, if you don't have microphones on the court report, do you want to log in?
Can't remember because she doesn't have a brain.
I'm actually going to go back here.
Okay.
If she only had a brain.
State had no objections to that exhibit?
Correct, no objection.
Your Honor, in light of the state's agreeing on these items, I'd like to just go ahead and enter them all into evidence, if I may.
State, any objections?
No, I've reviewed them all. There's no objection.
May I publish Defense Exhibit 2 to the jury, Your Honor?
Yes, you may.
Sir, can you see the photograph?
Yes.
Can the ladies and gentlemen of the jury see the photograph?
So that's Casey's room, I believe.
Now, sir, can you describe the room basically for us?
It's a single bed and some pillows on the bed, nightstand, a dresser.
What is this item here?
It's like several pictures.
Okay. And
Yeah, I think this is Casey's room, which, by the way, based on what everyone always said about her, she's a party girl and wild and blah, blah, blah. Is this what you would expect? Because this looks like, if I didn't know any better, I'd be like, oh, does like an 85-year-old live in that room?
would be behind this wall here.
The closet.
Okay. And tell us what your goal was to do that day. What were you there to do?
In that day was to collect some pieces of clothing from the closet and check those items at the bathroom with the alternate light sources, and then collect the clothing, the pieces of clothing.
Okay. And was it your understanding that you were going to look at the clothing that had, well, let me rephrase that. Was it your understanding that you were going to now look at all of Casey Anthony's clothing?
Yes, just to check the bathroom, yes, clothing.
And what was your goal in looking at all of her clothing?
My goal is to inspect the items with alternate light sources. If I see any suspected stain, and then collect the items that I observe some suspected stain.
Okay. And tell the ladies and gentlemen of the jury how you go about doing that.
I just put some black cover on the window.
Why do you do that?
In order to get the room dark, and then use the alternate light sources, which give me some fluorescent light. And then when I inspected the clothing, I'd be able to see any suspected stain. And then if I see any suspected stain, and then I separate that item and put it in the paper bag, and then collect as evidence.
Okay, let me take you step by step if I can. What is this photograph that you're looking at now?
That was the closet.
Okay, and that is that where you got all of the clothing from?
Not all of them. Some pieces of clothing, yes.
Okay, and you also checked the drawers in the room?
I don't recall if I checked the drawers.
Okay. Do you believe you would have done a thorough job in checking the entire room?
Yes.
Okay. And
So my guess is this is also when they found the
I'm
sticker.
going to show you some clothing. Is that one of the items that you inspected?
Yes.
Is that one of the items that you had found a suspected stain on at all?
That was the charcoal gray pants, brand name Zinc Sci-Fi, tag number H52175. I checked the item with ultralight sources. No stain was found.
Okay. Was it your understanding that these pair of pants were the pants that Caylee was seen wearing on June 16, 2008?
I was informed that she was wearing that pants, yes.
Okay. And you found no stains on those pants?
No.
I'd like for you to describe exactly a little bit more of what you did. You put black paper on the windows, correct?
Correct.
And the purpose of that was to make the room as dark as possible?
Yes.
Okay. And then what do you do when do you take one piece of clothing at a time and inspect it, or how does that go?
One piece at a time.
Okay. And do you photograph certain stains as you see them?
Yes, I did.
Okay. And I'm going to show you Defense Exhibit 14. Is this what the stains appear to you under the alternating light source?
Yes.
Okay. And you photograph them to document them, I presume?
Yes.
Okay. Now, when you see something,
Give me just a second, guys. I'm going to just do something real quick here and see if I can do, hold on. Let me see something. Let me see if I can present this a different way for a second. Because StreamYard has not been wanting to cooperate with video files. Let me just see here. Let's see if I can just do this briefly. Give me just 1 second. Okay, hold on. Let me try this.
I'd like for you to describe exactly a little bit more of what you did. You put black paper on the windows, correct? Okay. And then what do you do when do you take one piece of clothing and do you photograph certain stains as you see them?
Do this for a little bit.
Yes, I did.
Okay. And
okay,
I'm going to show you Defense
good day tomorrow.
Exhibit
Thanks for being here.
14. Is this what the stains appear to you under the alternating light source?
Yes.
Okay. And you photograph them to document them, I presume?
Yes.
Okay. Now, when you see something like that, that's, I guess, a stain on the bottom of someone's pants, correct?
Yes, look like, yes.
Okay. What do you do with an item like that?
As soon as I observed that kind of stain, what I did, I submit those items to the FBI lab.
Okay. And that would be a large stain under yours. Well, I'm sorry, I don't mean. Describe to us, would you consider that large, small? How would you describe that?
Let's say like a medium
Okay.
stain, yeah.
I'm going to show you now Defense Exhibit 12.
Amy Diemstein.
And is that another example of another piece of clothing?
Yes.
Okay. And what are we seeing here, sir?
In this picture, you can observe some scales and arrow that shows the indication that I found some stain.
Okay. Now, would you classify those as small stains?
Yes.
Okay. And these are the types of details that you're looking for, are they not?
Correct. In clothing, yes.
Okay. And do you even get more detailed than this as far as stains are concerned?
No, that's it. Just stain like that.
Okay. Okay. After you have inspected all of her clothing, what did you do next?
Then I proceed to packaging in every single item in a paper bag and submit it to the FBI lab.
Okay. Now, when you do this inspection, what kind of protective gear are you wearing?
Was wearing the lab Tyvek.
Okay. What is that?
It's like a jumpsuit.
Okay. And does that have a hood or anything like that?
No.
Okay.
Just
What
Tyvek.
about-
And clothing? I mean gloves.
Okay. So you have gloves on, you have a white jumpsuit, is it?
Yes.
And what about foot protection? Anything there?
No, it's in the lab,
Okay.
in a forensic lab.
Any hair nets or anything to prevent your hair from falling on?
Hair nets, I use hair nets, yes.
Okay. So you're in full gear.
Yes.
And do you speak while you're doing these things?
No.
And why not?
Huh?
Why not?
Because I by myself.
Okay. I mean, you don't talk to yourself? All right. Now, let me ask you this, Mr. Bloise. Was Alina Burrows with you?
Excuse me. Yes.
Okay. So did you talk to her while you were doing these?
Oh, if you refer to this picture,
Yeah.
I took those pictures in the forensic lab.
Okay.
Okay.
So,
I'm by myself.
okay. So if we're all to understand what you did, you inspected the items in her room and then decided which ones you were going to take. Is that correct?
That's correct, yes.
Okay. And then you went to the lab and you photographed them like this so we could see.
Correct.
Okay. But while you were doing this in Casey's room, you were also with Miss Burrows, another CSI person.
Yeah, she was with me.
Okay. And was Detective Yuri Melich with you as well?
Yes.
Okay. Did he go in the room or was it just the crime scene investigators?
No, he spent some time with us inside the room, yes.
Okay. So he was made aware of all that was going on and all that was being taken from the home.
Yes.
Okay. Was there anything else you did in regards to this search warrant?
That's it. That was my whole involvement in this search warrant.
Okay. And then part of your job at that point would be to do what with the information, what with these items of evidence?
Submitted to the FBI lab.
Okay. And how is that done?
I just photographed the items, prepared the letter to the FBI lab with the pictures that I observed a suspected stain, and submitted with the property forms that we have as an agency, as the Orange County Sheriff's Office property form, and then submit the items to the FBI lab.
And are these items of evidence protected in any way from further contamination?
Yes.
How so?
It's a paper bag. I seal it and put my initial on it.
Kind of like some of the bags that we see here today?
Yes, sir.
Okay. I have no further questions.
Cross-examination.
Investigator Bloise, the scope of the search warrant that you were just speaking of was to locate clothing items of Ms. Anthony's only, correct?
Yes, my best understanding, yes.
And it is also your understanding that the pants that you were looking for as perhaps a garment that Ms. Anthony wore on June 16th of 2008 had been washed by her mother.
Yes, she informed me that she washed the particular item. Yes, she did.
When you inspected Tony Lazzaro's Jeep, you recall
Yes.
doing that?
Yes.
Did it smell like there had been a dead body in it?
No.
No further questions.
Redirect.
Redirect. Redirect.
When you inspected Mr. Lazzaro's car, did you find a bag of garbage that had been in there in the trunk for 3 weeks?
No.
No further questions.
May the witness be excused. Thank you, sir. You may be excused.
Thank you, Your Honor.
We're going to continue on with the court TV one. I'll see if it goes done next. Okay, perfect. So let's do it this way. So just because, okay.
My name is Heather.
So StreamYard has been having trouble with video files. I'm just going to do this for a second to give myself a break from being really annoyed because it freezes and then I have to keep trying to refresh it and it's just a lot. So, you know, the only thing we lose is the times where I cut out certain periods of silence or like the labels up top and then like the fun stars, you know, stuff like that. But we'll just see if this makes it a little bit easier for a bit here. And this is a long witness. She's from the FBI, and I'll update my banner here as well for you guys.
Seubert, spelling of my last name is Seubert.
Good morning, Ms. Seubert.
Good morning, sir.
Can you tell us what is your occupation?
I am currently the unit chief of the Firearms Tool Marks Unit at the FBI laboratory located in Quantico, Virginia.
Do this.
Okay. And in 2008, what position did you hold with the FBI?
In 2008, I was one of the supervisory forensic DNA examiners in the DNA analysis unit, also at the FBI laboratory.
Okay. And how is the DNA analysis unit broken down at the FBI laboratory?
Well, currently there are actually three DNA units. There is the mitochondrial DNA unit, the nuclear DNA unit, and the federal DNA database unit.
Okay. And could you give the ladies and gentlemen of the jury just a brief synopsis of what each unit does?
Sure. In the mitochondrial DNA analysis unit, that unit's responsible for examining items of evidence for mitochondrial DNA typing. And the types of evidence that they receive are typically samples, bone, hairs, and teeth. In the nuclear DNA unit's responsible for also examining items of evidence for the presence of biological fluids such as blood and semen, and then examining those stains for processing them for DNA typing. And then in the federal DNA database unit, that unit does not receive any items of evidence. Its mission is to process samples from known convicted offenders for entry into the National DNA Index.
Okay. And how long have you been employed with the FBI?
Just about 12 and a half years. I started in October of 1998.
And with whom were you employed before the FBI?
I was employed with the Department of the Michigan State Police as a forensic scientist in the forensic laboratory located in Lansing, Michigan.
And what is your educational background?
I've received a Bachelor's of Science in Forensic Science from Michigan State University located in East Lansing, Michigan.
And have you taken any additional coursework in the area of DNA analysis?
Yes, I have. I'm actually currently enrolled in the graduate program at the University of Florida out of Gainesville, Florida, in a master's program focused on forensic DNA and serology. And I've also taken coursework through the George Mason University, which is located in Fairfax, Virginia, in the areas of statistics and genetics. And I've also taken a molecular biology course from Lansing Community College, located in Lansing, Michigan.
And have you taken any specialized training while employed with the FBI?
Yes, I have. I actually started as a biologist in the mitochondrial DNA analysis unit when I started with the Bureau in 1998. And so I was trained and qualified as a biologist. So I had undergone a specialized training program to perform DNA typing on bones, hairs, and teeth. And then I was promoted to a forensic DNA examiner in 2001. And as a part of that program or that position, I was trained and qualified under the supervision of a qualified DNA examiner to perform those job duties. And then I had also spent time in the federal DNA database unit. So I underwent a truncated training program to be a qualified database examiner as well.
And could you tell the ladies and gentlemen of the jury what is serology?
Sure. Serology is the science involved in identifying biological fluids such as blood, semen, and other biological fluids.
Okay. And have you received any training in serology?
Yes, I have. When I started with the Michigan State Police, I was devoted most of my time as a serologist in that position. And so I was trained and qualified as a serologist to examine items of evidence for blood and semen. And then when I started in the DNA analysis unit as an examiner, I also, as a part of my training, underwent some serology training there as well.
And have you done any teaching or public speaking in the area of, in the fields of forensic science?
I have. As one of my job duties with the FBI was one of the primary instructors on the FBI's quality assurance standards. And so I did that for a number of years and probably provided instruction to well over 1,000 DNA analysts on what are termed as the quality assurance standards, which laboratories performing DNA typing and entering DNA profiles into the National DNA Index have to comply with. And so I provided instruction on that for a number of years. And I've also presented at conferences on the area or in the area of the quality assurance standards and provided also specialized topics in DNA at conferences as well.
And are you a member of any professional organizations for forensic science?
I'm a fellow of the American Academy of Forensic Sciences. I am currently one of the proficiency test review members for the biology section for the American Society of Crime Laboratory Directors Laboratory Accreditation Board. And I was the vice chair of the scientific working group on DNA analysis methods, but I retired from that position in January of this year.
What does that mean, the scientific working group for DNA?
Well, the Scientific Working Group on DNA Analysis is a group of individuals from many different forensic laboratories across the United States and also internationally that are devoted to discussing current topics in DNA and setting guidelines, as well as managing the quality assurance standards for forensic DNA testing laboratories and DNA database laboratories. And they meet twice a year. And they're responsible for issuing documents for forensic laboratories and database laboratories to use in their analysis.
Okay. And have you testified as an expert witness in serology and DNA in the past?
Yes, I have.
Where and how many times?
Since I've been with the FBI, I've provided testimony 18 times and have been qualified as an expert 18 times in the area of DNA and serology, and the federal court systems that I've been qualified in have been Washington, D.C., Albuquerque, New Mexico, Oklahoma, Kentucky, Louisiana, Michigan.
That be all across the country?
Yes, sir.
Okay.
Sorry.
All right. Your Honor, at this time, I would move Ms. Seubert to have her admitted as an expert in serology and DNA analysis.
State absolutely agrees, Your Honor.
Ladies and gentlemen, the jury, the witness will be accepted as an expert witness in the area of DNA analysis and serology. You may proceed.
Thank you, sir. Now, Ms. Seubert, how were you initially involved in this case?
Yeah. So remember, even though, she's been qualified as an expert, just keep in mind, guys, these are not people that the defense hired or whatever. These are this counts, they relied heavily on the FBI. So this is law enforcement that the state used, right? That's how she was involved in the case. She's not hired. And when you hear serology, it seems like they're going to be talking about the hair, even though I don't think any of that's necessary, but we'll see.
When I was working as a forensic DNA examiner in the DNA analysis unit, I was the individual assigned to this case when it was received at the FBI laboratory.
Okay. And did you issue a report on October 8th of 2008?
Yes, I did. And at this time, if it would be acceptable that I may refer to my the notes that I brought with me today that I used in conducting my analyses.
You may.
Thank you, sir. I have the October 8th, 2008 report in front of me, sir.
Okay. Now, I'd like to take you section by section, if we can do that.
Okay.
To the relevant sections. Can you first tell the ladies and gentlemen of the jury what Q's and K's mean?
Sure. At the FBI laboratory, there is a process of assigning a Q letter or a K letter to items of evidence when they're submitted to the laboratory. And this helps to distinguish the location or where the item was collected from. So a Q specimen would be a specimen that was collected from a crime scene. It is something that's not known to a person. A known or a K sample would be a known blood sample, a known hair sample, and things that can be associated directly to an individual.
So if you took my DNA with a buccal swab, I would be K1 or K2 or K3, however number of items.
That's correct.
Okay. And if you collected an item off of the floor, that would be Q1, Q2, and so on.
Well, that would depend.
Okay.
Okay. If you were taking a known fiber sample from this floor, that would be considered a known representative sample, and that would be a K. But let's say hypothetically, if you had dropped a mask or a hat, and that was collected off of this floor, that would be a Q specimen.
Okay. Thanks for clearing that up. Now, were you given items having to deal with the car of a Pontiac Sunfire that belonged to Miss Casey Anthony?
Yes, sir.
Okay. What were you given exactly? And we'll start with, if we can, the first items on your report.
The items of evidence that were received at the laboratory were received into the lab under a cover of communication dated July 28, 2008. And simply a cover of communication just refers to an incoming letter which describes the facts of the case to the laboratory for processing.
I do have an objection that I might raise at the record to whether the items are in evidence, but perhaps counsel can clarify where we're going with this.
I'm questioning the witness what work she's done.
Ashton, why are you first?
To testify about matters that are not in evidence, obviously that's a predicate, and I thought if counsel could clarify for us, maybe we wouldn't have a problem with it.
Okay.
These are items that are in evidence.
If I could just ask.
Well,
counsel.
let's approach the side of folks.
Oh my God. Also thinking about, thinking as it pertains to CODIS, right? So then when you get the Q's and the K's, so the whole thing about CODIS, right, is those are all K's. They're known samples. So that's just another way you can think about how that is relevant to things that we hear about all the time. So CODIS, that's the whole point of the buccal swabs, right? Because it's a known sample because they know it's a K. So just think about that. So when they're going through CODIS or whatever, and they're trying to match DNA, they're still doing Q's and K's, Q's and K's.
Okay, ladies and gentlemen of the jury,
Okay.
there are going to be some matters we're going to need to take up outside of your presence. We're going to recess to 10 minutes past the hour of 10. I'm going to ask you not to discuss this case among yourselves. This would probably be a good time to take a special break. Any additional instructions on behalf of the state or the defense? Okay, we'll be in recess. State recognized persons of jury.
Yes, sir.
Defense,
Yes, sir, we do.
you may continue.
Thank you. Ms. Seubert, we left off talking about some items that you were given to test, and I'd like to take you through those items. First, I'll refer to Q from your report, Q13 and 14, which has been identified as State's Exhibit IJ. Can you look at that item, or can you look at your notes and tell the ladies and gentlemen of the jury what you did?
Yes. The two items, Q13 and Q14, and I apologize, I didn't hear the State's Exhibit number. IJ, were identified as swabs from spare tire cover collected from the vehicle, tag number G63XV.
If I may, sorry. I think that those probably need to be formally moved into evidence by the defense, to which I have no objection before the witness testifies about the analysis. Okay.
There being no objections lodged by the state of Florida. Now these are me. You wanted, it was marked for ID by whom?
By the state, but we'll move it into evidence. That's fine.
That would be defense exhibit.
Right, be defense exhibit. They're moving it.
Yes, sir.
Yeah.
Okay. Thank you, sir. Okay. When you have Defense Exhibit 13, when you have that, what's the first thing you did with those items?
So each of those items were looked at independently. So the first item, the Q13 swab from the spare tire cover, was examined in the laboratory, and a chemical test was actually performed on a portion of that swab.
Let me stop you there if I can. Okay. When you inspected, you're in a laboratory, correct?
It is performed in a laboratory setting, performed by a biologist of the DNA analysis unit.
Okay. And what is the first thing done? The test that you're referring to, the phenolphthalein test, correct?
Correct. It's a chemical test, which is a test that will detect the possible presence of blood. And it is the official name is called by is the phenolphthalein test, correct?
Okay. And what were the results of that test?
On each of those swabs, the test for the presence of blood was negative.
Now, I'd like to take you and direct your attention to the second page of your report on items Q22, which has been entered into evidence as States 143.
On those items, Q23, which was identified as a piece of spare tire cover, a chemical test was also performed on that item for the presence of blood, and it was negative.
Okay. And then after that, with that item, what did you do?
Well, after that item, the testing was conducted on that item. It would have been repackaged up, and then the next item would have been opened up and also tested as well, and that item would have been Q23.
And that is, for the record, States Evidence 139. And what did you do with that item?
And that item was identified as a spare tire cover. And on that particular item, there were brown and yellowish stains that were observed. And those stains would have been tested using a cotton tip swab from the laboratory. So distilled water was placed on that swab, and those areas were actually then individually swabbed. And then the chemical test was performed on each of those swabs from each of those stains that were observed. And those were all negative for the presence of blood.
Okay. Now, when we are talking about spare tire cover, that's a round circle cardboard type carpet material?
Correct. A particle board type backing, correct.
Okay. And then can you tell the ladies and gentlemen of the jury what the next item is?
The next item that was examined was Q24, and that was identified as the left side of trunk liner.
Okay.
It was,
just for the record, that's States Evidence 139. First describe the item to the ladies and gentlemen of the jury so they
lay this out a little bit here. So, again, this is the defense's second witness, right? And so, their first witness was Gerardo Bloise. So the first thing they've done is they've laid out how, you know, the Casey's clothes and stuff like that didn't have any blood, no suspicious stains, nothing like that found. Now they're going through the spare tire well and spare tire cover because, you know, the state made such a big deal about that. And so now they're going through that with all the DNA findings, because if you recall, the state didn't provide that. The state only tested it for like the smells. The state requested these tests to be done, obviously, but they did not choose to use this witness and to talk about the DNA findings because it did not benefit them. So that's where we're at here.
Like, kind of have an idea of what you're talking about.
State's Exhibit 139, or my item number Q24, was a dark gray carpeted section with a multi-colored fabric backing on it. And then on that item, again, brown and yellow areas were looked at throughout, and those areas were swabbed and tested for the presence of blood, and they were negative.
Okay. And then what's the next item?
Q25.
And what is that described in your report as?
Q25 is the right side of the trunk liner.
Okay, and that, for the record, is State's Evidence 140. Tell the ladies and gentlemen of the jury what you did there.
On that item, it was another section of a dark gray carpeted section with the multicolored backing. And brown and yellow areas were identified throughout as possible stains. And a cotton tip swab was taken, water was applied, and those brown and yellow stains throughout were swabbed. And then the chemical test was performed on it for detecting whether or not blood was there. And all of those stains were negative for the presence of blood.
Okay. So you had the spare tire well, correct?
Yes, sir.
The left side of the trunk liner and the right side of the trunk liner.
Yes, sir.
And you tested all of those areas for blood.
Objection, Ashton answer.
Overruled.
Yes, sir. All of those all of those items were tested and were negative.
Okay. What did you do with the swabs that you took from those items after you tested the area for blood?
After a swab is taken and the chemical test is performed on that swab is not retained by the laboratory. The chemical test has been performed. The period to see if a color change is going to take place or not has been observed, and that swab is not retained.
Okay. Did you do any other tests on those items?
Yes, sir.
Okay. Can you tell the ladies and gentlemen of the jury what kind of tests you did after that?
Yes, on those particular items, again, I'm referring to my notes.
Sure.
On specimen Q22, which was the piece of the spare tire cover, Q23, the spare tire cover, Q24, the left side of the trunk liner, Q25, the right side of the trunk liner. A swab was taken of those items and processed for DNA typing.
Okay. And what were the results of the DNA typing for the trunk of the car items that you described?
There was no DNA profile generated from those items.
Okay. Now, just so the ladies and gentlemen of the jury can understand a little more about what you do, the phenolphthalein test the chemical test that you did, that was for blood, correct?
That's correct.
Is it fair to say that the reason you took it a step further was because there are more types of bodily fluids that you could pick up for DNA that you can't from that chemical test?
Objection, leading.
Sustain, rephrase the question.
Why did you do the DNA test?
You know, usually you're allowed.
Although the chemical test for the presence of blood.
Usually you're allowed to lead expert witnesses, by the way. And I feel like the state was able to do that anyway. But I wanted to point something out here. So this is an important question because you might have been thinking what I was thinking, which is, well, there was really no suggestion that there would be blood, right? It's not like there was expected to be wounds. I mean, it's still good to be able to say, yeah, there was no blood found, right? Just because. But, you know, it's like it wasn't expected that there were cuts or wounds or whatever, right? So like there would be no expectation of blood. So this is the part that I was even more interested in because it's a good point, right? That DNA of any kind, right? when you've got a body that's put somewhere or whatever, right? Just people leave DNA all over the place, you know, and there's different types of DNA. So in other words, it wasn't just testing for blood, right? But it was testing after doing those tests for the presumptive, you know, presence of blood. Then they moved on to the rest of the DNA is what we're getting.
Blood was negative. The next step was to determine were there any other type of biological cellular material that could be detected through swabbing and a DNA result generated from that. So from any cellular material that could be present, or if there were any other types of stains that were there that weren't necessarily observed that could have contained DNA material.
And what can you get DNA from in a person's body?
Well, DNA is contained within every cell of your body except your red blood cells. They don't contain a nucleus. So any type of cell that has a nucleus is where the DNA is housed. So skin cells, white blood cells, the tissue, if you yank out a piece of hair, the tissue that's contained in there. And all of those cells within the nucleus contain the DNA. And that DNA is the same in all of your cells.
All right. Now, on further down on page 2 of your report, you received. Can you describe to the ladies and gentlemen of the jury what the items are from Q33 to Q43? And just for the court, the state and the defense have a stipulation with no objection on these description of these items.
If Cal could just remind me which item those are.
The clothing.
The clothing. No objection.
Okay.
I believe the agreement is that those are the items referred to by Investigator Bloise as being clothing from the Anthony home.
Thank you, gentlemen.
Thank you. You received some items from closet of East Room at 4937 Hope Spring Drive, correct?
That's correct.
Okay. Can you tell the ladies and gentlemen of the jury what you did with Q33 and so on?
Yes, so the items that were submitted from the closet, there were several different particular items, and I'll start with the first one, which was Q33, which was identified as a pair of pants. They were dark gray color, and that item was visually examined for the presence of any biological stains, and none were observed. So in that case, on that particular item, there was no chemical testing performed.
Okay, and what about Q34?
Q34 was identified also as a pair of pants, and they were actually light blue pants in color, and that item had some faint brown, yellowish brown spots contained on those pants, which were tested for the presence of blood and tested negative for the presence of blood.
And Q35?
Q35 was identified as a pair of pants. They were a pair of blue jeans, and a visual examination was performed on that item, and no biological stains were observed, and therefore no chemical testing was performed on that.
So here's what I'm gonna do here. So remember all the items of clothing that Gerardo Bloise tested for the, he looked at the stains, he looked at them with the light, and then if he saw anything, he sent it off, right? This is the sending off part. This is who tested it, right? So basically what he's now going through is all the different pieces of clothing. And I understand why he's doing it, because what you don't want is you don't want the jury hearing that this piece of evidence or this item was collected and sent off, and then no one tells you the result, right? So that's the first reason I think he's going through this. Because what I was going to say is they go through this for a long while, so we're going to skip past some of it. It's one after another, after another, after another. Spoiler alert, not really. They're all negative for any DNA. There's nothing. There's no blood. There's no DNA. Okay. So again, it's first of all to show that we're not hiding the findings from you. Here's the findings. Here's what came out of the testing, right? But also with each single item that he does this, even if it's a little bit boring, what the jury is hearing is no blood, no DNA, no nothing, over and over again. And so that's like, you know what I mean? You see why that is really, you want to go through it item by item so that the jury just keeps hearing how much they didn't find anything incriminating. But we're going to go forward a little bit because it goes on for a very long while, I will say. Let's see where she's at here.
And it was a gray carpet cutting. And
now we're getting to the car part.
Q45 was a piece of spare tire cover as well, okay. And it was also a gray carpet cutting.
Okay. And Q44, what did you do with that item?
That item had some extremely faint brown dingy areas on it that were spot tested for the presence of blood, and they were negative for the presence of blood.
Did you do anything beyond that?
On that particular item, it was actually combined with the next item for DNA testing.
Okay. Let's go to Q45, which is state's evidence 142.
On Q45, there were extremely faint brown dingy areas on that item that were spot tested, or were tested for the presence of blood, and they tested negative as well.
Now, tell the ladies and gentlemen of the jury what you did with both of these items together after you tested them for blood.
On those two items, a swabbing was taken, just a regular cotton tip swab with water applied to it, and a swabbing was taken of the entire item, as well as the Q45 item, and those two swabs were combined and processed for DNA.
And can you tell the ladies and gentlemen of the jury what the results were?
There were no DNA typing results obtained from either of those items, and they were combined, so there was essentially no DNA as a result.
Okay. I'd now like to direct your attention to the report that you issued on October 9th, 2008. Just let me know when you have it.
Lovely paper shuffling. By the way, you guys will see.
I have that report in front of me.
She has a lot of binders.
Ms. Seubert, can you tell the ladies and gentlemen of the jury what item we're discussing and a description of it and the Q number?
From the October 9, 2008 report, the items of evidence that were examined were Q46, which was identified as a shovel, and Q46.1, which was a label from the Q46 shovel blade.
Okay. And for the record and court, the stipulation that we could describe these items without any objection.
These are the items testified to by Brian Burke.
You know what is so funny? Who else forgot about the shovel? I completely forgot the shovel. The state made a big deal about that shovel very early on in the trial, but then that's it. I mean, I completely forgot about it. They just dropped it. I think because it got obliterated that there was any involvement of the shovel. But you know what they didn't do? They made a big deal about the shovel, and then you know what they didn't do? Provide any results of the testing of the shovel. Because, I mean, again, the whole thing is silly because I guess the shovel really connects to the backyard. And remember, we did that presentation last time about the backyard and like, did the state think something happened in the backyard? It seems like they wanted to go with that, and then they kind of walked it back, and the shovel would have been relevant there. But here's the thing. There would be DNA on that shovel of, you know, of course, there's going to be DNA of people using it, right? But the important thing, I guess, and we'll hear, is did they find like Caylee's DNA, right? But of course, what does the state not do? They make a big deal about the shovel, and then they just drop it, and they don't provide the results. But we're going to learn the results now.
Order the shovel testified to by Mr. Berner earlier in the case.
Yes,
we do agree. Thank you.
Okay. And could you tell the ladies and gentlemen of the jury what you did with the shovel?
Yes, the shovel was examined for the presence of blood. And so visual examination was performed on that to identify if there were any possible stains. There were some areas that were in fact tested on the shovel, and those areas were negative for the presence of blood.
Now, I'd like to direct your attention to your report of December 16th, 2008. I know you issued two, but I'll let you know which one specifically.
Before we leave this report, I wanted just to be sure the testing that we discussed was the specific to the serology, but there was also DNA performed on that. So I just wanted to be clear on that.
Okay. And what were the results of the DNA?
There, a DNA profile was not generated. There was a sex typing result at the amylogenin locus or the location, but it did not satisfy the reporting criteria of my laboratory.
Okay. And just so we can explain that a little bit. When someone grabs and touches an item, DNA is left, correct?
It's possible.
Okay. But would the touching of the how much DNA you recover depend on the item, how much force is used, and other factors? Can you tell the jury a little bit about that?
Objection, leading and compound question.
Sustain, rephrase the question.
Can you describe to the ladies and gentlemen of the jury a little bit about touch DNA?
Well, touch DNA refers to...
Let me object to the relevance since there was no...
Oh my God, Mr. Ashton, shut up. What is wrong?
I don't know the relevance of this explanation.
I think it goes through.
Yeah. Wow.
Well, touch DNA refers to a type of DNA testing where you expect to have very limited amounts of DNA left behind. It's on items that may not have had a lot of contact with an individual, such as perhaps a piece of paper. If you pick up a piece of paper and you hold that piece of paper in your hand for a little bit of time, it's possible that you've deposited some type of cellular material from your hand on that piece of paper. But in order to get a DNA result that is typable or usable, depends on lots of factors. How long you perhaps had that in contact, and if you are capable of leaving a lot of skin cells behind. And so that all comes into play when you're looking at a DNA result when we're talking about samples that have had limited contact.
Now, when we talk about levels of DNA, how is that measured?
Not sure I understand your question.
What are RFUs?
RFUs talk about relative fluorescent units.
To the relevance, the reproach.
You may. Yeah, objection overruled. You may continue.
Okay, Ms. Seubert, you've already described to the ladies and gentlemen of the jury what touch DNA is, correct?
Yes.
What is low copy number DNA?
Members of the jury, can you hear Mr. Baez?
Yes.
Okay, thank you.
Actually, if I can help. Thank you. Okay. Can you hear me? Can everyone hear me much better? All right. Ms. Seubert, I'm sorry. Can you explain low copy number DNA?
So low copy number DNA is a type of DNA process where going into performing the DNA testing on it, the individual knows there's going to be a limited amount of DNA information there. And so there is a procedure that can be performed to enhance the DNA analysis process to make even more copies, which we haven't really talked about, in the PCR process. So it's actually adding on some of the molecular xeroxing during the polymerase chain reaction when you're actually making multiple copies of DNA to enhance the end result, the DNA profile. So going in, you know you're going to have a limited amount of DNA. And so you're actually enhancing your DNA analysis process to adjust for that, to make more copies to generate a result. And with that result, there's certain evaluations that have to go into those results because of the nature of low copy number. Since you don't have a tremendous amount of cellular material at the beginning, there are some things that in the end that have to be evaluated in order to generate the reliable or to have a reliable result.
Okay. So when we say low copy number DNA, I know these two terms are used interchangeably at times, but that's incorrect, right?
That's incorrect. Right. Touch DNA can be samples where at our laboratory, if a firearm comes in and you think about the nature of when you hold a firearm and you put your finger on the trigger, your hand on the grip, you're coming into contact with it, but not necessarily for maybe an extended period of time. So that would be an area that we would swab, knowing that that's where an individual's had contact. I would expect perhaps to get a result for the deposit of skin cells, but I'm not going to enhance my technique to make more of those copies from my normal analysis procedures. I already expect to have limited amounts, but at the current, when I was in the unit, we didn't have procedures to perform low copy number, which is enhancing the analysis techniques.
Now, I want to skip ahead a little bit to when you actually get the readouts of the DNA results. Can you touch briefly on that? Because I don't want to get too technical.
So what the end readout or the profile is.
Correct.
Okay. Can I back up even a little bit more just to talk about the DNA process?
Sure.
Okay. Since we haven't talked about it, the actual DNA process, how that occurs is, let's talk about a swab. We've talked about doing a swabbing of the carpet out of the trunk, the spare tire cover. So that swab is put into a tube, and there are chemicals that are added, because in order to do DNA typing, we have to get to the nucleus of the cell where all the DNA is housed. So those cells have to be broken open in order to really get to that DNA and unwrap it from where it's contained within the nucleus. And so we're able to do that by adding chemicals, and then that DNA is now taken through the process. And the next step after we're able to extract that DNA away from the item that it's contained on is what's called the polymerase chain reaction, the PCR. And what that is essentially a molecular Xeroxing. It's like going to a copy machine and making billions of copies of that one page that you have, that you need copies of, but we're actually doing that at multiple locations on the DNA. We're actually looking at 13 locations on your DNA. And so we're taking all of those 13.
Now, we hear a lot of people talk about how DNA works in all these different trials. I have to say that I think that she does a job of explaining it really well, and in a way that is less boring and dry than perhaps others. I mean, no offense to great scientists and whatnot, she just, I find this easy to follow, I guess, which I appreciate, right? Because sometimes it's kind of easy to tune out, right? In all these trials when it's like DNA, but like, when she said PCR, I was like, oh, PCR, I don't know. So I think she's doing a good job.
13 locations in making multiple copies of the DNA that's present. And so the next step then is to actually, utilizing an instrument, the DNA is put into a capillary column through a process called capillary electrophoresis. And this instrument has a very small capillary column where the DNA in that liquid form is injected into this capillary column, and we're able to detect it through a process using a laser. And we talked about those RFUs, or those relative fluorescent units. What that's telling me is it's signaling that there's DNA present. And it's able to send that signal to a computer, which is collecting all of that information, and then it's interpreted into a DNA profile. Much like if you've been to the doctor and you have a heart monitor set up and you get an EKG done, you see those peaks on the EKG machine. That's what essentially my end product looks like, those peaks. And those are representative of the DNA profile from that initial test tube where we extracted the DNA out. And we were able to remove it from the inside the nucleus of the cell. And now I'm able to see the end result and generated a DNA profile, which I now will use in my interpretation.
Okay. And what you get through your readout, which are called electropherograms.
There it is.
That's correct.
I was just going to say, that he's going to be using that because this is what he does, right? So whenever you're going to have an expert like this, and the state never did this, right? But they're going to be talking a long time. There's a lot of numbers and information, and it's like really just seems kind of arbitrary. He always does this, and this is brilliant, right? He gets out the freaking easel, and he's going to make a visual. And then at some point, I'm guaranteed he's going to ask her to come down, and it's going to become more interactive, and it's just such a better way of teaching, right? This is teaching. This is how you teach. And you're going to hear, she explains everything verbally. Now it's going to be visual. So for every type of learner on that jury, they have a way to understand.
And what you get are some squiggly lines and some peaks. Do you not? Among other things.
Yes. The peaks are what I'm most interested in.
Right. Okay. And what you talked about to the ladies and gentlemen of the jury are the 13 different locations of where you search for DNA, correct?
Correct. The 13 locations, yes.
And these are also identified as markers.
Correct.
Okay. Points of interest, so to speak.
Correct.
Okay. And depending on how much DNA there is there, well, the peaks also indicate to you how much DNA is present at that specific marker, correct?
Correct. The RFU units will be higher depending upon the amount of signal that's being sent to tell the instrument that it's detecting the DNA that's passing by that laser and creating a fluorescence, which is being collected and is outputted into a peak.
Okay. So if you have, what are the cutoff levels for your laboratory when reporting out something as DNA being at that specific location?
To actually report a DNA type, the threshold for my laboratory at the time I was in the unit was at 200 RFUs. And that was our match interpretation threshold. So anything above 200, I could use to make a match with.
Okay. And there are other laboratories and other kits that can actually report lower levels, correct? That's just that 200 for you to report.
Overall, she can ask the question.
For you, that 200 level number, it's a determination made by your laboratory.
Right. That number was based on the validation by the FBI laboratory at the time when we were validating the instrument and the kit to do the DNA typing in the unit.
But it is common in other laboratories that sometimes the threshold can be lower. Is that correct?
Overruled.
Other laboratories will have different interpretation thresholds. That is correct.
Okay. And can you explain to the ladies and gentlemen of the jury as to what your threshold is to exclude an individual?
Any information that falls below that 200 RFU interpretation threshold can be used for exclusionary purposes. But there is one more threshold that's not depicted on your chart.
Okay, and what is that?
That is at 50 RFUs.
Okay, and what does your threshold with 50 RFUs mean?
50 RFUs is the threshold for where a peak will be labeled a peak. That is our peak amplitude threshold, which is based upon the validation of where a peak will begin to be detected in the FBI laboratory.
Okay. Basically, some people will call these other items down here noise or artifacts.
There are other laboratories that may in fact use the threshold below that 50.
Okay. And if in your laboratory, if you see something that's 50, you can call it a peak.
That's correct. That is when the threshold for identify or labeling a peak begins.
And would you consider the laboratory thresholds that the FBI uses as conservative?
The 200 RFU threshold it's a relatively conservative threshold, yes.
Okay. And the 50?
Conservative. Well, it's based on the validation, so I would say that is a scientific threshold based upon the validation for when reliable results are generated.
Okay. Now, you told the ladies and gentlemen of the jury about you being able to call something at the level of 50 a peak, correct?
Correct.
Now, and that would give you an indication that there's something there, correct?
At 50?
Yes, at 50.
Correct.
But unless it reaches 200, you can't report it out.
If it is at the STR loci, cannot be used for inclusion unless it is above 200. There's an exception with the amylogenin or the sex typing locus where information can be used if it's below 200.
And to kind of bring it all together with what we've talked about with the shovel and some other items that we're going to talk about, when you say that you cannot report it, doesn't mean that there isn't some DNA there. It's just something that your protocols preclude you from making or giving an opinion on, correct?
Objection, based on the competition of counsel.
Okay, you can approach.
No, I think based on the court's earlier ruling. All right,
Yeah. Okay, members of the jury, there's going to be a brief legal matter we need to take up outside of your presence. I'm going to ask that you step outside. We will get back with you as quickly as possible.
Remember, the thing that is surprising, right? Look at the way he stands there. He's doing the lounge lizard. The thing that's surprising is, remember, these are not, you expect this with like experts, right? Like if they bring in an expert, let me just say, because this is an expert, but it's not hired. Like if when the defense brings in their own expert, you expect this. But it's odd when it's law enforcement, who's not hired by the defense. It'd be like, remember the ARCA dudes and Karen Reed? It'd be like if there were a ton of objections, and actually maybe there were. I'm trying to remember. Well, actually, I guess they sorted a lot of that out ahead of time with proffers, which is what they're going to have now. But it's just interesting, right? Because this is like the state's evidence. It's the state's, people. It's law enforcement. Earlier we had Gerardo, Bloise. Now we have FBI. We're going to be going back and forth. This entire episode is entirely state witnesses in the sense that they're all government. They're not hired by the defense. Like if I were on the jury, I would just find it really odd, right? That the state doesn't want certain pieces of information to come out. So here we go. Proffer.
Okay, the jury is outside of the presence of the courtroom. You may proceed with the proffer.
Ms. Seubert, the amylogenin peak that was derived from the shovel, can you give us the RFU for that?
Certainly.
Another thing, she might take a while here. Another thing I will say too is that
on the
it's like, think about it, right? If you're on a jury, right, if you're on, you understand, you've been told what the burden is and all that, right, and how everything works. And it's like you would expect, and it would be normal to think that, like, if you're a criminal defendant, right, the state has all the resources, and their job is to prove that you did something wrong, right? So it's completely understandable and like reasonable, right, and expected that there's going to be pieces of information that are prejudicial, and that, if you're a defendant, you wouldn't want those things to come in. That's why it's weird when it's the reversal, right? That's why it's weird when it's the state, just like with Exhibit 313, when the state doesn't want their evidence to come in. It's a role reversal, right? Because it's like, wait a second, what? You know what I mean? Does that make sense? Like, it's like the state, if the state has their case, right, and it's like, here's the truth, right? The truth is going to point to this defendant, right? Then if the state's like, wait, we don't want this evidence to come in, and it's like their own evidence from like law enforcement, and especially, right? Again, it's different if it's somebody hired by the defense and they retest it can be different. But when you've got the people who the government brought in FBI to work on the case, it's just weird. It's just like with Exhibit 313, when the state is like, oh, we don't want this to come in. You know what I mean? It's like, well, hang on. The reason one side or the other wouldn't want things to come in is if it makes them look bad, which again is expected and normal when you've got the state proving things, trying to prove that a criminal defendant did something. But the reverse shouldn't be the case, right, when it comes to the state. So hopefully that makes sense. It's just ironic.
Swabbing from the shovel at the amylogenin locus, there was an X for the female that appeared at 55 RFUs.
Thank you. I think that answers our question, Your Honor.
Yes.
The import of that then would be to exclude it as being from a man, but not identify it as a woman. Is that how that would be interpreted?
Well, it's at such a limited amount, I wouldn't be able to give any type of information pertaining to that.
Oh, so you can't draw any conclusions? I
cannot draw any conclusions from that limited information.
Judge, that would be my objection. It's a result from which scientifically no reliable conclusion can be drawn. Therefore, it would not be admissible. To tell the jury this and to ask them to somehow interpret it in some way different than the witness does would, I think, be improper.
If I may briefly respond, Judge, I'm not asking her to report the results or to identify that it came from a female. I believe the witness has already testified that if it reaches the 50 threshold, that is an indication that there is something there, that it is beyond a artifact. That is all that I am attempting to elicit from the witness. Nothing more, nothing less.
Question, what's the relevance of that? What difference does it make if there is something there that cannot be scientifically interpreted to mean anything? Then what is the relevance of it?
The relevance is that there is DNA there. Not sufficient enough for her to make a determination as to who it belongs to or what it is, but there is something there. And that is it, nothing more. Now, there's a huge difference between being able to report something, exclusion or inclusion. We're not discussing that. We're discussing whether DNA material, and the witness has already testified that if it passes the 50 threshold, that is an indication that there's something there. That's it. As far as now, if that is fair game for cross-examination, when Mr. Ashton wants to get up and say, you can't say this, you can't say that, you can't do this, and that's fine. But as far as what I'm trying to elicit from the witness is simply that there was a portion of DNA there, and that's it, nothing more.
The problem is, to what end? Is counsel going to elicit this and then at some later point argue to the jury that somehow that bit of DNA could have been amplified, could have been this, could have been that, without scientific support? Unless it is relevant to an issue.
It's crazy.
Then
it seems like he's the defense.
It's meaningless. It's not relevant.
If it's not relevant, why is the shovel in evidence?
Great question.
The shovel is in evidence.
Mr.
Counsel knows why the shovel.
Mr. Ashton, calm down.
Wow.
Okay, calm down.
I love this.
Sit down for a
He's
second.
getting yelled at.
Yes, sir.
Woo!
Have you finished, Mr. Baez?
Well, my point is, Judge, this evidence this shovel has been brought into evidence. It is a relevant piece of evidence. There's testimony been admitted that Miss Anthony borrowed the shovel.
I'm not concerned. I'm concerned about her.
I just want to say that's exactly what I was saying, right? That the state brought the shovel in. That was their choice. And now he wants to keep the shovel out. You know what it is? It's like the state had to try they're improvising their theory of the case as they go along. It's wild. Because again, we saw them start out with these certain things and then they disappeared, just like with the backyard. The backyard and the shovel went by the wayside pretty quick with them. But anyway, I think Mr. Ashton gets scolded even worse during this.
Testimony and what she's going to say. Okay. You have anything else to say about her testimony?
Nothing further, sir.
Okay. Mr. Ashton, reply from the state of Florida.
Yes, sir. I still would submit that the fact that there is a scientifically meaningless result on a test isn't relevant unless it can be tied into some issue in the case.
It's such bullshit.
And my concern is that counsel is going to, without eliciting from a witness whether this could.
It's such bullshit because, this is more than what, dude, it's such bullshit because they offered, the story about the shovel, which literally made no sense. And it wasn't even Casey that used it. It was Tony used it to just pry open the lock on the shed or whatever. I mean, it was so pointless, right? But they brought that in and they're trying to say that this is pointless. It just doesn't make any sense.
Ever be used to do anything, argue to the jury something that we know is scientifically incorrect. I think it needs to be relevant for some argument or some issue before the court.
The converse to that, Mr. Ashton, is those are things that you can ask her in your cross-examination. Ma'am, the results that Mr. Baez is seeking to elicit from you, exactly what does those results mean?
All I can tell you, Your Honor, is that there is a peak there, and it is...
Is it DNA?
Considering that the initial threshold of determining a peak is at 50 and that peak does appear above 50 RFUs, it is a peak and is consistent with an X at the amylogenin typing or at the locus. So I have no other information other than there is a peak.
There's a peak and it is an X, you said?
Yes, sir.
Okay, and what does that translate into?
Well, it's potentially could be from a female, it could be from a male. It's at such a low level in my report for the conclusion that I gave is that it is do not satisfy the reporting criteria and no conclusion can be offered.
So you can't say whether it originated from a male or a female?
Well, with the absence of a Y peak, all I can tell you is there's an X there.
And you can draw absolutely no conclusions from that?
No, sir.
Okay.
I'm not asking for any conclusions of the witness, nor will I ascertain. The only thing that I was attempting
Okay, let me cut both of you short. Okay. I will permit you to ask the question. The state can clear it up in cross-examination, and then the jury can take it for whatever it's worth. Okay?
Yes, sir.
Anything else, folks?
Your Honor, may I ask a question?
Yes, ma'am.
And I don't know how the information will be presented, but it is at a level that, since it's not in my report, I would have to be speaking about the result from a table that's in my report if we're going to address that. That's in my case file to address that specific piece of information.
Okay. Anything else, folks?
Nothing further.
Okay, let's return to jury. Okay, state recognized presence of jury.
Yes, sir.
Defense?
Yes, sir, we do.
Okay, Mr. Baez, you may proceed.
Thank you. 1, 2. Can everyone hear me? Okay. Ms. Seubert, where we left off, and I'm just going to recap for a moment before I ask you my next question, is we talked about the different thresholds of how much DNA is present on your electropherograms, the readouts. And when we were talking about the shovel, you mentioned that at one of the markers, there was something that reached above the 50 RFU levels. Is that not correct?
Correct.
Okay. It did not reach the 200 level, and you did not have multiple markers or sufficient markers to be able to report it out, correct?
That's correct.
So is a fair statement that there is something there, you just can't report what with any degree of scientific certainty?
Sustain, rephrase the question.
Yes. What's the best way to summarize what's there and what's not there?
Well, at the locations that the short tandem repeats would be present at, the 13 locations, the DNA profile, a result was not obtained at any of those 13 locations. For the amylogenin or the sex typing locus, which would indicate male, female DNA, there is a indication present of DNA at that location, but it does not meet my reporting criteria.
Perfect. Okay. Now I'd like to direct your attention to the next report that you issued in this case on March 19th, 2008. I'm sorry, that would be 2009. And let me know when you take your time. Just let me know. I know you got a lot of stuff there.
Your Honor, could we put the bench on this matter?
You may.
Mr. Ashton is in Proffer.
I have that report in front of me, the March 19th.
Hold on.
Oh, sorry.
You may proceed.
Have you had sufficient time to get your documents?
Yes, sorry about that.
And you have your March 19th, 2009 report.
Yes, sir.
Okay. Can you explain to the ladies and gentlemen of the jury what these items of evidence were?
So items that were reported out on the March 19th, 2009 report were identified as Q62 through Q64 as tape, which were items from the medical examiner's office.
And for the record, this is State's Evidence 302. And are we talking about duct tape?
Yes, sir.
Okay. And these were duct tape items that you received from the medical examiner's office?
Yes, they were submitted to the FBI laboratory, and the origination of where they were collected from was identified from the medical examiner's office.
Okay. Can you explain to the ladies and gentlemen of the jury what you did?
On the items of the tape, they were examined, and there were three pieces, Q62, Q63, and Q64. And that the first examination was done on the top side of the tape. I'll refer to it as the silver side of the tape. And a cotton tip swab was taken, moistened with water, and the top side of that silver area was swabbed to collect any possible biological material that would be present on that silver side of the tape.
Okay. And when you say the top side, you're talking about the non-adhesive side?
That's correct. The top side, yes.
Okay. And were there any distinct markings on the top side of the tape to help you identify the item of evidence?
I have a description here that the manufacturer's logo, Henkel, spelled Henkel,
right there.
was throughout the tape.
Okay. And did you get any results, any DNA results from the top side of the tape?
Yeah, so the swab itself DNA typing was performed on that swab that was collected from those three areas of tape, and a DNA profile was generated. However, it was below the interpretational threshold of the FBI laboratory's reporting policy.
Okay. And when you say below the threshold reporting policy, can you give us how many markers were present, number one?
On the top side of the duct tape, or the silver side of the duct tape, an STR result, or the DNA typing result, was obtained at 6 of the out of the 9 locations that were tested. And if I can just back up and describe that
Sure, please do.
for you. So in doing DNA typing, there's actually 2 typing kits. They're called amplification kits that are utilized to come up with the totality of the 13 locations.
Let me ask you, I'm sorry, Ms. Seubert, would it assist you to would it assist you to use the board to kind of explain it a little clearer, or do you feel comfortable enough doing it from the stand?
As long, if it becomes confusing, you can let me know.
I don't know if the jurors can let you know. Well, Your Honor, may the jurors raise their hand if they're getting a little confused on the issue?
So this is,
No.
I can list out the locations if that would be helpful.
That might.
so what this is he wants her to come down and use the thing because he knows that that's a better learning tool. But it's not, the jurors are not allowed to do, like, I understand how he's trying to go about this in a way that makes it not awkward, but he really wants her to come down and explain it. But he can't, like, he has to make it seem like it was her idea, right? Because we see this all the time. So
Might be a little helpful. May the witness stand
Do
down.
it.
Your Honor.
Yes.
down.
I can hold your papers if you want. Okay, sure.
Okay. So the areas that we've kind of talked about, there are 13 locations on the DNA, and they are selected because of their highly polymorphic, or they're very different between individuals. And they're actually located on different chromosomes. And we haven't talked about chromosomes, but you actually have 46, 23 of them came from your mother, 23 of them came from your father. And so on those chromosomes, certain locations have been identified as being highly polymorphic or different that have been selected to be looked at in forensic DNA typing. And so within one of the kits, there are actually 9 of those locations that have been identified and that we will amplify the DNA with, or target those locations, make the copies, and generate, if there's enough DNA there, a DNA result. And so I'm going to write out those DNA locations for you so you can see their names, and I can tell you a little bit about what each of those names means.
Can you see that, Mr. Ashton?
I cannot see that. You can just push back just a bit. Yeah, that's fine. Right where you had it was fine.
Right there.
I can't see it.
Can everyone see it? Okay.
So what I've listed out here are each of, well, this is 9 of the locations that we would look at in one of the tests, or that are contained with one of the kits. And that kit that I've listed here is the Profiler Plus ID kit. And each of these locations, this one is D3S1358. D3 is actually on chromosome number 3, and it is the location. It's basically like its house address on the chromosome. If you think of the street that you live on, it's the main street, and it's kind of like the house number for the area that's been targeted. And so as you go down the line, you have VWA, FGA, DAS1179, D21, shortened D18.
What I want to point out is, like, that was a great way of describing it. And the thing is that I guarantee you, if she was still sitting on that witness stand rattling off this information the same way she's done for however many times, I guarantee she wouldn't have even said that. Now, here's why. What she's doing now is she's teaching, like she would be teaching to a class, right? The thing is when you change the environment, you change the testimony. So if you've got a witness like this, who, let's say she's, she's a teacher, that's clear to me, but she's sitting on the witness stand. She's in witness mode, right? And she's going to be giving this testimony, again, probably the same way she's done it a lot of times. But as soon as you ask them to step down and present information to the jury like this, especially with a demonstrative aid, now they're teaching. And it's just completely different testimony. And he does this all the time. And I don't think enough in any trial, attorneys utilize this enough. I think it's brilliant. And, you take a couple seconds to make sure that everyone can hear them, everyone can see. And then now you're teaching the jury. And it's just completely different. It's so much more engaging. And the testimony that you get from the witness, I think, is really much more helpful.
D5, D13, D7, and then amylogenin, which we've been talking about as the sex typing locus, which will tell whether or not you have male or female DNA present. And so what happens during the DNA typing at the very end, as a part of my analysis, when I do my interpretation, I'm actually looking at the peaks that Mr. Baez talked about earlier at each of these locations. So at D3, I would actually look at if there are peaks present and what the DNA type is for each of those peaks, and then I would populate the table, which would represent the DNA profile. And what these peaks actually represent, and we've talked about is DNA, but these are actually the short tandem repeats. They're STRs, which are the types of DNA repeats that are present at each of these locations. And so essentially counting up how many of those repeats are present at each of the locations that were examined.
And do you get one of those numbers from your mother and one from your father?
That's correct.
Okay. And what happens if both of your parents have the same one at that location?
So if your parents have the same STR type at that location, then you're going to have just the one peak. So for example, let's say we'll call this D3 here. And let's say this is a 15, 16. And let's say we go to VWA and there's just one peak there. That means both your mother and father have given you that one type, and then you would just be, we'll call it a 10. And so both parents have given you that 10 as your DNA makeup at that location.
So what we've looked at so far that you've written, in a hypothetical situation, this person would be a 15, 16 at this marker, and then a 10 at this marker.
Sure, and that's, so each of these markers, there'll be if there's enough DNA present to generate a result, there will be a peak or two peaks present if you have a single source sample.
And when you have the full combination of the 13, that is when you have a DNA profile.
Well, you can actually have a DNA profile just at one location. So you don't necessarily.
For anyone who's joining us, but she's been up here a while. So this is an FBI analyst. She's actually like a supervisory role expert from the FBI. Again, not hired by the defense. She was brought in on the case to test a number of items, but the state did not call her, and now she is explaining how DNA works to the jury.
Necessarily need all 13 to have a DNA result. It could just be at one locus. It could be at two.
Look how he's holding the boxy thing for her lapel mic so that she can do this.
It could be at a combination of them.
Boxy thing.
And so I've only listed out 9 of the locations here. The second test actually has another series of these locations contained within it that are targeted. And that's where you get the additional loci would be in the next test or locations.
And depending on the marker, it tells you how discriminatory it is, meaning how many people might have that number at that location.
That's actually a different part of the process.
Okay. And that's, I know we're kind of jumping ahead, but as it relates to the duct tape, what did you find on the non-sticky side of the tape?
In my report, I identified that there was an STR typing result obtained, but it fell below my reporting threshold. So if I list that profile here, it's going to, if I can list it as such that it would be representative of a profile that I would only be, that would fall below my reporting threshold. Okay. If I can write it out that way, but indicate that.
Okay, that's fine. That's fine. We understand.
Okay.
Okay, so this is DNA
Now,
duct tape.
how many of these markers do you need to exclude someone?
It could just take one marker to exclude an individual.
Okay. In what you obtained, could you exclude Casey Anthony?
Now we're talking specifically to this particular item.
Correct.
Yes.
Okay.
Wow.
So, Casey.
Did you hear that? That's huge. This is the duct tape. This blow, again, it's just, I don't know why I'm surprised. This is what I should expect, right? Because I know, I mean, you know, in my opinion, who handled that duct tape. But, I mean, she's excluded. She's excluded from the DNA on the duct tape.
Casey Anthony was excluded from what you got so far.
Yes.
Okay. And was Caylee Anthony excluded as well?
Yes.
Okay.
Okay.
Did you do something further to try and determine who this partial profile belonged to?
Interesting.
Yes, I did.
Okay. What did you do?
Well, after I had generated this DNA profile, I used all of the.
This might get to, remember we heard about this in the beginning, and we've been waiting this whole time. I've been waiting this whole time. We heard from opening statements about how you know, I remember him saying that the only DNA that was found belonged to one of the FBI analysts, okay? But that hasn't fully come in yet. Whenever it's been kind of dabbled with, the state has objected. And I wonder if that's where he's getting to. So I still think it's noteworthy that Casey is excluded, like she's excluded. But so is Caylee. But in other words, where we're at right now is there's some DNA on this duct tape, but it's not Caylee and it's not Casey. So it's really going to be a matter of like where I would see, is this trying to be like, could it be George, right? Or is all this buildup getting to the contamination from the FBI? So we'll see.
Known samples that were submitted to the laboratory, the known blood samples that were submitted from Ms. Casey Anthony, the known profile that we used for Caylee Anthony, as well as other family members that had been submitted, Cindy Anthony, Lee Anthony, George Anthony, and I compared those profiles to this DNA profile that I had generated. And all of those individuals were excluded from this profile.
Okay. Did you take it a step further? Actually, we could probably get you back to the witness stand.
Thank you.
Take that from you so I can give it to Steve. what was the next step that you took to try and determine who this might be?
Based upon the generation of that profile in it, and I had excluded the known samples that had been submitted as a part of this case submission, the next step was to evaluate the staff database that was maintained as of the DNA analysis unit. So the individuals who work in the DNA analysis unit will provide a sample and will maintain a database of all of those types to compare when a profile is generated to determine if it could be one of the staff who'd work the case or who are working in the laboratory.
Okay. And did you find someone that matched all of these different markers?
Not, and they're not from the DNA analysis staff database. No, I did not.
Okay. What did you do to, what further did you do?
The next step that I did was I determined what other units at the FBI laboratory had processed this item of evidence. And knowing that the profile I had was a female profile, I started looking at specifically any female female examiners or technicians that would have handled this item. And so working with the evidence control unit, I was able to identify which units this item had been processed in. And I contacted those individuals and asked if they would give a DNA sample.
And did they?
Yes, they all did.
Okay. And who did it turn out to be?
This profile was matched to Lori Gottesman, the question document units examiner.
Okay.
And
now,
there it is. There it is.
This.
So there it is. And we're going to hear from her actually as well later. So here's where I think this is going, because I know there's going to be more talk about the maternal line and all that of DNA. So here's where I think this is going. I think this is going to, just two things, right? First of all, obviously Casey's DNA isn't on there, but neither is George's DNA, right? But the fact that somebody from the FBI, and we're going to hear from her, right, and all the protocol and how easily she was able to leave DNA on that duct tape, right? So one would think to themselves, right, like if it's so easy, right, because duct tape, right, of all things, sticky, you leave, so easy to leave DNA behind. So that serves two things, right? It's like, well, clearly if Casey had handled it, her DNA would be there, right? And so I think one could say, well, then the same would apply to George, right? Like whoever handled that duct tape, whoever it was prior to the FBI, shouldn't their DNA be on it? But here's the thing. I think what they're going to be trying to show here is that when there's compromised DNA, right, or you can only test it that certain way, you can only get, and I don't know all the words, they'll talk about it. I don't know all the words off the top of my head, but in other words, it's the maternal line, right? That DNA that is less reliable, less specific or whatever, that will show up easier than male DNA. This would be sort of where I think this is trying to go. Now, they're not going to be able to come out and say this, but I think this is what will be suggested, is that the explanation is that given the degradation over time, that could be potentially how male DNA wouldn't be detectable, but how, female DNA maybe would, and therefore you could say, well, Casey being excluded is because she wasn't handling it, and maybe George being excluded or not found is because it's male DNA and the degradation. I don't know. That's just sort of what I'm thinking they're going with this. Because it's not like, the thing is he, like, sometimes people will bring this stuff in, right, in other trials, the contamination. Like, take Karen Reed, for example. I mean, there's other trials, but just as an example. Shown for a reason, whether it might be trying to show just shitty police work. Did a terrible job. You can't trust the evidence, right? Sometimes they'll bring it in to try to show, I guess like this is really more Karen Reed. Like they're trying to frame her, right? You don't see that one as often. But either way, usually when this is brought in where there's like some sort of contamination, it's to try to, this is I guess what I wanted to highlight. It's to try to cast doubt on the forensic techniques, right? It's to try to cast doubt and to say to the jury, you can't trust the results. That's what's different here. And this is really unique, is that is not why he's bringing this in. He's not bringing this in to try to embarrass the state or to say, or not the state rather, but the FBI, or say you did a crappy job, or we can't trust you. And the FBI is all up in this. They tested all kinds of stuff. There's been tons of FBI witnesses and there's more to come. That's not the point of this. I think the point of this is it's the opposite. It's, you guys did such a good job and you took all the protocols and you did everything right. And yet still, this is how easy it was to leave DNA behind. I think that's, so it's, you know, again, normally you see this coming in trying to be like, oh, it's contaminated. It's to try to, again, make them look bad. And that's not the case here. That's not what he's doing with this. He's using these FBI agents to explain to the jury just how, again, how unlikely it would be that if Caylee had handled it, her DNA wouldn't be found. That, in fact, the DNA of that FBI analyst is found. So, yeah, we'll see what else, though.
Well, let me ask you this first. Is it possible when you contaminate DNA that it may overwrite DNA that's already there?
Good question.
Well, it would depend on the quantity of the DNA.
That's a really good question that is so relevant for every trial, right? I don't know that I've ever heard, I mean, I'm sure it's been done, but I don't recall that question point blank being asked. Interesting.
That you're suggesting is the contaminant. So there would be some factors that would have to be considered with that.
Okay. Explain those factors.
Well, depending on the quantity of DNA, if you have a very large quantity of DNA, it is possible that it could shadow or hide the very small presence of DNA from another individual. However, on this specific item, the profile itself is at low levels. And so if there had been an additional individual present, I would have expected to see a mixture at some of those locations.
Another thing I'll say is you can tell by the questions he's asking, he's not met with her before, right? You know, that's, now they would have probably deposed these witnesses, but he's asking these questions, you can tell based on what she's saying. So what do I mean by that? What I mean is that he's getting an answer, and then based on the information, he's asking another question. And the fact that he's asking these questions, like, here, how to explain this? These questions to me show that he knows for a fact that his client is innocent, not just not guilty, not just she'd be acquitted. He knows she's innocent. He knows it. And here's why. Because you wouldn't ask questions. They all say, right, don't ask questions you don't know the answer to, right? There is a reason for that. This is a rarity where you can tell he's asking questions where he doesn't really know what she's going to say, but he has full and complete confidence that whatever she says is going to be informative to the jury, and in no way it will implicate his client. He knows that, because that's the only way you can ask these questions. When you have an expert like this, they could easily give an answer that, you know, could implicate. He knows it's not going to happen. That's what I'm taking out of this.
That would only include if you had various, a large enough amount of DNA to account at different markers, correct? Meaning if you only had 2 markers and this DNA overrode that, or just one, it is certainly possible that this would overshadow any DNA.
Objection, it assumes hypotheticals, not based on facts and evidence.
Sustain, rephrase the question.
If it's still possible that that this contaminant could have contaminated other DNA that's there, correct? At lower levels?
I would have expected at the levels that this profile is at, if there was an additional profile there, I would have expected it would have been mixed with another profile if contained there.
And what if that profile that might be there would be at such a low level that it got overridden with this? Is it still possible?
Oh, this is so important, though.
I'm asking her a scientific question, Your Honor.
But this is
she
important.
can answer it.
Stop.
Facts that are not in evidence.
Wow.
I don't think,
Wow.
Your Honor.
Fuck.
Okay, let me ask you this. Can contaminating DNA override something that's already there?
Objection has an answer.
Overrule, I'll let her answer the question.
This is a hypothetical. If you contaminate an item, can it override
This is
DNA that's
really,
already
God, I can feel the tension in the courtroom. This is incredible. This is really important. And that's why he's objecting so much. Again, just to reiterate, what they've already covered here, because it's been a long, she's been on the scene a long time, what they've already covered is they found, we've now gotten into the DNA that was found that came from another FBI analyst, and she went through all that. But the key thing about that is what she's saying is it was at very, very low levels. So the question that he's trying to ask here is, considering that the contamination, that DNA was at such low levels, the profile was at such low levels from Lori Gottesman, who we'll hear from later, would that be enough to override another DNA profile that was there? If there was another DNA profile there. I mean, obviously it's like somebody touched that duct tape, right? Like it had there, you know what I mean? Unless it was degraded. And that's where the next question came in is, what if that was also at a low profile? Because there's the different factors, right? Because some people leave more DNA than others just naturally, but then you also have the fact that this is duct tape. But he's getting objected to over and over again.
Either.
If the presence of a very large, if you have a very large volume or percentage of DNA deposited on an item in a very small amount of a second individual, it's possible.
Okay. Now, the item of evidence got to DNA, the DNA lab, much later through the processing of this duct tape, did it not?
We were the last units, yes.
Okay. Is that common?
Not sure how to answer your question if it's common.
Sure. Would it have been more advantageous for DNA to get the duct tape first, the DNA lab to get the duct tape first before other technicians had already had access to it and potentially contaminated it?
Okay, so the reason he's asking that, oh, sorry for that pause, is, oh my God, is because, so the contamination, oh my God, that pause isn't any better. There we go. Okay, that is because, remember, the contamination came from Lori Gottesman in the question documents department. So what is that? We're going to hear from her again, but the point is that she had to, the question documents department was to identify the brand, right? And that already came out, Henkel duct tape, right? That's the question documents. So that's one department. Then you've got the question DNA department, right? This is a really good question that he's asking. I see why he's asking it, because what he's saying is that normal for the duct tape to go to the question documents department first and then the DNA? And you can see why, right? Because the DNA thing is probably the most important, right? And maybe the most easily contaminated. However, determining the brand of the duct tape could be done after, I think is where he's going with this. And you can see she's taking a thoughtful period of time to answer it too.
It wouldn't have altered the way that the tape would have been processed in my unit.
Okay. But it would have reduced the possibility of other people contaminating the duct tape.
Because she didn't contaminate it.
Well, anytime an item is handled by fewer people, there's a less of a chance of.
I mean, what's happening here? She does not want to throw her colleague under the bus, and I get it. That's fair. It's fair, because it's common sense that it doesn't make sense that it was sent there first, and that wasn't her decision, you know. So what she's saying is my department would test it the same. Of course it would. It's whoever made the decision. I don't know who, and maybe we'll hear from them. Somebody made the decision to send it there first, and that's the error, right? Because the thing is that had it already been tested for DNA, you know, then if something was left behind by the question documents analyst, you know, yeah, that's still not good, but at least it wouldn't be as big of a deal if it's already been tested for DNA. Now, of course, things are always, you know, you want to be able to retest them and you don't want them contaminated, but just in case, right, it should be sent to DNA first. I mean, that just makes logical sense. But she doesn't want to throw anybody under the bus, and I get it.
Another or of individuals types being deposited on that item. So sure, the fewer people that handle an item, the less chance there is.
She's answering it in a common sense way.
Contaminant or another DNA profile being deposited on it. But that still didn't change the way that I would have processed that item.
I understand, ma'am.
Right.
From your understanding, how many divisions and people got to this duct tape and processed it before you got it?
Well, the examination plan is developed by the
I
evidence.
pointed this out. when what's her face was testifying. Oh, what was her name? Miss Fontaine was testifying. I don't know if you guys remember. I'm sure I have it timestamped where he had her go through every step. And what drew my attention, it was because he was counting. He was like step 1, step 2, step 3, step 4, step 5. And he went on and on. And then finally it was like step 9. And then it was like, is that the last step? And then she laughed and she was like, oh, there's one more. And everybody laughed. And it was funny. And I was like, there's a reason he's doing this, because it was going to take, I was like, this is taking a lot of mental energy for him to be counting this and remembering exactly what number. And she wasn't even memorizing what number, but he was. And I was like, the point of, there's a reason for that. And it's going to come up later. And here it is. That all these different steps and all the different people that handled it and all the departments it went through, and even within the same department, how many steps it went through, you know, that shows, you know, the ability for it to be contaminated and whatnot. And it's passed along through all these different people. I mean, even just that Miss Fontaine, she was in the fingerprint department and she had a bazillion steps. And so she had it in the fingerprint department. Oh my God, something just dawned on me. Sorry, something just dawned on me. Okay. She had it in the fingerprint department. We knew it was sent off, but she said she sent it off to question documents, but we didn't have the information we just got today. So she sent it off to question documents, remember? And then remember, she got it back, and then that's when she saw the outline. It does make you wonder if what she saw unknowingly was actually from the contamination from Lori Gottesman in the question documents department. Huh. And then that's when she noticed that. She didn't get to see it the first time, she saw it the second time. And then after all that, then it was sent to DNA. Fuck. Wow.
It's control unit for the movement of items in the laboratory, and that's where the decision is made for the movement of items in a case. And so on this particular item, there were several different types of examinations that were going to be performed. So it went through the trace evidence unit, the chemistry unit, latent print unit, and the question document unit prior to the DNA
more
analysis
units
unit
than I
receiving
named.
it.
Okay.
Jesus.
Now, it was your understanding as well that the duct tape had been exposed to numerous elements, right?
The case information did describe that the location of where the evidence was collected from was outside and would be have water in it at times. And so, yeah, it was conveyed in the incoming letter that it was outdoors.
Now, the elements do and can degrade DNA, does it not?
Oh my God, Mr. Ashton.
Sure, the elements, sunlight can destroy or deteriorate the DNA.
The state led the fuck out of every witness, even when they weren't experts. And usually you're allowed to lead experts. And he never objected. And this is an expert.
Present,
Anyway.
humidity, those several different factors of being outside could impact the amount of DNA that would be left on an item.
So why do you then do the tests?
Well, based on the item itself as being evidence, in this case, it was my thought that from a forensic standpoint, the item should be swabbed to determine if there was any DNA present on that tape that was left on the victim.
Okay. And you can still get DNA even from items that are underwater?
Objection.
Can you not?
Sorry, I thought it was objection leading.
Question calls for a yes or no answer. Chaz, can you get DNA from an item that's underwater?
I don't believe that's the question as phrased.
I believe it was, Judge.
So many objections.
And you still get DNA even from an item that's underwater?
Yes, so that's what I objected to.
Overruled. Can you answer the question, ma'am?
In a yes or no fashion, Judge?
It calls for a yes or no answer? Unless you need to explain.
Look at his face. Again, you can tell he doesn't know the answer. This is again my point. He's asking these questions without knowing what she's going to say, but there's only one reason for that.
If I could have the opportunity to explain.
Go ahead.
Okay, thank you, sir.
She's really funny. with this?
It's possible, but there again would be several different factors that would be involved in the length of time an item has been submerged, what type of biological fluid, was it blood, is it semen, is it other types of biological fluid that were present on that item. So there are several factors that would be considered into whether or not you would be able to obtain a DNA profile from something that has been submerged underwater.
And in fact, you can also get DNA from profiles from people who've been burnt victims. Can you not?
Sustained.
Do you know if you can get a DNA profile from someone who has been burnt or a burnt victim?
Yes, sir, you can.
Okay. And
got it in.
Are there multiple variables that could determine whether a DNA profile can be generated?
Sure, there are variables that the generation of a DNA profile would have to be considered. Sure.
Okay. And is it fair to say that you never know what all the variables are until you actually test it?
Objection, leading.
Sustained, rephrase your question.
Yes, sir. Would you know what all the variables are of a specific item before you test it?
No, I don't have all the knowledge of an item prior to its coming to the FBI laboratory.
Okay. So is it possible for you to know whether you'll get DNA from an item unless you actually test it?
Can I answer that outside the yes or no, sir? Well, that would depend. If it's a blood sample that is a red-brown stain, I expect to get a DNA profile from that reddish-brown stain that I've concluded is blood. If it is a general swabbing item that I've not identified any biological staining, but I am trying to collect biological material, in that case, I don't know if I'm going to generate a DNA profile.
Okay. And when dealing with duct tape specifically, where would you expect to get a profile? Where would you expect to get a better chance of getting a profile? The outer portion for the person applying the tape, or the inner portion where it might be attached to someone's face, saliva, and other bodily fluids might be getting on it?
Objection to a hypothetical applicable to this case because of the environmental factors. Could we approach for just a moment?
Yes.
Thank you.
He is just insufferable. The clapping bit.
I'm sorry, I forgot where I left off. Can I ask the court reporter to read back where we were, Your Honor?
You may.
And that's part of why he does that.
Where would you expect to get a profile? Where would you expect to get a better chance of getting a profile? The outer portion for the person applying the tape, or the inner portion where it might be attached to someone's face, saliva, and other bodily fluids might be getting on it?
Can you answer that question, ma'am?
Yes.
Okay.
The higher likelihood of where the DNA profile would be generated from would be from the underside, where it's actually coming into contact with an individual's face, saliva is being deposited on it, so there's cellular material coming from from saliva.
And if it is attached in a violent manner, it would also have skin tissue attached to it, would it not?
I'm not sure that I understand the violent manner.
If it was put on firmly, tightly, that would have skin tissue on it, correct? Or you would expect to find skin tissue on it?
Well, just the contact from the tape being placed on a person's face, you think about the adhesive, and just like when you pull a Band-Aid off, that hurts, and it's what it's taking with you are part of the cellular material on that topical surface of your skin. So you think about the same adhesive contained in a piece of duct tape being placed on the face, the same type of adhesive is taking place with the contact.
Okay. And did you test the adhesive side of the duct tape?
Yes, I did.
And was there anything that you were able to find there?
The information that was generated was inconclusive.
Were you able to find was there a readout at a D3 marker?
There was a peak detected at the D3, yes.
Okay. And can you write down or tell us what number that peak came to?
Yes.
You can just say it.
Okay. It's a 17.
17. Do you know if Caylee Anthony is a 17 at the D3 marker?
I'm going to take a moment just to retrieve my profiles.
She's retrieving her profiles. Let me see if I can. I think this one takes a while. Let me jump ahead a little bit here if I can. Pretty sure it takes her a good while.
Okay. And what about Casey Anthony?
Okay, so that was a no.
Casey Anthony is a 14-15 at the D3 location.
Okay. So she also does not have a 17 at the D3 marker.
That's correct.
Okay. And when you have one marker that does not match an individual, can you exclude them from being a contributor to that DNA?
Yes.
Were you given the DNA profile of anyone else other than members of the Anthony family?
Yes, I was.
Okay. Who else were you given?
Are they in evidence?
No, they're not, Judge. I'll withdraw the question.
Okay, thank you.
Okay, I guess that's everything that concludes the March 19th report, correct?
Yes, sir.
Okay, let's move to your next report on July 24th, 2009. Just take your time. Let me know when you have it.
Can you repeat the date again, please?
Yes, July 24th,
It's another
2009. I believe that's from my draft.
This is another
You have
long
it
one.
as August 19th of 2009. You identify to the ladies and gentlemen of the jury what items, the first item that you received on this report.
Yes, the first item that was received is identified as Q80, which was a pair of shorts.
Okay, and for the record, this is State's Evidence 269. And where did these shorts come from?
These shorts, the shorts were identified as items from the medical examiner office.
Okay, and what tests were done on those shorts?
So Kaylee's shorts.
On the Q80 shorts, the item was examined for the presence of blood and semen.
Okay, and what were the results? Were you able to confirm blood or semen on the shorts?
No, both of those tests were negative for the presence of blood and semen.
And then on, what's the next item that you received?
Q81, which was identified as clothing.
I'm sorry, I'm going a little too fast.
Sorry.
It's my fault. Okay, and when you refer to clothing, you're referring to the item which would include the shirt, which was like the elastic portion of the shirt and the letter writings of a child's shirt?
Yes, I can read my description if that would assist.
That would be better. Go ahead.
I have it identified as containing letters, stitching, and stretch material.
George.
With the
George.
letters being spelled or containing BIGTROUBLE.
Interesting. I wish they showed him
And
more.
there was also some stick and other debris contained with that item.
Okay. Were you able to confirm blood on that item?
No, I could not confirm blood on that item. The chemical test for the possible presence of blood was positive. However, there was insufficient quantity to continue on and confirm the presence of blood.
Okay. So you can't say in any way that there was blood on there?
Only that the possible presence of blood, that it was positive for the possible presence of blood.
Okay. And was that tested any further?
Specimen Q81 was continued on for DNA typing.
Okay. And out of that, what you thought was possible, were you able to come up with a profile?
No, sir, there was no DNA obtained from that item.
Okay. And on what's the next item?
The next item is Q82, which is identified as a blanket.
I'm sorry?
It was identified as a blanket.
Okay. And on the blanket, were you able to confirm blood on that blanket?
Could not confirm the presence of blood. However, the chemical test for the possible presence of blood was positive.
Okay. And did you then take it a step further to see if there was DNA there?
Yes, that item was swabbed for DNA testing, and no, there was no DNA profile generated from that specimen. There was an additional chemical test also performed on that blanket.
Okay. And what other test was done on that blanket?
That item was also looked at for the presence of semen.
Okay. And did you find any?
No, that item was negative for the presence of seminal fluid.
Okay. And the next item?
The next item is Q84, which was identified as a laundry bag.
Okay. And that laundry bag, what test did you run on that?
The chemical test for the presence of blood was performed on that item, and it was positive for the possible presence of blood. However, there was insufficient quantity to continue on for a confirmatory test.
That is very
Okay.
interesting.
And did you then take it a step further and try to get DNA?
Yes, sir. DNA typing was attempted on that item. However, there was no DNA typing results obtained.
Okay. And then the next item?
The next item is Q103, identified as a blanket.
And what test did you run on that?
Is significant.
That item was tested for the presence of blood and semen.
Okay. And what were your results there?
The chemical test for the possible presence of blood was positive on the blanket, and the tests for the presence of semen were negative.
Okay.
Remember, all of Casey's clothes showed no blood.
Okay. And can you give a better description of, actually, if I can have a moment.
And that's why it matters, because her clothes, there was no blood, and they didn't test any of George's clothes. So. Look at Mystery and Burdick. Wow, she looks nervous or something.
My apologies. The blanket that was just described is not an item that's in evidence. It's completely unrelated, and I wanted to move to strike that on my own. and the references to that.
This would be as to which Q number?
Q103.
So I agree the jury should disregard any discussions about Q103. It has nothing to do with this.
And it's completely my error. Mr. Ashton and I had spoken previously in the process of going.
So that's the blanket that she's just testified to?
Correct.
Ladies and gentlemen of the jury, you're hereby instructed to disregard testimony that the witness has given concerning the blanket that she's just testified to and not utilize that in the decision-making process in this case. You may continue. Thank you, Mr. Baez.
Now,
Thank you, sir.
the possible presence of blood is still pertains to
Ms.
the
Seubert,
laundry
there are
bag.
other items on your report that are not in evidence, so I have to ask you specifically for which ones, okay?
Yes, sir.
And testify only to those. Can you also tell us about Q244?
We identify that with
Yeah.
the number so that we make sure
That is, States Exhibit HR. Can you tell us, give us a description of Q244?
Yes, Q244 was identified as a doll that was received at the laboratory.
And where does the doll, where were you informed the doll came from?
It's identified that the doll was collected from a vehicle, and I can check my notes to determine what vehicle specifically.
Sure, go ahead.
Well, we know which vehicle, but you know. She's checking her notes.
Can we both stipulate it's the Pontiac Sunfire?
Yeah, go ahead and stipulate. 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 So she's still looking for it. Just, yeah, stipulate. Go on. Go on.
Your Honor, we have a stipulation that the doll came from the interior portion of the car on the car seat.
Which car?
The Pontiac Sunfire.
Obviously.
The car seat in the back seat passenger of the car.
Yes. Okay. Can you tell us what you did with that piece of evidence?
That item was generally swabbed for the presence of blood, and that test was negative. So there was no blood identified on that item.
Okay. All right. I want to take you now to your next report, which is December 16th of 08.
Is that a long report?
No, I believe I'm just got a couple minutes and then we can take a break.
Okay, go ahead.
I'm aware we're close.
Sorry, can you state the date one more time on that
Yes,
report?
December 16th of 2008.
I have that report in front of me.
Okay. On page 2 of your report, were you given the profiles of Cindy, George, and Lee Anthony?
If I may refer to one other.
Yes, go ahead.
The question that you had asked was if I had been given the profiles from Cindy, George, and Lee Anthony.
I'm sorry, buccal swabs from them.
Correct. The buccal samples had been submitted to the laboratory under communication dated October 20th of 2008.
And you, and I'm referring to State's Evidence 113. Were you asked to conduct a paternity test for Lee Anthony as to Caylee, being the potential father of Caylee Anthony?
You may.
Okay, we're going to have a problem here. This.
$11:59. We're going to recess for lunch. I'm going to ask you not to discuss this case among yourselves nor with anyone else. Enjoy your lunch.
Okay, so we heard about this in opening statements, and this is the first time it's come up, apart from witness testimony prior that Casey had said there were some issues with both Lee and her father potentially abusing her or attempting to abuse her. But this is a whole separate thing as to Lee being the father or being tested to be the paternal father of Caylee. And so they're going to be outside the presence of the jury.
Seated.
Yep.
Okay, Mr. Ashton.
The objection, Your Honor, is that counsel has no good faith basis for asking this question. He is aware, fully aware from depositions that the FBI laboratory does not perform paternity testing, that they were never asked to perform a paternity test on this case. And in fact, well, I'll let counsel respond and deny either one of those things I just said.
What is your good faith basis for asking the question that you were asking? Just a second.
Two things. Yes, sir.
Just a second.
Sure.
Pardon? I was going to find it, but if you can find it quicker than I can.
Were you asked to conduct a paternity test for Lee Anthony as to Lee Anthony, the potential father of Caylee Anthony?
I have two very good faith reasons for asking that question. Number one, it was tested to see if Lee Anthony was the potential offspring, if Caylee Anthony was a potential offspring of Lee Anthony. And number two, I asked this witness last night. The FBI does not normally do that, and that's what she will testify to, that they don't normally do them, but they can do them, and they did. And as far as the statistical analysis portion, they would have to refer it out to a second laboratory. So that's exactly what the objections raised by Mr. Ashton are not true. The FBI in this case did do a paternity test, but he was excluded as the potential father. And end of story. I don't understand where, if it's in black and white in an actual report, how that's not a good faith basis. And I also mentioned this when we were at the break, the items of evidence. I would assume that Mr. Ashton, knowing that it says that in this report, and we identified the actual item, that it was an area I was going to inquire about.
May I ask the witness a question, Your Honor?
You may.
Were you ever asked to do a paternity test to determine if Lee Anthony was the father of Caylee Anthony by the state or by Orange County or by law enforcement?
If I may refer to my communication log for the conversation that I had with the special agent in charge before I answer that, to be clear.
Go right ahead.
You may.
Thank you. I have the conversation here noted, if I may read that to answer that question. On September 12th of 2008, I spoke with Special Agent Nick Savage. The inquiry about paternity testing / reports, I let him know we could run sample generate results, and send our report to a laboratory for the statistical component. In this, it's referring to the lab. It has been a lab that has assisted us in the past, and he agreed. They do not have the sample yet. That's
Does that in any way mention Lee Anthony?
no, sir. Not in that particular conversation, no, sir.
Your Honor, that is my objection. While counsel is correct that by looking at the DNA profiles that were run, Mr. Lee Anthony and George Anthony can both be excluded as potential fathers for Caylee. But to ask that question, suggesting that law enforcement specifically inquired, is not a good faith question. If he wants to bring out that, in fact, coincidentally, these test results exclude them as the father, that's fine. But to suggest by that question that that request was made by law enforcement, there is no good faith basis for that. And also, of course, it's hearsay. What a police officer may or may not have suspected or had a question about is not relevant in this case. And counsel has no good faith basis for believing that it is.
May I inquire as to the witness, if it's
You may.
necessary? Who did you understand they wanted you to compare the paternity test for?
Before I answer that question, there is one more entry that I wanted to read prior.
Go ahead, man.
Go ahead.
So on October 8th of 2008, I also had an additional conversation with Special Agent Savage. And within that conversation, he would like us, it is stated, he would like us to submit the brothers' results with Caylee and Casey to the UNT lab. A possibility of parentage is present in the results.
So it was your understanding that you were to determine if Lee Anthony was the father of Caylee?
The question had been posed if we could run the samples and generate a result and do a comparison. Specific to paternity testing, our laboratory does not perform. However, we could have made the determination as a possible biological offspring or excluded as a possible biological offspring, and had identified the laboratory that would perform the statistic component if that had been a possibility.
So you run the test if he's a potential, if he's potentially the father, it would be sent off to another lab for the statistical component.
For this particular discussion, that was what had been laid out for this particular, these samples.
And in your report, do you report out that that based on the SDR typing results, the DNA obtained from specimen Q18-1 Caylee Anthony could not have originated from a biological offspring of the individual represented by specimen K9 Lee Anthony?
Yes, that is stated in that report.
The objection then is, what is the relevance of what a particular FBI agent thought or a question that he had? What is the relevance of that other than to suggest to the jury that there's some information out there that this
He's getting mad.
jury has not heard?
Mad.
How is the good faith basis relevance of that?
I never asked that question, Judge. I'm going through her results like and through the work she's done in this case. That is part of the work she's done in this case.
That is not the question counsel asked, and he darn well knows it.
Oh,
If
boy.
he wants to ask this witness whether Mr. Lee Anthony is excluded as the father of
Oh,
Caylee,
boy.
that's fine. That's in the report. More power to him. But that wasn't the question he asked. That wasn't the implication he was trying to leave with this jury.
Anything else, folks?
Not really.
Let me say this. I don't know what was in your mind. I don't know what was in Mr. Ashton's mind. But you are not to ask questions that may lead to inference that unless you want to call a law enforcement officer to ask that he specifically asks to have something tested, you can get the results as Mr. Ashton has indicated. That's a proper question. I'm not going to even venture a guess or speculate on the motivations or whether or not your question even suggested that. I would do what I told both sides to do some time ago. There's a case called the Amante Banana Company. which is found at 466 7th 2nd, page 1167. Read it. It talks about good faith basis for asking questions. There's another case, Broxson versus State, which is found at 505 7th 2nd, 1361, out of the First District Court of Appeals. Please read those two cases for a good faith basis for asking questions. And that's all I'm going to say. Okay. If there are other exhibits you need to line up for afternoon witnesses, please let the clerks know so those exhibits may be pulled. We'll be in recess until 1:30. Yes.
I do have a motion to strike. I'd ask to strike counsel's last question and have the jury, when they return, be instructed to disregard the question.
Folks, I will look at the question, but all I'm going to say is this. I don't have a hearing problem. And the amplification of questions, objections, I don't need them. Okay? I can hear in normal voices. Okay. I will ask the court reporter to mark the last question. I will review it when I come back, and I will consider that. Okay, we'll be in recess to 1:30. You may be seated. Let the record reflect that the defendant is present along with counsel for the defendant, assistant state attorneys, both sides ready to proceed.
Yes, sir.
Okay. Now, do we know what your next question is going to be so we don't?
Well, that's the, I want to know, I don't want any issues, so I want to know how the court.
The last question you asked you asked the following question before we went to sidebar.
Mm-hmm.
Were you asked to conduct a paternity test for Lee Anthony as the Caylee Anthony, potential father of Caylee Anthony?
Yes, sir.
Okay.
That's what I believe she was asked to do. I don't know if.
And Mr. Ashton, your objection, sir.
The objection is it is not relevant whether anybody asked that question. The relevant is whether a test was done and what the results were. The question. So go ahead, sir.
One at a time.
My apologies, sir. That was my fault.
No, you go ahead.
I can rephrase.
Okay.
I can rephrase the question. Did you conduct a paternity test for Lee Anthony? I won't ask if she was asked.
Okay. All right. Since we're now all on the same page, let's return to jury. Okay, state recognized presence of jury. And the defense?
Yes, sir, we do.
Okay, members of the jury, did you heed all of my previous admonitions during the noon recess for lunch? Okay. Apologize for starting late, but we had elevator problems. All right, Mr. Baez, you may continue, sir.
Thank you, Your Honor. May it please the court. Mr. Ashton. Good afternoon, ladies and gentlemen. Good afternoon, Ms. Seubert. I'm sorry.
Good afternoon.
Where we left off, I wanted to ask you if you conducted what would be considered a paternity test to determine if Lee Anthony was the biological father of Caylee Anthony.
Can I have the date of that report one more time?
Sure.
That we're discussing?
That's December 16th, 2008.
And you said December 16th, 2008?
That's what I believe the date. Yes, that's the date I have. And I would be referring you to page 2 and 3, specifically 3 of your report.
I apologize. I had that report out earlier prior to the recess, and I'm just trying to find that one again. I apologize.
No problem.
I have the December 16th, 2008 report in front of me, and you're directing me to page 2.
I believe you start on page 2, but the results of your examination are on page 3.
This report I have dated December 16th, 2008 does not address the question that's.
I know you have 2 reports that. You might look at the other one.
Would it be okay if I looked at the report that you had in front of you?
May I approach the witness,
Oh,
Your
thank
Honor?
you, Your Honor.
Thank you.
Yes. Go ahead.
And can you read to the ladies and gentlemen of the jury, page 3, with your results?
Yes, on page 3, it states, based on the STR typing results, the dean, apologize. Based on the STR typing results, the DNA obtained from specimen Q18-1, Caylee Anthony, could not have originated from a biological offspring of the individual represented by specimen K9, Lee Anthony.
May I approach the witness?
You may.
Now, these types of tests are not done very often at the FBI laboratory, are they, ma'am?
Objection, relevance.
Relevancy?
Just explaining the evidence a bit more, Judge.
Sustained.
Okay, let's move on to that same report, which you don't have. May I approach the witness again, Your Honor?
You may.
I have found it now. Thank you.
Can you explain to the ladies and gentlemen of the jury what Q47 is? And just for the record, the defense and the state have entered into a stipulation to discuss these items without objection.
Does Q
Yeah, that's correct.
47 have a reference exhibit number?
It would be identified as, and we would stipulate that it is the car seat, which is shown in the photographs from the Pontiac Sunfire.
Okay, thank you.
Can you tell the jury about the car seat? What you did?
Yes, I can. Q47 was identified as a car seat from the 1998 Pontiac Sunfire. And that item of evidence was examined for the presence of blood, and the chemical testing performed was negative.
Did you do anything further beyond testing for blood?
On Q47, the car seat, no, I did not.
Okay. And Q48, can you tell the ladies and gentlemen of the jury what that is?
Q48 was identified as the steering wheel cover.
And what did you do with that item of evidence?
It's the steering wheel cover from the Pontiac Sunfire steering wheel. Just so the jury knows what we're talking about.
On that particular item, it was visually examined for the presence of any biological stains. And through the visual examination, there were no biological stains observed. So therefore, no chemical testing was conducted.
Okay. And Q55 and 56, can you identify what items they are and where they came from?
Yes, Q55 was identified as debris from the spare tire wheel well. And Q56 was identified as a swab from the spare tire wheel well.
Okay. And other than the other report that we covered that is dated the 16th, which deals with identifying Caylee, have we gone over all of your reports?
Yes, sir.
Okay. I have no further questions for this witness.
Cross-examination?
Okay, here we go. Cross time.
Good
Okay.
afternoon.
Hello.
I want to take some time and go through what these results mean or don't mean.
Okay.
Let's
the
begin
thing
with
is-
the Exhibit 15 in evidence, which is
So the thing is that, again, the reason this is kind of interesting is because, you know, they can't really discredit these witnesses because these are FBI agents that, you know, they're not, again, this is not defense hired witnesses. This is, so you don't really want to attack their credibility because they were involved in the investigation. So it'll be interesting to see here how Mr. Ashton handles it. We already had a couple spicy moments. Shout out to Black Witter. Happy you're popping in to say hi. And Mr. Ashton kind of losing his temper a little bit, getting kind of yelled at by the court. So yeah.
is identified as the swabbings from the spare tire cover. All right. You indicated that you did a phenolphthalein test on that, which is a presumptive test for blood.
That's correct.
What does the phenolphthalein test actually react to in blood?
It is actually reacting with the heme portion of the blood.
And when you say the heme portion, can you let us know what you mean by that?
Sure. It is part of the substance that's carried along on the red blood cell that we're actually looking for. And it's basically a test where it's an oxidation reduction test. I know it sounds kind of technical, but it's a test where the first chemical that's applied is going to react with the heme. And then once you add the second component, it actually oxidizes it, causing that color change if the heme portion is there and is present.
And is the heme portion only found in intact red blood cells?
Well, it could certainly, if you had some broken down red blood cells, if it's still attached there, you could have some residual that could be present. But as you start to break down the red blood cells, you're starting to then also break down the heme portion that's present.
So when a body decomposes, blood decomposes, the hemoglobin also decomposes.
That would be a correct assumption, yes.
Is this test in any way indicative of whether a certain substance is fluid of decomposition of a human body? Is it sensitive to that, other than if there's whole blood cells?
Not sure if I understand.
Let me rephrase it. That was a little sloppy. Would this test react to other substances in the body like fat?
if there was any type of presence of that heme portion from the blood that could be connected when you talk about where fat is deposited, it is possible.
Okay, but only if there's relatively intact red blood cells.
Correct.
But if the blood cells have decomposed, then it wouldn't react, or it's less likely to react.
Less likely.
Okay. I guess what I'm getting at is the particular stain that you tested has been identified as being decomposition fluid from
Objection, Judge. Assumes facts not in evidence.
Overruled.
has been identified as a stain from fluid from decomposition of a human body. Does your
Objection misstates the facts, Judge.
Overruled.
Does your test refute that?
Well, I can't speak to whether or not there was a blood or decomposition fluid present there because my test is negative. So I can't.
All we can say is your test did not detect whole blood cells.
It didn't react with any type of substance that was present there. Whole blood cells that maybe were, as we talked about, partially broken down. So I have nothing that would indicate that there was blood contained on those items.
But you indicated it could be decomposed fluid, including decomposed blood that might not react.
Well, the test.
It's the testimony of the witness.
Just
Witness never testified to such a thing.
Objection sustained. Rephrase your question.
I guess what I'm trying to figure out is, does your test indicate that the stain was not the fluid from a decomposing human body, in your opinion?
Based upon my testing results, it's negative, so I can't testify to anything other than the evidence that was there that I tested was negative for the presence of blood, which I can't state anything other than I didn't detect any biological material, blood, or other fluid based upon my results.
Could the stain still be decomposition fluid?
Overruled.
As far as if there were other biological fluids that could have been present in there, it's possible.
Okay.
But based on my test, I can't say anything other than it was negative.
All you can say is it wasn't blood.
He says.
Correct.
Okay, I've got that straightened out. Now, what happens to DNA when cells decompose?
Well, as cells decompose, the DNA is going to start to also be degraded. Because if you think about where the DNA is housed inside the nucleus of a cell, if the cells start to break down, eventually it's going to get to that center portion, the nucleus, which is also going to cause the DNA over time to also start to be diminished, losing the information that's present.
And in order for DNA testing to work, you have to have intact strands of DNA.
Right. With the 13 locations that I examine as a part of my analysis, if I have portions of those locations still present on the chromosome, I may be able to obtain a result.
But generally with decomposing cells, you don't generally expect to find DNA.
Sustained.
I'm sorry, Your Honor, I don't believe she answered that exact question. It is cross-examination, Judge, so I would ask for some leeway to get.
One more time.
If I get the court to read back the question.
But generally with decomposing cells, you don't generally expect to find DNA.
Right. As the body breaks down, that information that's housed in the nucleus of the cell is also going to start to break down. And so the likelihood of obtaining a DNA result does start to diminish as a body starts to decompose.
Now, I want to go to this chart. I don't think I need to step down. I think you remember when it was written. I want you to clarify for the jury what this
Classic. Every time.
result means.
Every time Mr. Baez uses
Yes,
one of these exhibits or demonstratives, Mr. Ashton always uses it after, but he never makes one on his own.
This result that counsel wrote on this chart is 50. Well, I guess 55 was the RFU. What does that really mean?
Okay, so the two numbers that are circled there, the 50 is what's referred to as the peak amplitude threshold, or the first level of detection for what's considered a peak in the FBI laboratory's DNA analysis unit, which is based on validation and testing to support what's a reliable result in the laboratory. So during the capillary electrophoresis process, when the DNA is injected into the capillary column, and the DNA strands are traveling through that capillary column, at the end, there is a laser. And those DNA strands have been tagged with a fluorescent tag, which enables then that laser to detect the signal of that DNA strand as it passes by. And that's the fluorescence that's then collected. And that's the end result, that DNA profile, based on how much fluorescent was detected at each of those locations, which is then generated into the peaks that we talked about at each of those locations. So at 50 RFUs, that's when the computer interprets if there's enough signal there to determine that a peak can be called. That's the first initial, it's seen, it'll flag it as a true peak. And that is based again on the parameters that we've set at our laboratory to determine it is a peak. The next level.
Let me stop you for a second, because you kind of answered. I wanted to ask you specifically about the 55 peak that Mr. Baez was asking you so much about. In the context of this evaluation of this evidence, what does that mean, if anything?
A peak at 55?
The one you talked about the amylogenic peak at 55.
So a peak at 55, depending on which location it's detected at, and in this case was discussed, it was at amylogenin. Again, there's a peak detected, but it's only a sole peak at amylogenin. And so based upon the information of that I collected from that, determined that it was inconclusive. I cannot give any information about what that peak exactly means.
The amylogenin is a specific chromosome. You're looking at the sex chromosomes, correct?
That's correct.
And this particular result you got is consistent with either being a male or a female. You just can't tell.
Well, the only part of that sex chromosome that's appearing is the X. There is no Y. And it is at a limited level. I felt it was more conservative to say it was inconclusive. There's just information about one peak there, but is it any information that I can give weight to? I couldn't state that, and therefore I said it was inconclusive.
Now, just so the jury doesn't misunderstand, does this mean that there is potentially an entire DNA profile there that could be enhanced with one of these other techniques that counsel was talking about?
Well, to perform low copy number, that would have to be the initial beginnings at the very start of the DNA analysis. So that would be an enhanced DNA process that at the time I was in casework was not being conducted. And so if you were to take that same sample and perform a low copy number technique on it, I don't know what type of result would be generated. I can't speak to that.
It would be complete speculation to say that this would mean anything.
Right, I don't know.
But even if this were enhanced to a readable portion, it would only tell you whether it was a male or female.
Again, I don't know. It's possible, but I don't know.
Okay, there was a discussion about a single result on the sticky side of the tape at a 17 loci. Is that correct?
At the locus D3, it was a 17 allele. Again, well below the threshold.
Well below the 200 threshold.
Correct.
All right. Was there one of the individuals that you tested to the laboratory who had contact with the tape?
Approach.
Yeah. Okay, ladies and gentlemen of the jury, I'm going to permit Mr. Baez to ask an additional question that will provide some type of clarity to the issue. You may proceed.
Thank you, sir. Ms. Seubert, we're talking now about the 17 marker, the 17 allele that is on the D3 marker on the sticky side of the duct tape.
Okay.
Okay. When you saw this, did you attempt to eliminate other individuals other than Casey and Caylee Anthony?
Yes.
Okay. And what did you do to attempt to do that?
The same process that I did with the top side of this tape, I would have done with the underside of the tape, where I would have compared that type at that one location to all of the reference samples from the laboratory personnel, in addition to the known samples that had been submitted as part of the case that I mentioned previously.
Okay. And this is a little different because you only had one marker, correct?
That's correct.
Whereas with the other one, you had 6? You're just clarifying it all up, Judge.
Let's get to the point. Objection overruled at this point.
You can answer the question.
Correct. On the top side of the tape, there were results at 6 of the loci or locations or markers. On the underside of the tape, as far as the locations for the STRs, there was a peak, as Mr. Baez has pointed out, a 17 that was present at the D3 locus.
And how many people did you go through? How many people did you look at to see if they had a 17?
I went through the 5 known samples that were submitted as a part of the case, or the profile that was generated for Caylee Anthony, the known sample for Casey Anthony, the known sample for Cindy Anthony, George Anthony, and Lee Anthony. And then I compared it to the known reference samples that were from the laboratory staff. And there were a total of 5 individuals from which I collected a sample from, and DNA profile was generated for them.
And did you find someone that could not be excluded?
Again, based upon the report language that I utilized, I did not draw any conclusions to the information at that location. Based on my report, it says that that information was inconclusive and was not utilized for comparison purposes.
So if I understand you correctly, it doesn't meet your threshold to either include or exclude anyone.
It was very limited, so I didn't feel that it was suitable for that comparison, to report out a comparison in my report.
Was there another individual that had a 17 at the D3 marker that you looked at?
There was an individual, as a part of their DNA makeup at that particular locus, the D3, they did have one of their alleles was a 17.
Okay, what did that person have at the D3? What were their?
The DNA makeup at that particular location for that individual was a 16-17.
However, you didn't see any 16 at the D3 local from the duct tape, did you?
This goes beyond what the court allowed me to be interrupted for.
I don't believe so. This is clearing up the issue, Judge. This is what I would have done under direct.
You may continue.
There was, what was on the duct tape, there was no 16, correct?
The peak that there was just the 17 that was at the level of detection for a peak.
So just so the ladies and gentlemen of the jury can understand, this could be 2 things. A person can have 2 alleles, or a person can have 1 peak, like you had described earlier, correct?
Correct. You're either a heterozygote or a homozygote. Heterozygote having 2 peaks, like you referenced, or a homozygote just having the 1 peak.
Okay. The person that is a lab personnel is a heterozygote, meaning they have 2 peaks.
That is correct.
But all you found was 1 peak.
1 peak that was reported, correct.
Now, because it's so low, you can't make a determination at all as to either way, correct?
That's correct. As I stated, it was inconclusive for reporting purposes.
But what you can definitely say is that there is no 16 at the D3 marker for that peak.
Using the thresholds that we've discussed about from the FBI laboratory, that is correct.
I have no further questions.
Okay, Mr. Ashton, you may continue.
The reality of it is that this peak really means nothing. It's inconclusive. It really shouldn't be taken to mean anything. Isn't that really the reality of this?
And that is the result that I provided in my report, that it was the results for that were inconclusive.
And the reason for that is because at those low thresholds, you can drop out alleles. In other words, you can have someone with a 16, 17, but the 16 is so low it doesn't appear.
That's correct, referring to stochastic effect, where you have alleles that may be there at one amplification, and you may not get the same result at the next amplification because it is such a low level of DNA.
And that's why the scientifically responsible attitude toward this is simply, it's inconclusive, it doesn't mean anything.
That's correct.
But if it meant anything, it's not the DNA of George Anthony, correct?
At that particular location, Mr. Anthony did not have a 17.
All right. Okay. Now,
Mr. Ashton, may I ask one question?
sure.
Would that be okay, Judge?
Yeah.
I just want to be clear, the DNA types that we did talk about earlier about the same tape for Caylee Anthony and Casey Anthony, I just wanted to be clear on the types. I think I may have misspoke with
Sure.
the types that were at D3, so I just wanted to be sure the jury was clear on the types that were present, if that would be appropriate.
Right.
Right ahead.
Caylee Anthony at D3 is a 14-15, and Casey Anthony is a 15-19. And I think I had referred to them both being a 14-15, and I apologize for that.
Now, let's see, we've talked about the, Mr. Baez spent a great deal of time asking you about blood. You test for blood on items of evidence for the possibility that blood was shed during some event, correct?
Correct. That's one of the forensic examinations that's performed in the laboratory.
Testified to, she testified that she tests for blood.
Oh,
It's one of the examinations to examine items of evidence for biological fluids, and blood being one of them. I cannot speak to possibly how the nature of the substance would get on the item. I'm just looking for it to detect if there is any biological fluid present.
For instance, if someone is shot, there may be blood spattered or bleeding from a wound, something like that.
That's correct.
Or if someone is stabbed, there can be blood, again, gushing from a wound that might be on a piece of evidence.
Sure, that's correct.
If someone is killed in a manner that does not shed blood,
This is what I mentioned earlier.
the absence of blood doesn't indicate the absence of the crime. Wouldn't you agree?
Objection, Judge, calls for
Yes,
speculation and outside this witness's
Yep,
area of expertise.
Definitely.
overrule.
But of course, he's going to overrule it.
I'm sorry to
Sure.
make you, could you repeat it one more time?
That's okay.
Oh, boy.
I'm just talking about the significance of the lack of blood on a particular crime scene. If
thing
a
is,
method is used to
ignoring the
kill
fact that there was
someone
blood on the
that
laundry
doesn't involve
room.
bloodshed, then the absence of blood doesn't really say it didn't happen, correct? I mean,
Correct. I couldn't, yeah, correct. I couldn't speak to whether or not it happened or not.
Okay.
Her job is not to determine.
Now, let's see, we've talked about the items from the trunk. Oh, the tape. Were you involved in any way in the discussions about the order of examination of the tape? In other words, what should come first, second, third, those kind of things?
No, sir.
Okay. It's true, is it not, that you, based upon the history you were given of this tape, would not have expected to find any DNA from the victim on the tape? That's correct, isn't it?
If I may answer without yes or no. The expectation would have been on the sticky side of the tape if it had been in fact across the face of the victim. That would be the possible area where I would expect to find DNA, but
Wait.
again,
Let me back up.
with the
Hear that,
information about where the exposure and length of time,
Hold
I
on.
didn't expect that there would
That was
possibly,
an important answer.
of the victim. That would be the possible area.
Pausing it real quick. That was important. Listen to what she says about if it had been on the face. Listen. That is crucial.
The order of examination of the tape, in other words, what should come first, second, third, those kind of things?
No, sir.
Okay. It's true, is it not, that you, based upon the history you were given of this tape, would not have expected to find any DNA from the victim on the tape? That's correct, isn't it?
If I may answer without yes or no. The expectation would have been on the sticky side of the tape if it had been in fact across the face of the victim. That would.
Well, I hope the jury heard that. I mean, I'm sure they did. Because, wow, that is huge right there. I mean, that goes without saying, like, that's common sense, right? But the way that she said, if it had been in fact on the face of the victim. Wow.
Would be the possible area where I would expect to find DNA, but again, with the information about where the exposure and length of time, I didn't expect that there would possibly, the expectation was neither here nor there. It was a test that was performed, but if there was going to be DNA, the expectation would be that it'd be on the underside where cells would be collected on.
But for DNA to survive on an object in a swampy area for 6 months would be unlikely in your experience. Isn't that correct?
The other, yeah, here's the thing.
Your Honor, I believe we have expert testimony.
Here's the thing. No. We have taken a field trip to that area. They have entered a lot of pictures. It is not, to call it swampy is not accurate. It's a wooded area. It's not swampy. It's not a swamp. It's a wooded area. It's grass. You can walk on it. You're not in water. To call it swampy is completely misstating or misrepresenting the evidence entirely. Ugh.
May I argue the bench? Because
you shouldn't have to do that. If you're the state, you should be able to use the actual facts. They've been doing this over and over.
You may proceed.
Jesus Christ.
Let me just ask you, how was the area where the remains in the tape were found described to you?
It was described in an electronic communication as being an area that would have water coming into it in a swampy type area.
Oh, okay.
Now,
well, I think that was misrepresented to her then.
What would happen to any DNA on the tape under those conditions in Florida in the heat?
A great
for 6 months?
example.
If water was coming in.
Great example of where we can see it is because, a lot of those photos we didn't see, rightfully so, of the remains and whatnot. But in terms of a better example where you can actually see what that area looked like, if you guys remember back to when one of the forensic anthropologists testified. And I made a joke about it because he called it the tarp thing or whatever. And he was referring to the tent that they put up whenever they do this. Anyway, on the recap, I'll pull that image up because you can see really well all the investigators out there, and you can see the area, you can see the tent, and they're out there on their hands and knees, sifting through bones and what dirt and whatever, but you can see it. And they're not in water. It's not a swamp. So that was misrepresented to her, whoever called it that.
And receding out and drying and humidity, it is probable that if there were cells contained on there, that the cells could start to degrade over time, and the DNA that would be contained in there would also start to be diminished and to degrade.
Okay, thank you. And would that same answer apply also to things such as the shorts or the other clothing items that you were asked to examine from the same scene?
Yes, sir.
Now, in this case, Mr. Baez asked you about something he called a paternity test. The FBI doesn't actually do paternity testing, does it?
No, sir.
In testing the known samples you were given from Cindy, George, Lee, Casey, is it possible, and eventually from Caylee, correct?
Yes, sir.
And just so we're clear, the sample from Caylee was the marrow from one of her bones. That's what you ultimately tested.
Beyond the scope of direct.
Overruled.
Is that correct?
There were 2 samples that were processed for the identity of Caylee Anthony. One was initially a toothbrush, and then the tibia was submitted, which was ultimately the powder from that tibia was utilized to process and generate a DNA profile.
All right. And Mr. Baez asked you about a quote unquote paternity test. What you actually did was look at an existing profile of Lee Anthony, the profile you got of Caylee, and make a determination as to whether he could be the father, correct?
Right. I generated the DNA type from Mr. Lee Anthony and using Casey Anthony's DNA type, taking the 2 of their DNA profiles and comparing that to Caylee Anthony to determine if there were alleles present that would suggest those 2 individuals.
And there weren't.
That's correct.
So to summarize all of the testing that we've discussed here, the stain that was in the trunk of the car, all you know is it's not blood.
That's correct.
You can't tell anything other than that.
That's correct. I did not generate a DNA profile either. That's correct.
And the only DNA on anything from the scene is explainable by DNA from lab personnel. Would that be a fair statement?
Misstates the facts and evidence.
Overruled.
From the outdoor crime scene, in addition to identifying Caylee, the only DNA profile that was generated from the outdoor scene was that of a laboratory staff member.
No further questions?
Redirect.
You testified, Ms. Seubert, about decomposition in the trunk and talked about as cells break down, there's no longer an ability to get DNA, correct?
It diminishes over the time period. That's correct.
And that's what I want to ask you about. You can't testify as to at what point during the decompositional phase that you would not be able to get DNA, can you? Except the later stages.
There's many, it's hard yes or no answer, Your Honor.
Answer.
Just explain it away.
Okay.
Go ahead.
So, well, it depends on what exactly, when you talk about obtaining a DNA profile, you're trying to do. Are you attempting to generate a known DNA profile for the identity of that individual, utilizing a bone, utilizing a tooth? Those are the types of body parts that will remain, the skin, the tissue, the blood, and that over time will start to decompose and start to disappear. But the more hardy, for lack of a better word, the hardy areas in the body will remain. But as the body decomposes, all of those tissues, cells, and fluids that are contained within us will start to degrade, and the ability to generate DNA from the collection of those types of cells and bodily fluids diminishes.
And that happens at the latter part of decomposition, does it not?
Objection, leading.
Sustained, rephrase the question.
Yes, sir. Does that happen at the latter part of decomposition?
Objection, leading.
Overruled.
When you ask the question at a latter part of decomposition, are we talking you know, what is the environment for that decomposition that's happening? Is it in a hot environment? Is it a cold environment? Because all of those factors are going to play a part in how the body breaks down.
Right.
And so in order for me to give a scientifically based answer as to where is the period in time that I can no longer generate a result, I can't give you that answer.
You can't say.
I cannot say.
However, what you can say is that you did not get DNA or blood from the trunk of that car, correct?
That's correct.
And is it your understanding that in the early stages of decomposition, there is blood?
If you think about what's running through our bodies, there's the circulatory system comprised of blood. And so as a body starts to decompose, those fluids are going to start to leak out from the body. So the possibility would exist.
And there's also a possibility that blood would leak onto a carpet of a trunk liner.
Objection beyond the scope of her expertise.
I think the witness.
Just a second.
Yes, sir.
Ma'am, can you answer that question within the scope of your expertise?
Yes, sir.
Can you be permitted to answer?
Go ahead.
Well, within the confinement of a trunk, if a body is placed there and it's slowly going to decompose, all of those fluids are going to start to dissipate into that carpet or the trunk liner if that is contained within the trunk and the body is just placed there and not contained with any type of protective material. You know, it would just be placed there as such.
And if it is contained in a plastic bag and there is a hole in the plastic bag in the front where you tie it up, could it leak out of that area? Is it possible?
Sure, it's possible.
Okay. Now, I think I just have one. The summary that you gave on the as to the items recovered at the scene, you could only testify to the contamination aspect of the potential contamination of the lab person on the non-sticky side, correct? Of the duct tape?
Objection leading.
Sustain, rephrase your question.
When you gave that answer, you were considering what is reportable through your protocols, right?
Objection leading.
Sustain.
Okay. Were you taking, look, let me ask you this way. As you were giving the answer to Mr. Ashton in reference to what you were able to get out of the scene, did you take into consideration your protocols? What your reporting protocols are?
When I gave the answer to Mr. Ashton, I was giving that based upon what I issued in my FBI laboratory report.
And that's based on the protocols that you're allowed to report out?
It's based on the standard operating procedure of the laboratory, correct?
And the 17 allele that you can't make any conclusions on, you did not take that into consideration when you issued your report on that?
Well, as discussed, that information for that portion of the tape, could not provide a conclusion to. It was inconclusive. And so in my answer to Mr. Ashton, I was considering what I issued in my laboratory report, and that was a part of it.
And when you discussed about the elements, the outdoor elements, did you consider let me rephrase that. When we were discussing the outside elements and the potential of being able to find DNA, you did say that the expectation, if duct tape were placed around someone's mouth and there was if duct tape was placed around someone's mouth, you would more so expect to find that DNA on that portion than the non-sticky side. Right?
Sustain.
Would you expect to find more DNA on
the sticky side or the non-sticky side?
My expectation would be that if there was DNA recovered, it would be more probable or more likely to be on the sticky side.
Thank you, ma'am.
Just one quick question. When fluids leave the body, they continue to decompose, don't they?
Yes, sir.
So even blood that is spilled on the surface, if it's hot or wet, it'll continue to decompose.
Yes, sir.
Thank you.
Oh, didn't even get to change the banner. That
Will
was
the witness be excused?
Yes.
Thank you, ma'am. You may be excused.
Robin Maynard, Maynard.
You may proceed.
Thank you, Your Honor. Ms. Maynard, how are you employed?
I'm the founder and executive director of Libby's Legacy Breast.
So we are back to another witness who testified for the state, and I don't remember if she's FBI. I think she is FBI. She's either FBI or Orange County Sheriff's. We'll hear. But again, so far they're only calling these witnesses who are part of the government, helped the state build their case. They're not calling any witnesses that are working for them. These are all, it just says a lot, doesn't it? Right? Like when they don't even need to bring in people to be like, you guys did everything wrong. Like they're bringing in the state's own witnesses, law enforcement, all of them so far. So I think that is a huge, so rare that you see that, right? So let me just update my ticker here. Let's see. So Robin Maynard. Okay, cool.
Cancer Foundation.
And back in 2008, how were you so employed?
I was a crime scene investigator with the Orange County Sheriff's Office.
Okay. And you were the person that actually collected an item of evidence,
The heart sticker?
313 in this.
Yep. 313. There it is. 313. For anyone, I don't know if they're going to show it. So let me pull this up real quick. So everyone, in case anyone didn't see what exhibit 313 is, let me pull this up. This is a huge deal. So, okay, just 1 second. And I will share this to you guys so we can all know. So it is this. Okay, so exhibit 313 is this, where my hand is, or well, the computer's hand. That's exhibit 313. That's the exhibit that the state tried to hide from the jury. That is looks like a kid's press-on earring. That is what was found at the crime scene. It came stuck on or attached to this piece of cardboard. It was about 10 feet away from the remains. Okay, this is what they're going to be talking about, because I don't know that they're going to pull it back up again. They may or may not, but just in case, just for the reference, so everybody knows. So now let me pull that back up. Okay. Okay, cool.
State's evidence 313. May I show you a photograph of it?
Oh, well, there it is. Well,
Your Honor, may I approach the witness?
Yes.
he's going to show her. I think that's the same outfit
Recognize that item, ma'am?
the other day.
I do.
Okay. Can you tell the ladies and
Same
gentlemen of the
outfit.
jury
Pretty sure
what
it's
that
the same
item is?
outfit, same shirt.
It is a cardboard mat with a pink heart-shaped raised material.
Yep.
May I publish a copy of that to the jury as well?
You may. Number what?
313.
All right.
Oh, wow.
Photograph.
Oh,
Photograph.
The photo.
No objection. The actual item is, but that photograph needs to get a separate number.
I think the photograph does have.
back. Okay.
I think the
That photograph needs.
Number what?
313.
Go back.
All right.
So this is actually really helpful because now we can get an idea for the size. So I'm glad we took a look at it up close because you can't really tell that it's raised in this picture, but you could in the close-up. But here there's a scale. So if you look at the cardboard, although I feel like they have a discussion about this where they say it's not to scale. That's really funny how on the label they drew a heart instead of wrote heart. They drew a heart. Okay, let's just see what they say.
Photograph.
Oh, the photo.
I have no objection. The actual item is, but that photograph needs to get a separate number.
Yeah,
I think the photograph does have a
on
separate
earring.
number.
Definitely. That's what that looks like. I added a ton of the, like, let me see if I can find an example for you guys, for anyone who's not familiar.
That's exhibit W.
Okay.
No objection to its introduction.
You want to introduce it?
Yes, sir.
Okay, it'll be introduced. It's defense numbered.
Ma'am, when you collect an item of evidence like that, what do you do to record where you found it and a description of it?
I was in charge of the sifting operations, and that's quite different than how we would normally collect something because they're coming in, items were coming to the sifting stations in buckets. So for example, a map couldn't be made in the primary search area of items I found because we only had a baseline measurement. So as buckets would come to the sifting stations, they would have the searcher's initials, the lane number, and the coordinates for where that item was. We would sift, and when an item of evidentiary value or items to be collected were collected, I would photograph the item, note on the bucket where it came from, which would indicate to me lane, coordinate, and tell me how many feet that was.
Okay. And what lane was this found in?
This item appears to be from lane 6.
Okay. And how many feet from the baseline was it?
I have here in my marker that it was 45 feet west of the baseline.
Your Honor, I'd like to publish Defense Exhibit AT and introduce this with conditions from the state, and I have stipulated that it is not to scale. Is that correct? That it is not to scale, but it's still open.
What says the state?
No objection with that stipulation.
Okay, you will be received in evidence as. You wish to publish?
Yes, I do, Judge. I apologize. My apologies. Was everyone, did the jury see the last photograph?
No.
That's my fault, Your Honor. Can I publish?
Put the
that
last
first?
one back up. Which is what?
This is 16, Defense 16.
Okay.
W.
I think this thing is breathing.
Y'all, I'm trying to find the exact press-on earring, if you can believe it. I think I might even be able to.
Okay. Now, can you indicate to the ladies and gentlemen of the jury where you indicate that it's lane 6, 45 feet from the baseline? Okay. Can everyone see that? Okay. Okay. Now, at this time, Your Honor, I'd like to publish Defense Exhibit AT, which will be admitted into evidence as Defense 17.
You may.
Can you show the ladies and gentlemen of the jury where lane 6 is? And can you show the ladies and gentlemen of the jury? Let me clear this out.
I wonder if anyone else has identified that as a press-on earring or a stick-on earring. I wonder if anyone else made that connection. Because, like, not every kid would wear
Where 45 feet from the baseline would be.
But I definitely had those.
And lane 6.
I had those
And
on earrings.
taking into consideration this is not to scale, where are the areas where the bones were found?
The areas where bones were found in the sifting, there are other items that are not here. The bones that were found through sifting only, this is not in the primary search area, are indicated in a general way where it says bone location. It can't be exact because it came from a bucket that was sifted in a general area that was specific to about 5 to 10 feet.
And that's what's indicated in the white dots?
Correct.
Okay. And is it fair to say that this is just a general, you're not pointing one bone was found at each dot, correct?
No, those are each bones. I believe there were 13 bones that were found in sifting. And so based on the lane coordinates, I did a general map when bones were found, and I would collect them where they were located based on the coordinates on the bucket.
Do you know if any bones were found in this area here?
I believe there was a bone found in lane 6, and I'm not certain how many feet west of the baseline that it was.
Okay. I have no further questions for this witness, Judge.
Cross-examinations.
No questions on cross, Your Honor.
No questions on cross.
May the witness be excused.
Yes, sir.
Thank you, ma'am. You may be excused.
Thank you.
It's Ronald Murdoch, M-U-R-D-O-C-K.
We're back to another witness we've seen
Thank you.
already before,
Thank you, Your
law
Honor.
enforcement.
Mr. Murdoch, how are you so employed?
I work for the Orange County Sheriff's Office as a supervisor in the forensics unit.
I'm going to ask, you had previously demonstrated that you had drawn up a mapping system through a map through a.
Here, what they're doing with this witness and the previous witness is showing how far away, the sticker and the cardboard and I think, also the two other pieces of duct tape that were stuck together, how far away they were from the remains. Yeah.
Software system. Can you open that up and because I'm going to ask you to demonstrate something if you can.
Yes. Would you like me to hook it up as well?
Yes, please.
Hook this stuff up. Let me think here.
Okay. Yes. Yes, sir.
Can you draw I realize you don't have the exact spot to where the heart shape sticker on the cardboard that was attached was found, but from lane 6, 45 feet from the baseline, can you tell us how far that is from area A where the skull was found?
So 45 feet from the baseline?
Yes. Lane 6. Okay, can we publish, Your Honor, to the jury?
No. I mean, I plug it all in the back?
Yeah.
Yes, sir.
Well, it's not up on the screen.
There we go.
Okay. You
Okay.
wanted to publish, right?
Yes, sir.
Can you see it, members of the jury? Okay.
And how far is the distance from the skull area to where 45 feet from the baseline lane 6 is?
It's approximately 30 feet. Again, that's basing that upon the middle of lane 6 and the approximation of the area in which that was taken, that heart-shaped sticker and that piece of cardboard.
Okay. And how far would you say Q63 and 64, the two pieces of duct tape, were away from the skull area? You don't have a measurement like that, or would you say?
Are those the two items that were on the diagram as duct tapes 2 and 3?
Correct.
Okay. I can bring those up if.
I object, that's inaccurate.
Are you? So the best that you can give as far as an estimate as to where the sticker found was compared to where the skull was found is 30 feet away?
Yes.
Okay. Can I have you, for the record, mark and give an indication of an X on state's evidence 279? May I approach?
No,
Right.
no.
There.
And what is it that you want me to mark, this location?
Yes.
Okay.
Okay. I have no further questions for the witness, Judge.
No cross.
May the witness be excused.
Yes, sir.
Thank you, sir. Please retrieve the exhibit.
My name is Jennifer Welch, W-E-L-C-H.
Your Honor, prior to this witness testifying, both the defense and the state have entered into a stipulation as to defense exhibit AS, AR, AQ, AP, AO, AN, AM, and AL.
I'm pausing it real quick to show you guys something. So let me just show you this real quick here. So for anyone who's not familiar with like these press-on earrings, let me pull my banner down, or stick-on earrings, as it were. You know, I had these as a kid. This is a good example. I'm trying to find the exact one, but you know, this was from 2008. So, but this is a good example. So like this, and Claire's is a good bet for wherever this came from. So when you look at like, oh my God, when you look at like, not that one, but like these ones, I would say probably it was more, I don't know, maybe more of that pinkish color. But if you see, so these are press-on earrings or stick-on earrings or whatever, okay? And this is like, I think exactly what they found. There's a bunch of different varieties of these. There's like, you know, I was trying to find the exact one, although it's kind of hard, but there we go from like a zoomed out version. Let me pull up on that one a little bit. So there's different sizes, but yeah, they're like jeweled glitter, you know, 3D press-on earrings. I think that's exactly what they found. So anyway, I just wanted to show for anyone who's not familiar with what that is. They're like, and there's a bunch of different kinds, but you know, the pink and purple hearts are really super common. And yeah, so there you go. There's an example. So now we'll go back to Jennifer Welch for the bazillionth time on the stand. This time called by the defense. Oh, sorry. Somehow I stopped sharing this to you guys. Hold on. Let me pull that back up. Sorry. Here we go. We're back.
As defense exhibits.
AS will become defense exhibit number 18. AR will become defense exhibit number 19.
Jennifer Welch has testified a bunch, even more than George.
AP will become defense exhibit
You might actually have the prize for testifying.
AO will become defense exhibit number 22. AN will become defense exhibit.
Oh, she's witness number.
AM will become defense exhibit number 24, and AL will become defense exhibit number 25.
Good afternoon, Ms. Welch.
Good afternoon.
You were in charge of documenting the scene off Suburban Drive, were you not?
Yes, I was.
And were there a large number of items that appeared to be disposable waste in that area?
Yes, there were.
Okay. Summed it up, without getting too technical, would you consider it trash?
Yes, some of them were.
Okay. And were a lot of these items collected?
Yes.
Okay. I believe you testified previously that there were over 300 items collected?
Yes.
And did there ever reach a point where you just stopped collecting trash?
I recall there were some large items, but I don't recall at what point that was.
Okay. Now, are you familiar with the different lanes and the setup as far as the measurements from the baseline?
Yes.
Can you tell me if there were any bones found past lane 6, 45 feet from the baseline?
May I refer to my documentation?
Absolutely.
I'm having to refer to a printed diagram, and in referring to that, there does not appear to be any bones collected past that location you stated.
And I'd like to show you some photographs with the court's permission of different items of trash and see if you would characterize this as some of the items that were collected.
Okay.
May I publish, Your Honor?
Yes, please refer to them by the exhibit.
Yes, sir. Defense Exhibit AM.
Okay, this is interesting.
Have they been remarked?
So
Okay.
while they're remarking them. So far,
Head them to the clerk so she can remark.
they're remarking them. It'll take a second. Okay. So far, we've heard a good bit about how there was different trash at the crime scene. Now that has always come up from the defense, not the state. And so the state has like kind of left that out, but they've been asking everybody, you know, who was there, like there was other items of trash, but we don't have any idea like how much trash or what the trash was, which, you know, in my mind, I figured it was 1 or 2 pieces of trash, right? Something like that, that wasn't significant. We're about to, for the first time, see what all trash was there. And it's pretty surprising, I will say, that this, well, a couple things are surprising. There you go.
Appear to be.
Okay. So first of all, that the state left all this out, right? It's a lot of trash. And second of all, I don't know that any of it was tested, and that's what we're going to find out here.
I'm showing you Defense Evidence 24. Does that appear to be?
It's a lot. And
generally
this is not all of it, by the way. It's a lot of trash.
What was collected?
And I think, okay, I just want to say real quick. This is, just like I said before with the other witness, you know, oftentimes we'll see defense attorneys bringing in stuff like this, try to show sloppy investigation. Blah, blah. That's not their goal here. Mr. Baez's goal, I think, is a couple things. I think it's to show, one, how close the crime scene location was to the road, because that's how the trash, you know, people threw shit out of their car, right? But two, I think it's to show how plausible that, you know, I don't think the duct tape would be in that category because that is too specific and that connects to George. But again, I think what they're doing is they're making a distinction with those lanes. They're making a distinction between with the duct tape, the Henkel duct tape being found, like, what was it, like 7 feet away or whatever, right? But that the cardboard with the sticker was like 10 feet away. And that when, in other words, when the investigators connected, like the fact that they connected the cardboard with the sticker and connected that to the crime scene, but they didn't connect all this trash to the crime scene, is like, shows that A, the heart-shaped sticker and on the cardboard really didn't have anything to do with it, in the defense's opinion, I think is what they're showing. Because again, it was 10 feet away and it had no connection to anything with Casey or Caylee or anything, right? But also it kind of shows that they cherry picked. They saw that and they included it. And why would they do that? Because of that ghost phantom heart-shaped outline thing, you know, but yet they didn't take any of this and include it into the crime scene, right? But it also, again, points to just so the jury understands how likely and possible it is that there's just other trash around that can be from other things, right? It's not like this is so remote where anything that, because there are cases like that, right? Where there's a crime scene that's so remote that anything that's found with the body is probably related, right? And that's not the case here. It was so close to the road. It had been traveled by. Search parties had been there, somehow missed the body. We'll get into that with Roy Kronk, I'm sure. And again, just as you can see, right? Yeah, hopefully that makes sense.
Through the sifting area off Suburban Drive.
I don't recall this being found through sifting, but I recall it being found through searching and clearing of the vegetation.
Okay. Were any of these items submitted
to
the lab for further testing?
Not that I can recall.
Okay.
Which is odd, right? Because the thing is like, again, it's odd that they didn't submit that stuff, but they submitted the cardboard with the sticker. When it's like, they really have no way to know that stuff wasn't involved. Again, it's just because they were only taking in what they were looking for that they thought could connect to Caylee. I mean, having said that, whether it was Caylee or anybody else or whatever, whoever, right? There could have been something substantial or helpful on any of that, and they didn't test it. So again, well, I don't think that the defense is trying to make the point that it was sloppy or whatever. I think it's more so trying to make the point that it was just so tunnel visioned. Well, I think that's again secondary to just the suggestion that it's clear that the cardboard with the sticker isn't that weird, right? But it's just me making the point, I guess, that they could have missed an opportunity, right? But we'll never know. But that's me making that point, not him. Look at all that evidence. Look at all the evidence.
I'm now showing you defense 25. Does this also appear to be certain items that were collected?
Yes.
Okay. And do you know if any of these items were sent to the lab for further testing?
Not that I recall.
Actually, let me stop you there.
Is that on the
Can you identify?
I didn't even get to mention this. On that first picture, there was a black trash bag. It's weird that they did not include that when we all know the black trash bag. Anyway, it just seems crazy, right?
By what lane this was in based on the photograph?
Yes. As can be seen in the photograph on a card that I had written, these are miscellaneous items collected from lane 4.
Okay. And I'm now going to show you Exhibit 23. And does this look like items that were collected?
Yes, it does.
And were any of these items sent to the lab for further testing?
Not that I recall.
And what lane did these come from?
Crazy.
As indicated in the photograph on the card, they are miscellaneous items collected from lane 1.
Yeah, it's not. Even though they're not making the argument needs to be made that it should have been done. It should have been sent in for testing. There's just no question about that. You have to.
And so put it in perspective, I'm going to show you Defense Exhibit 17 again. Would lane 1 be this area here, this lane?
Yes, as indicated on that diagram, yes.
Okay.
This is really smart, how he got Ronald Murdoch to come in and get this whole thing, the computer, into evidence or whatever, because now there's a reference point when they go through all these items of trash and anything else. Now he can use this exhibit. It was really
And
smart.
lane 4 would also.
By the way, the white squares there, just in case it's hard, it's kind of blurry. Those are where the bones were found. The lanes are hard to see how they're. Oh, okay. When he says lane, it's hard to see because it's like black on black. I don't know why. So lane 1, if you guys can see my mouse, can you guys see my mouse? Is right here. God, why did they not make it a different color? That is ridiculous. So lane 1, lane 2, lane 3, lane 4, and then these are where the bones were found.
Be indicated there in that diagram.
Black on black.
Yes, it would.
Are you kidding me?
I'm going to show you now Defense Exhibit 21. Were these items collected?
Yes, they were.
And were any of these items sent to the lab?
Not that I recall.
And what lane were they found off of?
As indicated in the photograph on the card, they're miscellaneous items found in lane 3.
And could you just point really quick on the prompter where lane 3 is?
Yes.
Yeah. So do you see why this is a problem? Because in other words, what he's showing is how close these pieces of trash were. Or I mean, they're in the same lane. They're in the same lane as the bones. And I'm pretty sure that's why they make these lanes, is so that anything that's in the lane is collected. So, I mean, this is insanity, right? I mean, she's trying to highlight, we all know the telestrator thing acts up. We've heard about them joke about that. But yeah, so lane 3, it's in the same lane as a bone or more than one bone, whatever.
I'm now showing you Defense Exhibit 20. Were these items collected? Let me turn it upside down. And were any of these items sent to the laboratory?
Not that I can recall.
And what lane were these collected from?
As indicated in the photograph on the card, they are miscellaneous items from lane 3.
Can you indicate briefly where that is? I'm now showing you Defense Exhibit 19. Do these appear to be items that were collected?
Yes.
And can you make out what lane those were found at?
Not in this photograph.
Neither can I, so I'll move that out. And now I'm going to show you Defense Exhibit 18. Were these items collected?
Yes, they were.
And were any of these items sent to the lab for analysis?
Not that I recall.
And where does it say this was found?
Interesting.
I can't quite read it in the photograph.
Let's see if I can zoom in a little bit. Can you make that out now?
Yes.
Okay, where was that collected?
According to the card in the photograph, as indicated here, they're miscellaneous items from the clearing area east of the wooden fence.
Okay, and where just generally would that be located? From here, if you can just point in the general direction.
Yes, the general direction of the wooden fence would be along this side. I don't recall exactly what lanes it would have matched up with.
Okay. I have no further questions for this witness, Judge.
Cross-examination.
Just one question. Investigator Welch, would it be fair to characterize the area where Caylee Marie Anthony's remains were discarded as a trash dump?
Yes, that's what I would classify it as.
Thank you.
Huh? Why are people dumping trash?
May the witness be excused.
Odd.
Yes.
Thank you, Investigator Welch. You may be excused, ma'am.
Thank you.
My name is Lori Gottesman. That's spelled Lorie. Last name is Gottesman.
And how are you employed, ma'am?
I'm employed at the Federal Bureau of Investigation, Laboratory Division.
Okay. And what is your occupation at the FBI laboratory?
Okay, this is
I'm the Supervisory Forensic Document Examiner.
question documents.
And how long have you been employed there?
I've been employed at the Federal Bureau of Investigation since 1992, just shy of 20 years.
And can you please share with the ladies and gentlemen of the jury your educational background?
Yes, I received a Bachelor of Arts degree in psychology from the George Washington University in Washington, D.C., and a Master of Science in Forensic Science from National University in San Diego, California.
And what is the nature of question documents? What does that mean?
Well, as a question document examiner, I examine all different types of documentary evidence. That would include handwriting, hand printing, printing processes, typewriting, plastic bags, shredded paper, torn paper, alterations, obliterations, charred documents, and liquid soap documents. For example, I compare those items with question items with known items for the purpose of trying to determine the question item's authenticity or origin.
And what kind of training do you have in that area?
Well, to become a document examiner at the FBI laboratory, I underwent an intensive training program there at the FBI laboratory. The training included classroom instruction, reading from related books and journals. I attended professional meetings. I went and toured factories. I took tests. I had oral boards. And most importantly, I worked actual cases under the guidance and supervision of actual certified document examiners.
And is question documents not just relating to documents, it relates to a whole different field, does it not? A whole different field, different types of materials, I guess is what I'm asking.
Well, it doesn't necessarily need to be on documents. Sometimes writing can be on different types of surfaces. For example, sometimes a person might write a threat on a bathroom wall, for example. So I might examine the writing on a wall, graffiti, that type of thing. So any type of writing might be on a different substrate. I mentioned torn edges or torn items. It could be some type of packaging that needs to be put back together. So it doesn't necessarily need to be a document. It could be other types of substrates that I look at. So it's not necessarily documents, but it's included in the question documents unit.
And do you belong to any professional organizations?
Yes, I'm a member of the Mid-Atlantic Association of Forensic Scientists. I'm a member of the American Society for Testing and Materials. And I'm also an assessor for ASCLD Lab, which is the American.
Shout out to ASCLD. We know about ASCLD and ANAB.
I'm sorry, for ASCLD Lab, which is the organization which accredits the laboratories.
Are glasses upside down?
Or no? American Society of Crime Laboratory
Directors, Laboratory Accreditation Board. Thank you. I just drew a blank for a second. And that's international. And I think that's it for now.
Okay. Have you ever been admitted as an expert witness to testify on question documents in court?
Yes, I have.
How many times?
Well, I'm not exactly sure, but somewhere more than 20, maybe 20 to 25 times.
And has that been throughout the country in both state and federal courts?
Yes, I've testified in federal courts and state courts and also in Canada.
At this time, Your Honor, the defense would move to have Ms. Gottesman admitted as an expert in question documents.
No objection from the state.
Ladies and gentlemen of the jury, the witness will be accepted as an expert witness in the area of question document examination. You may proceed.
Thank you, sir. Do you, in the course of your work with certain instruments?
Yes, I do.
Can you name some of the instruments that you work with?
Yes, there's certain tools that I work with regularly in my unit. One would be the ESDA machine, that's the electrostatic detection apparatus, and that's used to detect indented writing on documents. Another would be the video spectral comparator, that's also known as the VSC, video spectral comparator.
And what is that? What is that instrument?
That is a tool that document examiners use for a variety of reasons. That is basically a tool that is comprised of a variety of lights and filters, a camera, a computer, and a monitor. And using those different lights and filters, I'm able to see different parts of the spectrum of light and detect different things depending on what it is that I'm actually looking for on the document.
I can have a moment. I'd like to refer you to your report on December 22nd, 2008. Did you receive any items to test in this case?
Yes, I did.
And what items did you receive?
At that particular time, I received 3 pieces of tape, actually duct tape. They were identified as items Q62 through items Q64.
And what is your understanding that where these items came from?
It was my understanding that they came from the victim herself.
Do you have your report with you?
Yes, I do.
Okay. With the court's permission, can you look at your report and see exactly where the items were supposed to have come from?
Yes.
Interesting.
Right.
You know what this is about? This is just going to show you just the insidious nature of like she even said, like her understanding. Now this is her memory, right? Her memory of what she understood at the time was that the tape came from the victim. This is important. This is just proof right here, right? This is an FBI analyst. Wait, I wonder what she's going to say when she learns how that's wrong.
Thank you.
Wow. Wow. I mean, there you go. That's a great example of just implicit bias, right? That's what that is. It's not her fault. It's normal. You have to check. You have to check yourself. Yeah, it looked like StreamYard did the thing that it does.
Were received from the medical examiner's office.
Okay. And these were the items admitted into evidence, Q62 through Q64, which I believe are
State's Exhibit 302, Council.
302. Now, what were you asked to do or to look on these pieces of duct tape for?
The purpose of my examination with respect to these 3 items was to determine if I was able to detect a heart-shaped sticker or a sticker or any remnants from this sticker.
And did you use the video spectral comparator?
Yes, I did.
Okay. I'd like to now show you Defense Exhibit AU with as a demonstrative aid.
So remember how the mysterious sticker thing vanished or whatever? So it got sent off to question documents to see if she could detect it, I
I
guess.
believe we have an objection from the state, Judge. May I?
Is it? Counsel was talking about the photographs on that page,
Correct.
not the text.
Correct.
If she feels that she needs it, then I have no objection to it.
Okay. I'd like to show you certain items so you can explain to the ladies and gentlemen of the jury how this, I'll zoom in, so.
Could we just cover the text part since that's not really before the jury?
Sure.
Because I didn't think that was needed. It's just for the. Thanks.
No problem. Okay. Can I publish to the ladies and gentlemen of the jury, Judge?
Any objection to that being published as demonstrative aid?
No, sir.
Okay, we will publish.
Okay, the VCS, correct? Is that what
It's the
called?
VSC.
VSC, sorry. The VSC, can you explain to the ladies and gentlemen of the jury what they're looking at here and how this machine helps you in the course of your work?
Just back it up a second.
Has a series of lights and filters. And what it does is it allows our eyes to see things that we wouldn't normally allow it to see. Our eyes as human beings see things between 400 and 700 nanometers. And we see things as different colors. We either see things as white if the light is reflected. We see things as black if the light is absorbed. And we see things as colors if it's a combination of absorption and reflection. That's between 400 and 700 nanometers. If we go outside of the 400 and 700 nanometers into the ultraviolet or infrared spectrum, which is before the 400 nanometers or above the 700 nanometers, which where we don't see light, that our eyes can't see it, but using these special lights and filters, we can allow our eyes to see things that we wouldn't normally see. So basically, by putting these documents
StreamYard's having a moment.
Under those lights and filters, we're able to see things without disturbing the documents or changing the documents that we wouldn't normally see. So basically, this is an example of just putting documents inside the video spectral comparator, which is just a box, and looking at these.
Basically, she's going to show us how she does her
documents. And you can see with the naked eye, they would have just been white paper.
There we go.
But I mean, putting them in perhaps under ultraviolet light, they react differently, where one document is brighter than the other four. So in this particular case, there might have been, say, a 4-page contract or a 4-page will, where there might have been a suspected insertion of a page. And in this particular case, one page is different than the other 3. We couldn't see that with the naked eye, but just using some different lights and filters that we wouldn't normally see with our own eyes, and just using this tool to aid us to see something that is outside of that 400 to 700 spectrum, we can see something that we wouldn't normally see.
So if somebody tried to pull a fast one on a will, you could spot it by using this instrument.
Right, it could be indicated that there's a different piece of paper.
Okay. And what does this example here show?
Well, this is an example on our right is shredded paper without using any different light except for normal everyday light. Then if you put it in the VSC, you can see that some of the pieces of shred are reacting differently than other pieces of the shred. And in our unit, we do put shredded paper back together. And so we can use this as a method to sort the paper. So it helps us to put the paper back together quickly if we can sort the pages by how they react in the VSC. We know which pages may go back together and which pages don't belong together.
And what about this example? What does this show you?
Well, this shows, again, on the right is a document that's been cut. There's two pieces where the page is cut using the regular light. And then on the left are those two pieces, again, in the video spectral comparator. And there's some little paper fibers that are luminescing under the video spectral comparator, and we can use that to connect the pieces of paper back together, because these random paper fibers are actually in the paper, but they can't be seen with the naked eye. But using the VSC, we can see those paper fibers and show that those pieces of paper were at one time attached, because we can match them by these fluorescing or luminescing paper fibers.
And the last example that I'll ask you to explain, it appears something with matches here. What is that?
Yes, well, matches from a matchbook have a lot of impurities in that paper. And because of that, there's a lot of fillers, and those fillers fluoresce under the ultraviolet light. So if there was, say, an arson case and that match is left at the crime scene, and they get a suspect and they can find the matchbook either on the subject's in their pocket or back at their house, we can match those up again by the bottom. It's maybe a little hard to see here, but there's again some fluorescing pieces that we can line up using the video spectral comparator.
Okay.
Comparator.
Tell us how you used the VSC in this case.
Well, in this case, I was unable to see any sticker or sticker fragment with the naked eye. So I went to the video spectral comparator to see if I could find any sticker fragment or remnants from the sticker using the video spectral comparator with some of the different lights and filters where I wasn't able to see it with the naked eye.
Would that include residue as well?
Yes.
Okay. I'm sorry, go ahead.
That's okay. Thinking that perhaps it was out of the normal range of my abilities, out of the 400 to 700 nanometers. So that was my thought, my intention.
Okay. And can you tell the ladies and gentlemen of the jury what the results of your examination were?
Well, after trying all of the different lights and different filters, I was unable to detect any sticker or sticker fragment, sticker residue utilizing the VSC.
Was there any evidence whatsoever of a sticker there on any of these pieces of duct tape?
No.
Now, after you had conducted your examination, were you ever asked to submit a DNA sample?
Yes.
Mm-hmm.
And what was the reason for that?
Well, about a month later or so, I got a call from one of the analysts in the DNA unit, and she said that they had an unknown profile from one of the pieces of tape, and they were unable to, I guess, eliminate it from anybody in their unit. And I suppose they have elimination samples. And they will, and it wasn't any of the suspects. So they wanted to know if they could get mine. And I readily complied.
Did you later find out that it was your profile on the duct tape?
I did, and it was.
Now, when you handled these
How did
items of
you handle
evidence,
that?
did you handle them with care?
Yes.
And what precautions did you use when handling these items?
Our normal procedure is to wear gloves, and that is what I did.
And you cannot,
Please tell me that's
can
not
you
all.
recall a situation where you believe you might have contaminated the duct tape? Or do you have no?
No, I have no idea how it happened or when.
Wow.
In this particular case.
Interesting.
You had no time sneezed on it or anything like that?
No, sir.
And when you scanned these items, were they in protective plastic protectors?
Yes, and looking back at my scanned images, I did notice that they were scanned in their in the glassine, which is a protective plastic.
And throughout the entire time that you had these items of evidence, you of course exercised great care.
Yes.
Were you given other tests to run on any other items in this case?
Yes, I received other items later.
Okay. And I'd want to direct your attention to April 2nd, your report of April 2nd, 2008. And per stipulation, Judge, these items, I will just speak generally of them. Can you tell the ladies and gentlemen
From the state?
I believe we've listed the items in evidence by evidence number. I provided those to counsel. Those would be the items she's referring to. But there are items in evidence that probably should, just for the record, be designated so we're clear what we're talking about.
Sure.
Just some garbage bags.
And what we're referring to are states 294 through 299.
And I guess somebody's going to tell us what they are.
Yes, sir.
You may continue.
Can you tell us what you did, what you were asked to do in this report? If you want to refer to it, go ahead.
Okay, in the whole entire report?
Yes.
I was given a number of different pieces of plastic, and I was basically asked to just give an overall assessment of the plastic, as well as to compare some of the pieces of plastic with some of the other pieces of plastic.
And what were your ultimate conclusions? Were you able to make any matches on any of the plastic?
No, some of the pieces of plastic I was able to eliminate as having originated from one another, and others I was inconclusive on.
Were you able to match any of the plastic bags from the residence to the scene off Suburban Drive?
No.
I have no further questions, Judge.
Okay.
Cross-examination.
Courtesy cross.
You received the tape that was referred to a moment ago, States Exhibit 302, after the latent print unit had already examined it. Is that your understanding?
Yes.
So they had examined it, noted something, processed it, went back, tried to photograph it and find it. They couldn't photograph it and find it. You tried to find it. You couldn't find it either.
That's right.
That's the sum of that. As far as the bags, you were given a whole bunch of bags purportedly, and I'll fill this in, Judge, taken from the Anthony residence and compared them to some bags from the scene where the body was found. Is that generally what you were asked to do about these garbage bags?
There was just a couple of bags that I compared from, there was 5 bags from the residence that I compared to 2 items from the medical examiner's office. All of the bags from the scene, I didn't conduct a comparison.
The 2 items were 2 black plastic bags from the medical examiner's office. Is that correct?
Can you say that again?
Sorry. The 2 items from the medical examiner's office, those were 2 black plastic bags. Is that correct?
Yes.
Just want the jury to understand what we've been talking about.
Yes. And then there were 2 plastic bags that were known bags from the crime scene that I examined. But the majority of those bags from the crime scene, I didn't conduct a comparison of.
Okay. But in answering counsel's question, you were talking about looking at the bags from the medical examiner's office, comparing them to bags from the Anthony house.
Right.
Is that correct? Okay. And you said, and the way you would compare bags is you would look at the fracture patterns in the ends of the bags to see if they could match up.
There's not quite, there's actually machine impressions in the bag as well as impurities in the bag that cross over from one to the other. So it's not actually a torn,
Okay.
It's not actually a tear on the end.
So some of them you can say, no, these were not from the same roll as the bags from the ME, and some it was just inconclusive, maybe not.
Right. Some were actually different in class characteristics. Maybe one was brown and one was black.
Right.
Those I could eliminate completely.
Right. But the other ones, it's just, you could be, maybe not.
Right.
No further questions.
Any redirect?
We were talking about the duct tape, ma'am. You mentioned that you were asked to, that DNA was going to be compared from the suspects. Did they indicate who the suspects were?
Sorry, objection. I believe she was asking about DNA comparison in cross.
It's about the duct tape. No further questions.
Excused.
Yes, sir.
Thank you, ma'am. You may be excused.
Thank you. May I go back to Virginia?
Yes, you may be excused. And
Yeah, she can go back to
home.
Virginia.
Quantico.
May we approach briefly before the next witness? is
Yes,
called?
you may.
My name is Carrie Oyen, Caryoien.
Good afternoon, sir.
Good afternoon.
How are you employed,
It's
sir?
number 7.
I'm currently employed as the section chief of the scientific analysis section of the FBI laboratory. Prior to that, I served as the unit chief of the firearms tool marks unit, unit chief of the trace evidence unit, and prior to that, I served as a forensic examiner in the trace evidence unit.
And how long have you been employed with the FBI?
I've been with the FBI just over 15 years.
And what is your educational background?
I have a bachelor's degree in biology and a Master of Science degree in entomology.
And have you received any specialized training in your field?
Yes, as a trace evidence examiner, specifically, I was a hair and fiber examiner. I received over a year of on-the-job training at the FBI laboratory that involved lots of reading of scientific papers, books, lots of microscope time looking at different hair samples, fiber samples, learning how to identify hairs and fibers, then comparing hairs and fibers to each other and to known samples. oral examinations, microscopic examinations. At the completion of that training program, I was qualified as an examiner within the trace evidence unit, specifically within the field of hairs and fibers.
And when this case, did you receive any, well, actually before that, Your Honor, at this time I would move, unless there's any objection, to have Mr. Owen admitted as an expert in hair and fiber analysis.
No objection.
Ladies and gentlemen, jury, the witness will be accepted as an expert witness in the area of hair and fiber analysis. You may continue.
When in September of 2008, where were you working at?
At that time, I was the unit chief of the trace evidence unit, which means I was managing all of the trace evidence unit personnel, the forensic examiners and the physical scientists who work in the unit.
And would that include both Karen Lowe and Stephen Shaw?
Yes, it would.
Okay. And you were asked to conduct an examination in this case, were you not?
I did conduct an examination on this case, yes.
Okay. Tell the ladies and gentlemen of the jury what you did.
On this submission of evidence?
Correct.
Okay.
I'm specifically referring to your report of September 12th, 2008.
A submission of evidence came into the laboratory. In this specific instance, the primary examiner, Ms. Lowe, was not present in the laboratory. As I was still a qualified examiner within the discipline, I was taking proficiency tests. I had an opportunity to conduct the analysis so that the evidence could move on and flow throughout the rest of the laboratory. The item of evidence was a shovel. I believe, may I look at my notes?
Yes,
quickly?
please.
The state and the defense have agreed that the shovel is in fact the one testified to by Mr. Berner
He's just
earlier in the trial.
I would agree.
Okay, thank you very much.
he just tries to interrupt him. Really, that's what I think.
Specifically, it was our designation of Q46, a shovel. It was received into the trace evidence unit for a mineralogic examination, one of the other disciplines within trace evidence, but there were stickers on the shovel. Now, stickers are very good receptors of trace evidence. They're sticky, they hold on to things. So just as a normal course of events, because these stickers were present, even though the shovel was submitted for a mineralogic examination, we wanted to have a hair and fiber examiner take a look at that piece of evidence also. So I went into the processing room with the mineralogy examiner, examined the stickers, the underside of the stickers using low power microscopy, removed debris that I felt was hair or fiber debris, mounted that on a glass microscope slide, and then did my analysis on the glass microscope slide.
Okay, and what were your conclusions?
On one of the stickers, it was specifically the sticker from the shaft of the shovel. I found a very small, approximately 1/4 inch long or less, human hair that exhibited Caucasian characteristics on that sticker. The hair, based on the size and the limited nature of the hair, it was not suitable for me to compare to a known sample. So I could not do anything further other than to identify it was a fragment of hair, and then that fragment of hair was removed again from that microscope slide, and then I submitted it to the mitochondrial DNA analysis unit for their subsequent analysis.
And were you advised what the results of the mitochondrial DNA was?
I do not know what the results are, no.
Now, you mentioned that you are the section chief.
Yes.
Okay. Now, as part of the section chief, as part of your job as section chief, is it part of your job to ensure quality assurance within the quality and control within the lab?
That is certainly one of the assets of the job. Within each of the case working units that are underneath me, they have unit chiefs that manage the unit, and they each have quality assurance personnel that ensure that the quality system for the laboratory and within each unit is specifically followed.
Now, your laboratory, is it what is called ASCLD certified? It
is
ASCLD.
ASCLD Lab accredited.
Shout out to
Accredited.
ASCLD.
Okay, and what does that mean?
ASCLD Lab is an organization that will accredit a forensic laboratory. The accreditation process, there are many criteria that are established, and these are actually established by ISO.
What is ISO?
Loosely translated, it's the International Organization for Standardization. It's an international standard. But ASCLD Lab has these criteria that all the laboratories have to follow. And it's everything from the training that personnel need to have in order to qualify to work in a discipline. It's the competency tests that they have to go through. It's, do you have policies and procedures, standard operating procedures for how you conduct your analysis? Do you maintain your equipment? Do you calibrate and validate your equipment? There are management aspects. It's a very broad-reaching accreditation program. And when you volunteer as a laboratory to go through that, you volunteer to have an inspection team or an assessor team come in, assess you against all of those criteria, and determine whether or not you are meeting them.
Does a research lab have to go through these same type of rigorous criteria?
Can you be more specific?
Outside of their expertise, it's hair examiner.
Sir, is that outside your area of expertise?
I was going to ask if he could be more specific on what he means by a research lab.
Okay.
Sir.
I can. If a laboratory is not accredited by ASCLD or another one of these organizations,
BNAB is another one.
are they pretty much on their own, or are they monitored like an ASCLD certified lab is?
Objection. May we approach? We have a
You may.
discovery issue.
Oh, boy.
Thank you.
Okay. Cross-examination.
So you found a 1/4-inch hair in the back of a sticker.
That's correct.
Don't know who it came from?
That's correct.
Don't know how it got there?
That's correct.
Don't know how it's been there? Don't know how long it's been there?
That's correct.
Don't know what it means?
Other than it's a Caucasian hair fragment.
Okay.
No.
No other question?
Breathe.
Very brief. Fair to say you did a thorough examination of that item of evidence.
Yes, I did.
Oh, well, not even have time to update my ticker.
May the witness be excused. Thank you, sir. You may be excused.
Thank you, Your Honor.
Okay, to be continued, guys. So that was a lot. That was 7 witnesses. Jesus, that was a lot. They got, dude, I feel like when you compare how much they got done, like in one episode, right, compared to the state, it's insanity. Like, I feel like we got so much information. They went through 7 witnesses. Everybody was from law enforcement. The majority of the testimony in terms of the timing, like the length, was FBI. Wow, they covered a lot of ground, didn't they? The hair, the DNA, how they tested the clothing, the trash at the crime scene, the heart sticker. I mean, I'm probably forgetting things. They covered a lot. They covered a lot. So it's a lot of, I feel like it's a lot of information to distill, but there were a lot of interesting things that did come out. And, you know, the recap will be interesting. What was it? Oh yeah. In the recap, I wanted to make sure too, that I showed that it wasn't a swampy area, because I thought that was noteworthy how they called it a swamp. But yeah, there was a lot of spiciness. Dude, Mr. Ashton was just objecting left and right. Pretty crazy. Wow. So the next episode, we will have testimony from the so we will have the first witness that the defense has hired. Okay, because today was all law enforcement. So their first witness, the expert witness that they've hired, is going to be a forensic. Guess what? Is it a pathologist? Is it an archaeologist or a anthropologist? It's an etymologist. And you know what? I think it's a smart choice because the bug evidence, I mean, there's so much that I was going to say disproves the state's case. The state doesn't really have a case, but if you say they did, just for the sake of argument, there's so much that disproves it. But for me, that bug evidence, while at first it kind of seemed like, okay, we're talking a lot about bugs, but once it got into what you should be seeing and all that, and that became really clear, and then I started to figure out, okay, because there's a lot of background, and that was when the state put on their expert. There was a lot of background. That was the dude that likes to talk and talk and talk, and he was like really, one of those. It was like an hour and a half of that until it finally became relevant, and then it was like, oh my God, right? And that for me was like another light bulb moment of like, wow, the state's theory is impossible because the bug evidence is irrefutable. You can't mess with it. You know what I mean? Like the DNA can wash away, it can get degraded, fingerprints, all that testing, but the bugs don't lie. That's the thing. The bugs don't lie. And it's really interesting because there's no way around that. So anyway, I still think that Dr. Haskell, he was the forensic etymologist for the state. I still think that it proved the state's theory was impossible. But the defense is bringing in their own expert, and turns out this young whippersnapper was a student of Dr. Haskell. However, has gone out and made a name for himself and is considered to be just as experty. But boy, oh boy, does some fireworks happen? I'm telling you, it gets really contentious. I will tell you what, like, it was not nearly as contentious for the state's case in chief, and by which I mean, what makes it contentious is the objections. So this is Mr. Ashton. Like, in other words, when it was the state's case in chief, you only had Mr. Baez objecting, but he does everything so politely and so kindly and mild mannered and whatnot. And Mr. Ashton, we've already seen it so far on day one of their case in chief, losing his temper, getting scolded by Judge Belvin, and it just gets worse. It just gets worse. It's really a lot. But there's also going to be a moment coming up soon on the next episode, I believe, where Mr. Baez gets a big scolding from Judge Belvin. It's really interesting. There's a lot. This is getting more and more. And you have to think about it too. The case has been going on, like the trial, it's getting towards the end. They're all getting testy, and patience is wearing thin. I would say not really for Mr. Baez, but for Judge Belvin and for Mr. Ashton. Mr. Baez remains patient as ever. But anyway, there's a lot. And we still have Roy Kronk to look forward to. That's going to be, and I still have it because, I don't try to look ahead. I don't want any spoilers. So I don't know who calls him, if it's the defense or if it's on rebuttal for the state. I would imagine it's probably the defense, but we will see. It would be really epic if they ended their case in chief with him. But powerful first day for the defense. I believe that where we pick up next time, it might still be on day 19, but I know we do get into day 20. So yeah, so that is it. So for anyone who hasn't heard, I'm all caught up on previous live streams with the timestamps. And if you don't see them on the scrolly bar, always check the description because sometimes it messes up and it doesn't show them on. Sometimes they disappear and come back. Also, tomorrow I'm going to be covering all the latest Kohberger documents. I don't think anyone's covered those yet. But regardless, they're dated the 6th, but they just got posted. They got posted after the fact. But it's all of the state's objections to the motions to suppress. And the spice is flying there as well, man. Talk about spice with all the things that I'm covering, right? Like just at a quick glance, in every single motion or objection to the motions to suppress, in every single one, Prosecutor Santa is using the word facts in all caps and scare quotes. So saying the defense stated, and then it's in all caps and scare quotes. That's how they put facts. And it's in every single one. It's really a statement. And then we're also going to be having another episode, I think on Sunday for Shanna Gardner. This, of all the things, I've never seen pretrial, of all the things, right? I've never seen pretrial litigation like this ever than what is going on with Shanna Gardner. Now, I don't mean currently because we're catching up, but this is from June, July, and August or something like that of this year. So just we're almost caught up. But literally, I've never seen anything like it. All I had to do was look just to get the dates, so I can make the thumbnail. And like, I just scrolled to like a random spot and then I hit more so I could read the date. And it's like mind boggling, because where we had left off was like, what's going on with Kimmy and Sue? And I kept saying over and over again, why are they not being charged? The state's calling them co-conspirators, but they're not. Like, what is going on? Well, that mystery deepens, and there's going to be a number of firsts. Again, there's a general first, which is I've never seen anything like this in terms of pretrial litigation being so contentious, so spicy. Like, it's just wild. There's a lot of weird, crazy stuff. And it started out with like the crazy attorney-client privilege breach, and that seemed like a lot, but that's nothing compared to where we're at now. That's all in the past now. Well, I mean, I think they've sorted through it, but like now it's like this Kimmy and Sue thing, and so what's going to be so the first, that's a first, right? This in general, it's a first. There's a first, as in Jose Baez gives his first and I believe only press conference. Incredible. That is from June 21st of this year. And then what's going to happen is it looks like there's like it's still kind of related to Bond, but like not really. This is like we're like on like a million side quests with this, because like basically what we learned with the Arthur hearing, the whole thing with when you've got a non-bondable offense, right? So like first degree murder, you have to really kind of prove that the state's, well, I kind of explained it at the last episode, but like basically what you're trying to prove, the defense is trying to prove if they want to contest this, is that the presumption that the state can meet the burden for those charges, not beyond a reasonable doubt. It's just like it's a low standard, right? That it essentially goes to overcharging, right? That's kind of what it's going to. That because of the fact that the charge is what keeps you non-bondable, right? It's kind of like saying this charge is, there is not a fair presumption that a reasonable jury or that this charge is reasonable. Like, in other words, it could be less type of thing. And so it's kind of like when people argue for lesser includeds or whatever, but it specifically applies to bond. And the reason being, again, because of the fact that, and it varies by the state, but in Florida, a capital offense, right, is non-bondable. So that's where this applies, where it's like, okay, but also if there's a presumption that it could be less than that, right? Or that's too high, or that it's just not, you have the wrong person, or whatever the case may be, right? You're trying to get away from that to say it could be something else, and then it's bondable, if that makes sense. So all that being said, what you end up with is these bond hearings, quote unquote, are really less about bond and more about arguing the facts of the case. It's like a trial, but where the rules of evidence don't apply. So when I say it's insane, that's why. The rules of evidence don't apply, right? So there's hearsay, there's all kinds of stuff. And so what we're seeing is like the evidence and the facts of the case, like we're getting into all that. It's really, again, it's for their purposes, it's for bond, essentially, if they're trying to prove, the state's trying to prove that they have the right charge. The defense is trying to show that, that they don't have enough to keep her on bond for first degree murder, right? So the way that they have to go through that is by putting on witnesses and having these evidentiary hearings. And what has transpired is them finding out at the last one that like they didn't have this grand jury transcript where Kimmy testifies. And Kimmy is a huge part of this. It's insane. This is just absolutely insane. Oh, it just booted my thing. Booted my my video file. So let me just try adding that again. It's just insane. And so what's going to be happening on the next one is it's like the second part to the bond thing. Because what happens is when you get denied, then you can challenge it again with like another, like, it's part of the Arthur, not the Arthur hearing, but I forget what it's called. My brain has a lot of information in it right now. Anyway, it's you can see it's timestamped. It's at the end of the last Shanna Gardner live stream. Anyway, basically they get another chance, right? They can try again. So again, while it's not just like trying for bond again, it's like another second mini trial in a way, if you will, where the rules of evidence don't apply. And so much happened in the last couple hearings, especially that bond hearing, that, evidentiary, it's an evidentiary hearing, where all the stuff with Kimmy and Sue and the co-conspirators, and then the state alleging that Shanna's family like has shell companies. There was a lot. It was insanity. It was insane. I've never seen anything like it. And it's like, with all the allegations that the state is making, it's like, why are you not charging other people? And then also there's another thing of like, why are you charging Mario as the same as Shanna when clearly you've already come out and said he was coerced and he was essentially a middleman? I don't know, it's insane. And then there's the first of Jose Baez doing a press conference. And then there's just a lot. So but basically, it's this whole thing where there's like this mystery of Kimmy and Sue has now morphed into potential Brady violations. So on this next upcoming episode on Sunday, what we're going to have is we're going to have the motion filed by the defense to reconsider pretrial release, which again, it goes way beyond bond. This is not typical. Because it's like in that same motion, it's not just motion for pretrial release. It's like also saying Brady violations, and like it's like insane. It's all caps. The title of it is the caption is all caps, bold and underlined. So Jose Baez files these. There's that, and then there's two other pleadings. Files them at the court. Comes out of the courthouse. Gives his one and only, to my knowledge, press conference. And then after that, they have the next hearing. On all of that. So it's essentially again, right? It's like that last bond hearing that we had, we just split it up into two. It's like another one, but now honestly, it's going to be even crazier, even more insane, because of all the stuff that came out at the previous one. And that's where you get into the Brady violations, because it's like they learned stuff that day that they didn't know before. And like the little it keeps doing that. The little part that I saw, little part that I saw, it was like Jose Baez with like a PowerPoint presentation that he'd put together. So he's there in person the whole time. So just like how he was there doing his thing, he's going to do it again. We get another one. But this time the PowerPoint presentation is basically pulling up transcripts from the previous bond hearing that we just covered and like impeaching the fuck out of everybody. Y'all, you're not going to want to miss it. It's really insane. And so that's going to be Sunday. So we've got tomorrow, Cobra. I moved Karen Reed out because this stuff is just way more exciting. So on the table still, we've got the Karen Reed Daubert hearing, and we've got the Sarah Boone letter, but I'm tabling those for now because I want to get into the Koberger stuff, and I want to get into this next epic part of the Shanna Gardner. It's wild. It's wild. So anyway, there's a lot going on, but for anyone who's new, I've got playlists for everything that I've been covering, have covered, am covering. And thanks for bearing with the technology challenges. StreamYard's, still, I guess, getting acclimated. I mean, I don't know. It's a lot. It's annoying. It's frustrating, but we do our best. But anyway, thanks for being here and being a squirrel. I will see y'all next time.